It's a good thing we like it.
All right. Good morning, everyone. Welcome to the House Judiciary Committee. And I'm going to begin by recognizing Representative Manos to lead us in the Pledge of Allegiance.
Under God, indivisible, with liberty and justice for all.
Good morning. We have a number of bills and proposed constitutional amendments on for hearing today. I see a number of cards for the first bill, CACR 2. As you know, we've scheduled this hearing for an hour and a half, and I'm going to sort of start out with the presumption that everybody will sort of say what they have to say and be relatively brief. I'd rather not try to impose time limits, but if it starts to look like we're going to run way over because people are, just going on longer than being brief, I may have to impose a time limit so that we retain some kind of adherence to the schedule we have today. I'm not looking to be right on the money, but if it looks like we would go way over, I then may impose some time limits. The other thing I would like to say is we are all very aware that that the issues that we're hearing today raise can be very strongly held views on both sides of these issues, and that's fine. That's exactly what you'd expect in a democracy. We on this committee, despite the strong disagreements we may have had on many bills, have always conducted a respectful debate among each other, and I'm very gratified, and I know my colleagues feel the same way about our ability to do that. And so what I would ask, please, is this is the House of Representatives, and I would please ask you to also conduct your testimony, provide your testimony in that same respectful manner. Thank you. With that, I'm going to call first on CACR 2 on the sponsor of the bill, Representative Amanda Toll. Ms. Toll? No, you need the red thing. There you go.
Good morning. Can you hear me better now? Great.
Yes.
Honorable members of the Judiciary Committee, my name is Amanda Elizabeth Toll, and I represent Cheshire 16, which encompasses Keene, Walpole, Hinsdale, Chesterfield, Surrey, and Westmoreland, New Hampshire. I'm here today as the prime sponsor of CACR 2, New Hampshire's Reproductive Liberty Amendment. And soon it's going to actually be Amanda Elizabeth Soto because I just got engaged on Saturday night. So, to my partner Alberto. So, very excited about that. I had an abortion when I was a teenager. And approximately 11 weeks ago, I gave birth to my second child, Jordan, who's here too. And it hasn't been easy. I got a terrible case of PUPS while pregnant, needed iron transfusions, and the sleep deprivation has been especially hard. My son is such a blessing, and I'm grateful to care for him with the most wonderful, loving partner by my side. But parenting is likely one of the hardest things one can do, and it shouldn't be forced upon people. Because I was able to have children when I was ready and not before that, I've been able to become a state representative who's advocating for public policy based in compassion and justice. I'm tremendously grateful for being able to obtain the abortion care I needed when I was younger. Sharing my own abortion story for years and hearing the stories of others, I know one thing for sure. Abortion care is an intersectional issue. People of all economic classes, races, and religions access abortion care. Legal barriers to abortion will not stop abortions. They will only keep disenfranchised folks from accessing the care they need, sometimes with deadly results. With all the attacks on reproductive rights, it's critical to lay the foundation for proactive legislation to protect them. Constitutional protections for reproductive rights are imperative for the following reasons. I'm so sorry. I'm just going to grab my phone because I thought all my paperwork was here, but I'm not seeing it. Yes, thank you so much. Please, thank you for your patience. So constitutional protections are the gold standard, as they give the highest level of legal protection. In addition to the purposely bold and progressive content of the New Hampshire Reproductive Liberty Amendment, the fact that it is a constitutional amendment means it's not subject to the governor's veto, and it's a lot harder to undo, and would mean that we do not need to fight tooth and nail for reproductive freedom each time it goes before the state legislature. We don't want legislators to be able to play political ping pong with people's reproductive rights every new session. This bill is also a reproductive justice bill. It isn't just about abortion rights, but also about the right to have children when you want to have them, free from state-sanctioned violence. Sister Song, a collective of women of color fighting for reproductive justice, defines this term as the human right to maintain personal bodily autonomy, have children, not have children, and parent the children we have in safe and sustainable communities. CACR2 models this more expansive vision of what it means to have true reproductive autonomy. It is meant to protect the right for folks to end pregnancies or to choose when to become pregnant. This means that it will protect the right of abortion and birth control at the same time that it protects Granite Staters from state-sanctioned violence like forced sterilizations. New Hampshire citizens should be able to directly weigh in on the reproductive rights and affirm their values relating to reproductive autonomy by giving these rights the highest legal protections. New Hampshire residents are overwhelmingly pro-reproductive freedom. Indeed, during the last Judiciary Committee hearing on the New Hampshire Reproductive Liberty Amendment last year, 1,413 constituents signed in favor and only 134 opposed. Putting this issue on the ballot as a constitutional amendment will allow residents to directly show support for reproductive rights as an issue of personal liberty that is very important to Granite Staters. This past November, 3 states opted to take this path. Michigan, California, and Vermont affirmed abortion rights in state ballot proposals. Voters in all 3 states amended their constitutions to support reproductive rights. This bill, which utilizes the same language as our neighbor Vermont just passed, lays the groundwork for doing the same thing here in New Hampshire. I hope that you will vote in favor of CACR2 and allow New Hampshire constituents to weigh in on reproductive autonomy. Thank you so much for hearing my testimony, and I'm happy to answer questions.
Questions from members of the committee? Not seeing any? There's one. I'm sorry. Yes, Representative Greasy.
Thank you, Mr. Chair, and thank you, Representative. What reproductive decisions do the biological fathers of preborn babies have the right to make?
Can you please repeat the question louder into the microphone?
Sure. What reproductive decisions do the biological fathers of preborn babies have the right to make?
Thank you so much for the question. This constitutional amendment is to affirm everyone's personal, for themselves, their reproductive autonomy. And so it is about your own reproductive autonomy and New Hampshire constituents having the right to weigh in on that directly. Thank you.
Any other questions? And please, given the way we're sort of physically set up, please raise your hand so I may not see you if you don't. Any other question? Seeing none? Thank you very much.
Yes. Thank you. Can I just say one more thing I wanted to say? So I wanted to say that so the goal of the Reproductive Liberty Amendment is to enshrine into our state constitution what medical practices were happening in New Hampshire prior to recently passed abortion ban. And for nearly 50 years, the state of New Hampshire trusted doctors and patients to make these decisions around abortion care, including later in pregnancy. These are complicated and often heartbreaking decisions. And there was bipartisan agreement for decade after decade that said New Hampshire supports privacy, particularly when it comes to these personal medical decisions. And so, again, I think allowing the voters to weigh in on this because we know it's popular across the board is really the right thing to do. And I urge you to pass CACR2, New Hampshire's Reproductive Liberty Amendment. Thank you for hearing my testimony today.
Great. Thank you. I'm next going to call on Representative Joe Shapiro, and I'm the next witness. I'm going to just sort of announce the next witness after him so people can get ready. And what I would say is the next witness after Mr. Shapiro will be Sean Filiant. I hope I'm pronouncing that correctly. The only thing I would say is if there are other reps or members of the legislature, senators, who are here and you're here because you have other business, I recognize that there's a lot of other hearings going on. So I will take those reps or senators out of order after Representative Shapiro because of the fact that they have other business. So I see Representative Notter, so I'll ask Representative Notter to testify after Representative Shapiro. Representative Shapiro, thank you for being here.
Thank you, Chairman Lynn, and thank you, committee members. I want to just take a moment to thank you for your, Mr. Chairman, for your introduction about how we want to conduct business here and in the legislature. I appreciate it. For the record, I am Representative Joe Shapiro, representing Cheshire 16, which consists of Keene, Ward 2, and 9 small surrounding towns. In anticipation of today's hearing, I wrestled with what to say. As a man, I was unsure that I had something to offer to a discussion about reproductive autonomy. Eventually, I decided that speaking on behalf of this bill, which will enshrine in the New Hampshire Constitution a woman's right to make decisions about her body, her health care, and her well-being, was an opportunity to honor the two most important women in my life. When I was a very young adult, my girlfriend became pregnant. We were not ready. We were scared, and I must admit, I was clueless about how to navigate a situation like this, emotionally and practically. When my girlfriend chose to have an abortion, it was my mother who came to her side, taking her to the clinic, coming to our apartment to offer healing and support, and most importantly, lending her strength, communicating by the force of her very nature that there was no reason to feel shame. Fast forward more than 10 years, another unplanned pregnancy. My wife and I knew we wanted children, but we were once again less than prepared. I was a student, we were poor, we were betwixt and between several life transitions. We wrestled with what to do. We worried about what could go wrong. Could we provide the stability a child needed? Would we have the resources to give our child the life that they deserved? The discussions were long, hard, and honestly, pretty excruciating at times. But I can't think of anyone who I would rather have had them with than my wife, Nikki. She was a beacon of strength, competence, and hope. Our daughter is 37 now. We are thankful every day for her and her sister and for our 2 grandchildren. We know that our daughters will have to wrestle with difficult life-altering situations. In fact, they already have. We have full confidence in them. My mom and my wife taught me, and more importantly, taught our daughters, that women are fully capable of making the right decisions for themselves about their bodies, their health care, and their well-being. They do not need the state to decide for them. I urge you to vote ought to pass on CACR 2. Let the people of New Hampshire decide. Thank you.
Thank you, Representative. Questions for this witness? Yes, Representative Greason.
Thank you, Mr. Chair, and thank you, Representative. According to the text of the bill, it says all persons have the right to make their own reproductive decisions. Does this mean that someone who may have an affinity for animals, or a brother and sister who would like to keep it in the family, or perhaps maybe a minor attracted person has the right to make their reproductive decisions as well?
I did not catch that. I did not catch that question.
Okay.
You know, I think the problem is that the acoustics are not great in here. So, Representative Greason, I wonder if you could get
Sure.
maybe closer to the microphone.
I will speak a lot louder then. How's this? That better?
Thank you.
Okay. The text of the bill says all persons have the right to make their own reproductive decisions. Does that mean that someone who has an affinity for animals, or a brother and sister who'd like to keep it in the family, or a minor attracted person may have the right to make their own reproductive decisions?
I find that question offensive, and I'm not going to answer it.
Right. Any other questions for this witness? Seeing none, thank you very much. Our
Thank
next
you.
call on Representative Jean Notter, please.
Thank you. For the record, I'm Janine Notter.
Janine Notter, I'm sorry.
Hillsborough 12. I didn't know what I was going to say today when I came here, so I'm going to tell you why I'm pro-life. When I was 10 years old, I saw pictures of little arms and legs in a pool of blood. And I knew I was looking at pictures of dead babies. And I've always kept that image in my mind. And in 1995, I lost a child. I didn't lose a blob of tissue. It was a baby. It was my baby. And then I had a dream, a very, very vivid dream, that the child was standing right next to my bed. It was like I woke up and there was this child there, looked like my other kids, but half the face was deformed. And I kind of put in my head, oh, that's why the baby didn't make it. But it was my child, and I loved him, and I said, oh, no, I love you. And I reached for him, and he backed away like in fear, which in my mind I thought, well, okay, we can't touch what's on the other side. And he was gone. Now, I first became a mother when I was still a teenager. And that baby was a baby the day before he was born, 3 months before he was born, and he was a miracle of life from the moment of conception. even though I put the cart before the horse. I remember the words of a former drill sergeant who later became a priest, and he had this deep voice that I cannot mimic. But he said, if you are in a position, if you know that something is wrong and you are in a position to do something about it and you do not, then you are at fault. So because I have this great fear of God, and I remember his words, and I'm pro-life, I have to be here today to say that I think it is wrong to put this into law. I think we're asking for trouble from above. Thank you.
Thank you, Representative. Questions for Representative Nada? Seeing none, thank you. Sean Filiak, I hope yes, thank you.
Thank you, Mr. Chairman, and thank you, members of the committee. My name is Representative Sean Filio, and I have the privilege of representing Cheshire District 7, which covers Keens Ward 2. I'm here to talk to you today about some of the legal aspects of CA-CR 2. The proposed amendment would apply strict scrutiny to reproductive decisions. As you may know, strict scrutiny would require that in order for the government to apply limitations upon reproductive decisions, the government would need to have a compelling interest, and that if the government had a compelling interest in applying limitations on reproductive decisions, that any such limitations would need to be narrowly tailored. This is a standard that has been applied by the US Supreme Court and New Hampshire Supreme Court for decades. Thus, CA-CR 2 would not make it such that there could be no limitations on reproductive decisions, but rather that such limitations would need to be narrowly tailored to a compelling governmental interest. Let's take an example. As one representative recently placed, could there be no limitation on bestiality or pedophilia or incest? The answer is an unequivocal no. Of course there could be limitations because the government has a compelling governmental interest in prohibiting incest and bestiality. So of course there could be limitations because there's a compelling governmental interest. But any such limitations would just need to be narrowly tailored so that the law would go no further than what we need to do. This is the standard that has always been applied to fundamental rights. This proposed amendment just seeks to apply a governmental standard that has always been in place to reproductive decisions. The key word here is reproductive decisions. What does reproductive apply or mean? It means what it means. It means the dictionary meaning. If we need to figure out what that means, that's the work that courts have always done. We trust our judges and we trust our courts to determine what that means. We simply ask that we now apply an existing standard to a new right. I welcome your questions.
Questions for this witness? Representative Greason.
Thank you, Mr. Chair, and thank you, Representative. You've used the term compelling state interest. Multiple Supreme Court rulings have declared that the state, that this is U.S. Supreme Court rulings, that the state, being the government, has a state interest in protecting the life of the baby. So how do you, if this U.S. Supreme Court has already ruled that the state has a compelling interest in protecting the life of the baby at one point, at the same time of protecting the rights of the woman, then how does this bill not then contradict what the U.S. Supreme Court has already ruled is a compelling state interest in protecting the life of the baby?
Thank you, Representative, for the question. Indeed, the U.S. Supreme Court has said that there is a compelling governmental interest in protecting the life of an unborn child, as well as the right of the health of the mother. That was said in Roe versus Wade. So we're seeking to reinstate the standard of Roe versus Wade. It's always the work of governments to balance. Government is tough work, but that's what our constituents asked us to do, is tough work. It's always a balance, but I think we're up to the task.
Other questions for this witness? Yes, Representative Manos.
Thank you, Mr. Chair. Representative, this is a proposed constitutional amendment to the New Hampshire State Constitution. Is that correct?
I'm sorry, Representative, could you please pull your mic a little bit closer?
Thank you. Sorry. This is a proposed constitutional to the New Hampshire State Constitution. Is that correct?
Yes, Representative, this is a proposed amendment to the New Hampshire State Constitution.
And as such, it would be submitted to the voters of New Hampshire. Is that correct?
Yes, Representative, this would be submitted to the voters of New Hampshire to decide whether they believe this is an appropriate right for them to have under their state constitution. This is asking whether we believe that as citizens of our state, whether we want this right, just as citizens of other states have been asked a similar question, and citizens of other states have made that determination for themselves. It should be a basic right of citizens of this state to determine for themselves whether they want this right, just as citizens of other states have had that privilege to decide if they want that right for themselves.
And isn't that the most democratic of processes, to let the voters of New Hampshire decide for themselves whether this amendment should be made to the state constitution?
Thank you for the question, Representative. That would seem to be the fundamental definition of democracy, to let the people decide for themselves how they wish to rule themselves.
Other questions? Representative Horrigan.
Thank you. Thank you very much, Mr. Chair. Thank you very much to the representative from Keene. Basically, men cannot get pregnant, although we did hear an anecdote in the hearing about transgender rights about a trans man who hadn't had bottom surgery who got pregnant anyway. But so men can't get pregnant. But do you think if we did get pregnant, do you think this ongoing debate of which this amendment's a part would probably be different?
Thank you, Representative. As noted, trans men do get pregnant, but I think we also need to consider the fact that this amendment is about reproductive rights. It deliberately does not use the word pregnancy. Men make reproductive decisions. Men decide whether or not to use a condom during sex. Men decide whether or not to get a vasectomy. This equally applies to those reproductive decisions. If the government wants to decide whether or not a man can get a vasectomy, the government needs to have a pretty good reason to get involved in that decision. If the government wants to place restrictions upon contraception, such as condoms, the government needs now to meet the strict scrutiny standard. We need to recognize that this is reproductive. So yes, it also applies to men and some of the reproductive decisions that men make, because men make reproductive decisions.
Thank you.
Representative Stapleton.
Thank you, Mr. Chair, and thank you for taking my question. I'm having trouble with the audio in here because of hearing aids, so if I've missed something, I apologize. First, wanted to ask if you are an attorney and have a legal background.
Thank you, Representative. I am an attorney. I hold the bar here in New Hampshire and have also passed the New York bar. I've had the privilege of serving with the Attorneys General of New Hampshire, Vermont, and Massachusetts, and was a federal judicial law clerk under Judge William Young in the U.S. District Court for the District of Massachusetts, and I'm now a practicing attorney for a private law firm based out of Manhattan. Clearly, I work remotely.
Thank you. Follow up, Mr. Chair?
Yes.
If I caught this correctly before in part of your testimony, you seem to imply there should be a balance between the mother and the child in the womb, and a balance between the mother and the state compelling interests. Now, the question is, in Planned Parenthood versus Casey. The viability standard came into the forefront. And I happen to think that that's a decent standard, but the viability, if the child has the capability of surviving outside of the womb, does this come into play with your balancing and the state compelling interest? Because in Casey, that was stated that with viability, that the state did have a compelling interest in the life of the preborn child.
Thank you, Representative. Viability may have a role here if that's how the legislature decides to define the balance between the rights of the mother and the rights of the unborn. And it may also be how the New Hampshire Supreme Court decides to apply this, given the fact that the precedent described has now fallen under Dobbs. It would be for the New Hampshire Supreme Court to decide how they would apply this standard, but they would certainly look to the prior standards that had existed as being compelling and convincing, but it's unclear if they would be binding given the fact that they've now fallen.
Other
Follow-up,
questions?
please.
Follow-up? Yes.
I have not had a chance to read the complete Dobbs decision, but the question would be, how much of Roe, Doe, and Casey was obliterated by the Dobbs decision, or are there pieces of those things that still survive in the decision of the Dobbs decision?
Thank you, Representative. I think that is the question that we're all still working out, and will be the question that we figure out over the next few decades. If I knew the answer for that, I think I would be sitting in a different chair than I am now.
Thank you.
Other questions for this witness? Seeing none, thank you very much, sir.
Thank you,
Next, I'm
committee.
going to call on former Representative Kurt Wolpert, and the next person after that will be Representative Sellers, just so you'll know for...
Thank you, Mr. Chairman, members of the committee. For the record, like this. Okay, so for the record, my name is Kurt Welper. I reside in Stratford, New Hampshire, and I'm Vice President of New Hampshire Right to Life. I put down 2 minutes. I'm going to stay within it. New Hampshire Right to Life is in total opposition to this because there can be no constitution.
You know, I think we're really having trouble hearing you, Representative Wolpert. I'm sorry, but...
Oh, yeah.
There you go.
Good idea.
There, thank you.
All right. So New Hampshire Right to Life is opposed to this. Excuse me. I'll leave it there. All right, start over. New Hampshire Right to Life is opposed to this because there can be no constitutional right along these lines. There can be none for two reasons. It has to do with the fact that this is the right to abortion. Abortion is an intentional killing of an innocent human being. That cannot be constitutional. That is opposed by every part of our body of law. Second is they want to put it in the right to privacy. There are at least two individual human beings involved when the decision about abortion is made, the mother and the child, and there could be many others very closely related who would be seriously impacted as well. To allow one person to so severely impact the other people is not a matter of privacy. It's a matter of community. And so if you were to adopt this at all, it shouldn't go into the privacy part of the Constitution. You'll have to find another place. The idea that the established, in Roe versus Wade, the Supreme Court recognized that it did not know what was in the womb. Today we know. But they said if we did know what it was, and it was a human being, then that human being would already be protected. This is 1973. Would already be protected by the United States Constitution, Article 14. Which means essentially what I just said, there can be no right, no constitutional right to abortion. And the last thing I'd like to say is that when they talk about reproductive anything, they're really talking about abortion, because nothing else is really a matter of dispute in our society. And I think if we want to put this into anything, it should talk about what it's talking about and not hide behind the euphemism of reproduction. And with that, I will conclude.
Thank you. Questions for this witness? Seeing none, thank you very much, Representative Wolf. Representative Sellers next, and after the next one after that will be Representative Murray. Representative Sellers.
Morning, representatives. Thank you, Mr. Chair, for the time, and committee members. Representative Sellers, Grafton 18. I am going to list the towns just to give you an idea. If you haven't heard them before, you're going to hear them at least once. I represent Alexandria, Bristol, Bridgewater, Hebron, Groton, Dorchester, Orange, Grafton itself, Canaan, and Enfield. Those towns, I'd like to say we would all be on the same page and we're 100% agreement in this bill, but of course we're not. And as we all know, we're pretty divided what's going on here. And but I did want to bring up a few items here, or at least one or two. It is, I honestly believe that our state and any government does not have any rights or any say over any reproduction of a male or a female. Zero. However, because of the predicament and the times we're in, we're trying to solve problems by putting in amendments and also other bills because of the times we're in. And which I disagree with, but they're here, and since they're here, we need to address them. So one thing I have here is, or maybe two things. It says, I just want to make sure of this bill, and it's unfortunate, maybe when you guys deliberate and stuff at that point, it says an individual's right to personal reproduction. I take that as male and female. I'm not looking at this as just a female issue, it's a male issue as well. That's one. The second part, it says, I'm going to read on line 5, it says infringed unless justified by a compelling state interest, and so on. Man, if I was a lawyer, and I'm not a lawyer, but I think I could come up with about 50 different ways of saying the state could be justified. So I look at this and I say this bill is going to be very vague and open to interpretation and will be a real problem if it's put forward. Thank you.
Questions for this witness? Seeing none, thank you very much, sir. Representative Murray, and after Representative Murray, the next witness will be Jean Espinola. Representative Murray.
Thank you, Mr. Chair and members of the committee. Can you hear me? Okay.
You have to,
Get closer? Okay.
yeah, pick it, you can pick that up if you need to.
All right.
That's great. Thank you.
So I'm Representative Alessandra Rodriguez Murray, and I'm very proud to be a co-sponsor on this legislation. Last July, the unthinkable happened, and the Supreme Court overturned Roe v. Wade. Since then, we've seen thousands of women, young girls, and other pregnant people struggle to get often the life-saving care that they need. While New Hampshire laws have remained stable during this time, we have seen an increase of patients from out of state coming to access abortion care in New Hampshire. These patients are receiving delayed care that is more stressful, expensive, and feels out of their control. We must protect New Hampshire citizens from this same fate. The fall of Roe confirmed what Granite Staters have always known. We cannot depend on the federal government to protect our rights. CACR2 is exactly the kind of legislation we need at this moment, a democratic way for our constituents and fellow citizens of New Hampshire to determine the future of abortion in New Hampshire for themselves. The people of New Hampshire deserve to know that their reproductive rights are protected in the state that they live in and that the laws won't constantly change back and forth every 2 years. Let New Hampshire continue to be the safe haven of liberty and personal choice that we always have been. Please vote ought to pass on CACR2. Thank you.
Thank you. Questions for this witness? Seeing none, thank you. I believe it's Jean, it's hard to read the first name, Espinola. Joan, I'm sorry, Joan Espinola. And the next person after that will be Bob Dunn from the Diocese of Manchester. Thank you. Oh, forget, turn on the red. There you go. Thank you.
My name is Joan Espinola, and I am from Londonderry, New Hampshire. And I'm asking you to please vote no on CACR 2. There's no freedom for the baby in the womb when it comes to reproductive freedom. And reproductive freedom is just means a woman can kill a living human being with no repercussions from the state. If you vote yes on CACR 2, you're coarsening New Hampshire's culture by adding this resolution to our Constitution. Our world is coarsening more and more each day with violence, drugs, suicides, sex trafficking, social media attacks, canceling people, and the bullying of children who are fortunate enough to be born. Then there's the lies told to women that they can abort the baby in their womb and feel good about it. I still don't believe, after hearing the sponsor of this bill, that a woman can abort her baby and feel good about it. I'm sorry. Also, the hard hearts that tell the mother it's okay to kill your baby instead of giving them real loving help with support to keep the baby or suggesting adoption. All of you on this committee have the power of life and death in your vote. Please choose life and help our culture soften its attitude toward life. And I'd just like to share one thing that happened to me. I was protesting in front of a Planned Parenthood, and a car stopped in front of me. And it was a woman in the car, and she started screaming at me and hollering at me because my sign said end abortion. And she had 2 children in the back of that car. And her language wasn't good either. So after she stopped screaming at me, she turned around to the children, who I think one was probably about 10 and the other was younger. She said to the kids, "What do we say to her?" And they dropped the F-bomb. The 2 children in the back knew what this person was telling them to do. So you know what, these children are adults now, because this was about 15 years ago. So the coarsening of our culture was happening then. And now we have people like that woman telling these children, you know, to say that to me. And I still can't get over it, to tell you the truth. So thank you. And I'm also asking you to vote no on House Bill 271, 224, and 88. These 3 bills, along with CACR, do nothing to make our world a better place, but only coarsen it even more. Thank you.
Thank you. Questions for this witness? Seeing none, thank you very much. Bob Dunn, please. And then next will be Representative Newell.
Thank you, Mr. Chair, members of the committee. I'm Bob Dunn, the Director of Public Policy for the Roman Catholic Diocese of Manchester, and I'm here today on behalf of Bishop Peter Labashi to oppose CACR 2. Is that okay? Can you hear me all right?
Yes, thank you.
I have written testimony, so I just want to make a couple of quick comments, if I might. First of all, if there's one thing that I suspect everybody in this room agrees on, it's that in certain ways, human dignity and solidarity are things that are beset by many challenges in today's world. And so I ask the committee to think about this question as you deliberate on this CACR. Will the work of building up human dignity and solidarity be advanced or hindered by the adoption of a constitutional amendment that effectively declares a certain category of human beings as expendable? Proposals like this inevitably have repercussions in other areas. If we want society to recognize the human dignity of the young human being at the border, or the young human being who is homeless, or the young human being who is in need of health care, then we need to recognize the human dignity of the young human being in the womb as well. If we begin to ask society to treat certain ones of us as expendable, then we can't be surprised if society begins to treat certain ones of us as expendable. And so I ask you to vote down this proposal. Thank you.
Thank you, Mr. Dunn. Questions for this witness? Seeing none, thank you. Representative Jody Newell, please, next. And the next witness after that will be Senator Deborah Oshler. I hope I'm pronouncing that correctly.
Thank you, Mr. Chairman, and thank you to the members of the committee. My name is Jody Newell. I'm a representative representing Cheshire 4, a very solidly pro-choice district. So I'm happy to be here today representing my constituency. As I thought about what I was going to say today, I was once again filled with a sense of discouragement. We are so set in our ways. It seems we've staked our flags firmly on either side, and by God, we'll fight to the death to defend our positions. Now what, in this context, could I possibly say that would change the mind of someone who believes that abortion is murder? And after a lot of time and thought, I decided to share a little bit about my own journey. From regular March for Life participant and attendee to abortion storyteller to civil disobedience participant and willing arrestee on behalf of the right to choose. I intend to address 2 points. The first is that abortion should be legal, and second, that it should be an unencumbered right. And I won't throw statistics at you. I know we're awash with statistics, but that part actually plays a pretty significant role in my journey. See, I was raised in a conservative Christian household with a fiercely loving mama who devoted much of her time and energy to overturning Roe v. Wade. Every January, we traveled to D.C. on a bus to the March for Life, and I believed myself that abortion was murder. So much so that I was the one person in my high school class who would stand alone, arguing and defending this point. I remember a paper I wrote once and the disdain I felt at corrections from my teacher on the statistics I used to back up my claims. But being, me, I was not satisfied with just knowing that I was right. I needed to prove my point. Smug teacher be damned. That was when I signed up for a newsletter from NARAL. It's not that I trusted them. In fact, I thought they were evil. But I did this in order to pick apart their alternative facts, their competing statistics. But in the end, I had to take a good look at my own. This effort led me to understand the true nature of abortion, because the way it had been presented to me was false. It was inaccurate. It was emotional. I still can't get this image out of my mind 30 years later, and I won't describe it here. I don't want to put y'all through that. Let me just say that for a long time, I believed that partial birth abortion was abortion. This is propaganda. This is indoctrination. What it is not is factual in reality. The overwhelming majority of abortion is still legal in New Hampshire because it happens well before 20 weeks, well before a fetus becomes the full-grown, viable, precious baby portrayed in the image that I remember in my mind. So why, as a mother of two amazing human beings created in my own womb, and of whom I am so extremely proud to have brought into this world, do I believe this should be an unencumbered right with no restrictions from the government? Well, let me tell you about these babies' entrance in the world. One was a year and the other yet to be born, just 3 weeks out, when their father, my fiance at the time, overdosed on heroin in our bathroom, 10 feet away, on the other side of a closed door. Even saying that now, as a legislator, as someone who tries to do good things in this world, there's a twinge of fear that you'll judge me, demean me. I am perpetually afraid that my past, even if the reality and context isn't explained in detail, even if you know and love someone who has found themselves in a similar situation, even if you are a compassionate person who makes all efforts not to, as does my mama, that your opinion of me will change and you will value my words less. But I say it all the same, because having known that judgment, having had my integrity questioned, my motives scrutinized, and worked in other people's minds, and having found the strength to fight back, I cannot and will not remain silent when good people, many going through the hardest time of their lives, are called murderers. There are as many situations as there are people, and to assign malice, to install roadblocks, to impose faceless and unnecessary barriers based on a default assumption of their nefarious intent is simply abhorrent, and frankly, it's inaccurate. We, as a legislature, and collectively the government, are not capable of, nor should we be in the business of assessing the merit of each individual situation. These very personal and impactful decisions belong in the hands of the individual with expert guidance from medical experts, which is exactly why we're here today, to ensure that that's where they will stay. Thank you for your time, and I'm happy to take questions.
Questions for this witness? Seeing none, thank you very much. Senator Oschlitzer. And the next witness after that will be Danielle Pimentel.
Good morning, Chairman Lynn, honorable committee members. My name is Deborah Altschiller. I represent Senate District 24, which includes the towns of Exeter, Greenland, Hampton, Hampton Falls, Northampton, Rye, and Stratham. I'm here in support of CACR 2 relative to reproductive medical decisions. In November of 2018, 81% of New Hampshire voters approved adding 22 more words to our state's constitution, right to privacy, an individual's right to live free from governmental intrusion in private or personal information is natural, essential, and inherent. These words added as Article 2B. This amendment was about control, and who has it? New Hampshire citizens want control over their private and personal information. Our proposal of CACR 2 would be added as Article 2C with 31 words, which complement Article 2B. The right to make personal reproductive medical decisions is inviolate and fundamental to the human condition. Neither the state nor any political subdivision shall infringe upon or unduly inconvenience this right. This amendment, like 2B, is also about control and claiming it unequivocally. This amendment didn't come out of thin air, and it has inspiration from current statutes and legislative intent. Let me elaborate. In doing legislative research, there's another place in New Hampshire law I would like to share with you, the first part of Chapter 137-J, titled Written Directives for Adults Without Capacity to Make Medical Decisions. It states its purpose in policy as the state of New Hampshire recognizes that individual persons have the right founded in the autonomy and sanctity of a person to control the decisions relating to the rendering of their own medical care. The New Hampshire legislature has amended this chapter 3 times and consistently reiterated that purpose and policy statement. The state of New Hampshire recognizes that its citizens have the right, founded in the autonomy and sanctity of a person, to control the decisions relating to the rendering of their own medical care. And yet, when that New Hampshire citizen is pregnant, their rights to control decisions related to their medical care and the privacy of that personal information is thrown away. Pregnancy seems to be the line where constitutional rights are stripped away. In Article 1, equality of men, origin, and object of government, all men are born equally free and independent. Therefore, all government of right originates from the people, is founded in consent, and instituted for the general good. There is no caveat in Article 1 that says all men are born equally free and independent, except when pregnant. And yet that loss of freedom and independence is exactly what happens. Article 2, natural rights. All men have certain natural, essential, and inherent rights, among which are the enjoying and defending life and liberty, acquiring, possessing, and protecting property, and, in a word, of seeking and obtaining happiness. Equality of rights under the law shall not be denied or abridged by this state on account of race, creed, color, sex, or national origin, except when pregnant. A New Hampshire citizen who is pregnant loses the benefit of their life and liberty, particularly if their pregnancy is life-threatening or their pregnancy loses viability. Their affirmative rights to seek happiness by making reproductive medical decisions independently, as is their natural right, is stripped away. They no longer have control over their own body. They are enslaved to a law. Marginalizing pregnant women by stripping them of their natural, essential, and inherent rights is not the New Hampshire way. When a person does not have freedom over their reproductive decisions with affirmative rights because the state can interfere, they are chattel. This is not the New Hampshire way. New Hampshire citizens value our natural rights, and it is an unjust and undue burden to restrict the reproductive medical decisions made by citizens. It is our time to enshrine our values of freedom of reproductive decisions into our state constitution, because constitutional protections for reproductive rights are the gold standard. I respectfully ask you to recommend CACR 2 ought to pass. Thank you.
Questions for this witness? Yes, Representative Stapleton.
Thank you, Mr. Chair, and thank you for taking my question. This has been very helpful, your presentation piece, to be able to follow. I'm having difficulty with hearing in here, and I believe other folks may also. It's a very nice presentation that you've done here. I have one question. Relative to privacy in this argument, in this issue, are there any limits, or better term would be conditions, on how privacy governs this individual right of reproductive freedom? Specifically, would be how it may affect other persons, including the conception partner, as well as the individual person being grown in the womb.
I'm sorry, as well as the individual person, what? That last bit?
Yeah, the individual person being grown in the womb, as well as the conception partner to raise that individual if it were to be born.
I understand that. Thank you for the question and allowing me a moment to clarify that this constitutional amendment is designed to make sure that we are focusing on the person here, the person now who is covered by the Constitution. Women should have freedom to make their own reproductive choices. It is not the state's responsibility, it is not the state's purview to get inside a woman's body and make any decisions for what is right for her medically at any point. It is her decision to make, particularly reproductive choices, because they are reproduction is dangerous. It can be life-threatening. It is not an easy thing to do. It permanently changes someone's body, and entering into making a choice to have a pregnancy and follow through, if possible, with that pregnancy is not our business. The privacy of making medical decisions should be with that person. I hope that answers your question in terms of how this is.
I hear that.
Oh,
But
sorry.
does the conception partner also have that right to participate in that? Is it a sole right of the woman, or does the right expand or extend to the conception partner, the other individual who may decide opposite, for instance?
So I would say that CACR 2 specifies that anyone in New Hampshire's reproductive choices, whether they are the person, whether they are whatever side of the equation, I'm being delicate here, of a reproductive act, should have the medical autonomy to make their own choices. I would no sooner come before you and put legislation in front of this body that would limit your reproductive choices and where you can control your reproductive health. And we are requesting that equanimity for women too.
Thank you.
Thank you.
Other questions for this witness? Thank you very much. And ladies and gentlemen, thank you.
I appreciate the time. Thank you.
Ladies and gentlemen, next is Danielle Pimentel. And given what I see as the time and the number of additional witnesses, I am going to ask, please follow Ms. Pimentel and the witnesses that follow to please limit your remarks to 3 minutes. Thank you.
Good morning. Can you all hear me?
Yes.
Good morning, Mr. Chairman and members of the committee. My name is Danielle Pimentel, and I serve as Policy Counsel at Americans United for Life, which is a national law and policy nonprofit organization with a specialization in abortion, end-of-life issues, and bioethics law. Today, I strongly urge the committee to oppose this resolution because it prohibits common sense protections for women's health and safety from being enacted in the future, as well as infringes upon healthcare providers' conscience rights. Currently, New Hampshire has very few protections for pregnant women and the unborn. However, if this resolution is passed, it will make it even more difficult to enact future protections for the health and safety of women, which includes informed consent laws as well as parental involvement laws. And this is because the resolution imposes a strict scrutiny standard, whereby the state must have a compelling interest in order to regulate abortion, which can be achieved by the least restrictive means. Currently, New Hampshire does not have any informed consent process for women undergoing abortions, such as medical disclosures of the risks of abortion, the type of procedure, or a reflection period, which would ensure the woman has the time necessary to consider these risks and information before making a decision on whether to continue her pregnancy. These safeguards are critical because women cannot agree to medical treatment unless they are competent and have the adequate information to make that decision. Informed consent safeguards are also important because many women or protect many women against coerced abortions. Many women are subject to intimate partner violence as well as reproductive control. As many as 1/4 of women seeking abortions have some kind of experience with reproductive control. And informed consent safeguards women by providing them with material information to let them know that they are not alone in their decision, and that they have other alternatives, that they have other resources available to them. However, the resolution today would prevent states likely from passing these kind of safeguards to protect women. Additionally, the resolution contains broad protections for abortion, which raises serious conscience rights concerns. New Hampshire does not protect the conscience rights of healthcare providers in the abortion context. And although the state's constitution includes a purported right of conscience, it is an adequate protection for healthcare providers because the Constitution does not include within the language any mention of abortion or healthcare or anything that would ensure that healthcare providers' conscience rights are protected if they have moral or ethical obligations to abortions. Thus, this resolution could leave healthcare providers with either the choice of losing or not providing care, or having to violate their own conscience in performing an abortion. So for these reasons, I strongly encourage the committee to oppose this resolution in order to protect the health and safety of women, as well as protect the conscience rights of healthcare providers in New Hampshire. Thank you. And any questions?
Thank you. Questions for this witness? Representative Horgan.
You were speaking about coerced abortions. Does it go the other way around sometimes, where a woman becomes pregnant, but her partner coerces her to stay pregnant, even though she doesn't feel that continued abortion is a good thing to do, either for health reasons, because not all embryos that are conceived develop smoothly into babies, or just because of her relationship with a partner or where things fit into her life. So is it, isn't that also a problem though? Coerced pregnancy as well as coerced abortion?
Yes, that's part of reproductive control. There definitely could be individuals that have exercised some kind of control over a woman to continue her pregnancy. That is true.
Other questions for this witness? Seeing none, thank you very much. I'm going to next call on Representative Catherine Prudhomme O'Brien. And the next witness after that will be Sebastian Fuentes.
Good morning. Thank you. Thank you all for being here and listening to this. I know this is a very emotional topic, and it is an emotional topic for me as well. This bill, this CACR, really is about allowing abortion for any reason at any time in the pregnancy. It's not the same as a discussion about a woman who has a child that has a condition incompatible with life. Okay, that's a different argument. It's a different story. Now, when I ran for state representative, the first thing I told people when they asked me about myself was that I was pro-life. Okay, and I got elected. So I feel a duty to be here and say some things. My journey to being pro-life is probably unusual and not what you would expect. So to talk about it means I have to talk about my life, and it's kind of hard, but here I go. I grew up in the 70s and the 80s when there was a large feminist movement where we were told we could do anything and be anything, and I took that to heart. Okay, I really appreciated that kind of equality. It meant a lot to me. It meant so much to me. And I was a huge fan of Susan B. Anthony, and I read her life story, and I took it to heart because she believed in the equality of women and their ability to do what they needed to support themselves. The reason that she was so in favor of women supporting themselves and taking care of themselves was because she saw that it was a way that women could take care of their families and not have to endure the terrible situation of abortion. She did speak on abortion. A lot of people don't know that. I think she would be proud of what I did with that with her teachings. I was the first female in my vocational high school to graduate from the machining program, and I did support myself in that field for many years. I had an unplanned pregnancy at that time, and it made it all the difference. My own childhood was difficult. I've talked about it a little bit here in the past. I was born into a kind of poverty that I think a lot of people don't realize happens in the United States. I did not have a bed till I was about 7 years old. I was hungry a lot. We were in subsidized housing. We were on government aid. You would think that maybe that was my family story for generations, but it absolutely wasn't. My grandfather, who passed away soon after I was born, was a renowned physician and medical researcher, and he was the chief pathologist at USAMRIID when he passed away. USAMRIID is United States Army Medical Institute researched something. Okay, I'm sorry. I asked my mother why she did not have an abortion when she was pregnant with me, because how much poverty happened after the divorce and all of that. And she told me about something that happened when she was a child. And
Representative, we are
I will
over
be quick.
You're over the 3 minutes now.
I will be very quick.
All right.
She told me about something very interesting that happened when she was a child. She was on the campus of the University of Vermont, where her father was a medical professor, and she waited for him at his office. And when she was in the office wandering around, she found fetuses in jars in all stages of development. And she told me that is why she did not have an abortion when she was pregnant with me, despite the fact that it plunged her into years and years of poverty because of the divorce. She said she knew those were people when she saw them. And her father came out of his office and told her, those are fetuses. Fetus means baby, and those are babies. And she said, yes, I know those are babies. Obviously, they're all babies. They were all in very different stages of development. I feel like I owe my life to those medical teaching aids, because my mother really struggled and worked very hard to have children. And I'm pro-life because of that. I feel like I was a person before I was born, just as much as I am a person today, worthy of protections. And so that I want to share that story with you.
Thank you. Questions for this witness? Seeing none. Sebastian Fuentes, and the next witness after that will be Liz Canada. Fuentes?
Thank you, Mr. Chairman Lin, and members of the committee for listening to my testimony. My name is Sebastian Fuentes. I'm the Movement Politics Director for Rights and Democracy of New Hampshire. I'm also a North Country resident for the last 21 years. I don't want to address you as a political director or anything like that, but I'm here to talk to you as the son of a brave mom, as the husband of an amazing woman dedicated to her family and the community, and the father of 2 amazing, beautiful daughters. I need to fight day and night for the rights to make their own decisions. I'm also a father of 4 children. I was able to, after my last baby was up in this world, to go to the hospital, make an appointment. Literally in a matter of a week, I was able to just request a vasectomy. I was in and out. I made my own choice. I walked out of the hospital and realized that my wife don't have that right. I realized that my daughters won't have that right. I realized my mom don't have the right. My neighbors, my siblings, my sister don't have the right. It felt good to be able to do that. But I also felt really worried about their rights. They were not able to do that as well. I came 21 years ago from a country where women die in improvised abortion centers because abortion was banned. I came from a third world country where indigenous women were forced to have the uterus removed for money in order to keep poverty low. Many died in the process, many were forgotten. Restricting access to reproductive care, abortion included, is a threat to our communities, especially Black and brown communities in this country. New Hampshire needs to move forward when discussing reproductive rights, not backwards. Now, for the last 7 years, I have come to this state house to testify about many issues from affordable housing. When my son was 3 weeks old, I came to this same building downstairs to the Senate committee to testify about paid family leave. For the last 7 years, I have came to testify about minimum wage. I came to testify against guns in the schools and many other issues like utility bills. And right now, right after this, I have to go to LOB 101 to testify with my son, my wife, and my daughter about childcare affordability because it's something that is hurting us. So my question to you all is, when are we going to allow young families in New Hampshire to thrive? Enough is enough. Our state legislators, regardless of party affiliation, must support affordable access to abortion. And bodily autonomy should be left to the discretion of the individuals. We should let the residents of New Hampshire make their voices heard about this issue. My mother, my wife, my 2 daughters, and thousands of amazing women in New Hampshire are waiting for action. Let's be on the right side. We owe that to them. So I'm here to support CACR 2, and I hope you do that too. Thank you so much.
Questions for this witness?
Thank you. I just got to rush to
Thank you.
101 now. Thank you.
Liz Canada, and next after Miss Canada will be Josie Pinto.
Good morning. Are you able to hear me with my mask on? Sounds okay? Sorry, my kids are really sick, so I'm like really worried. Okay, so my name is Liz Canada. I'm the advocacy manager at Planned Parenthood of Northern New England and Planned Parenthood New Hampshire Action Fund, and we're here to support CACR 2. After the U.S. Supreme Court completely overturned Roe v. Wade last June, abortion was on the ballot very explicitly in 4 states: Vermont, Kansas, Kentucky, and Michigan. 2 of those measures were to further restrict abortion, and 2 of those measures were to enshrine protections into their state's constitution. Those states have very different processes in order to amend their constitutions than we do, and they allow ballot measures based on signatures, but the overarching question was still the same. And in all 4 states, which are arguably very different from one another, voters overwhelmingly supported reproductive rights, soundly defeating anti-abortion measures and approving reproductive freedom. Reproductive rights, abortion, birth control are all bipartisan supported issues. They are not red or blue issues. Here in New Hampshire, we have enjoyed for so long a bipartisan support of reproductive rights here in the State House. CACR 2 would send the question to the voters. It would allow for the voters of New Hampshire to decide on whether the New Hampshire Constitution should be amended to explicitly include reproductive freedom. It is a very high bar to amend the state constitution here in New Hampshire. But we know that the vast majority of Granite Staters support reproductive rights, and they do not want government interference in their reproductive health care or in anyone's reproductive health care. Polls indicate that New Hampshire is one of the most supportive states regarding reproductive freedoms and limiting government interference on pregnancy. And CACR 2 would let Granite Staters voters' voices be heard, just like we saw in multiple states this past year. So we encourage you to vote ought to pass on CACR 2. Thank you.
Thank you. Questions for this witness? Seeing none, thank you.
Thank you.
Josie Pinto, and next will be Megan McNeil.
Good morning, representatives. My name is Josie Pinto. I'm a constituent of Dover, and I'm here in my capacity as the Executive Director of the Reproductive Freedom Fund of New Hampshire, urging you all to support CACR 2. My work is about breaking down barriers for patients who need abortions, and I believe this legislation would be the strongest possible way we can ensure patients are able to access the reproductive health care they need without worry, fear, or confusion. Ever since the 24-week abortion ban went into effect in New Hampshire and Roe v. Wade fell early this summer, my organization has dealt with a lot of confusion from patients around where their rights stand. It's understandably hard to keep up with the shifting national landscape, but I'm confident this bill would help bring voters into the decision process to affirm once and for all that Granite Staters support the right to abortion. Recent polling has already shown us this is true, with about 70% of citizens affirming their support for abortion rights. Regardless of your personal opinion on abortion, I urge you all to consider that this issue deserves to be decided by the voters of this state, the people who would truly be impacted by this. When Roe was struck down, the decision was handed to the states. So let's allow the voters of the state to decide. I want to see New Hampshire declare our strong support for abortion, not just in this current political moment, but for the generations to come who deserve to be guaranteed the rights that most of us of reproductive age have had our whole lives. The right to abortion is a right that goes alongside our values of living free. I believe that bodily autonomy is the ultimate form of freedom, and that we should be guaranteed that right in a state that so highly values personal autonomy. New Hampshire has a long bipartisan history of supporting privacy, particularly when it comes to personal medical decisions. CACR2 will protect Granite Staters' right to reproductive autonomy and prevent future attacks on our access to contraception, sterilization, and abortion care. Let's let the voters settle this matter once and for all. Please support CACR2 to bring our state one step closer to making reproductive liberty a reality for us all. Thank you.
Thank you. Questions for this witness? Seeing none,
Thank
thank
you.
you. Megan McNeil, and after Ms. McNeil will be Courtney Reed. Ms. McNeil?
Hi, my name is Megan McNeil, and I'm a resident of Dover, New Hampshire, and I'm here to ask you to support this bill. As a libertarian woman, I believe that individuals should have the freedom to make their own choices about their bodies and their lives. This includes the right to access safe and legal abortion. The decision to have an abortion is deeply personal and should be left up to the individual. No one knows the circumstances of a woman's life better than she does. It's not up to the government or anyone else to dictate what a woman should do with her body. In fact, attempts to restrict access to abortion are a violation of individual liberty. These restrictions not only limit a woman's ability to make decisions about her own body, but they also disproportionately affect low-income women and women of color who may not have the resources to access safe and legal abortions. Furthermore, making abortion illegal does not stop women from seeking out this necessary medical procedure. It only pushes them towards dangerous and potentially deadly alternatives, such as self-induced abortion or seeking out unlicensed providers. As a libertarian, I also believe the importance of limited government intervention into people's lives. Laws that restrict access to abortion are a clear example of government overreach. The government should not be in the business of dictating medical decisions or moral values. Ultimately, the decision to have an abortion should be left up to the individual. It is a private matter that should be made in consultation with a healthcare provider, not politicians or activists who seek to impose their beliefs on others. In conclusion, as a libertarian woman, I firmly believe in the importance of individual liberty and limited government intervention. This includes the right to access safe and legal abortion. Attempts to restrict this right are a violation of individual freedom and have a negative consequence for women's health and well-being. It's time to trust women to make their own decisions about their bodies and their lives. Thank you.
Thank you. Questions for this witness? Seeing none, thank you. Courtney Reed, and next after Ms. Reed will be Jocelyn Toffee. Toffee, I believe I'm pronouncing that. Toffee. Oh, thank you. Ms. Reed.
Thank you. Can you hear me?
Yes.
Thank you, Chairman and members of the committee. My name is Courtney Reed. I'm here with the ACLU of New Hampshire, and I just want to provide another brief statement of support for this CACR. As we've heard, this amendment would enshrine reproductive rights in New Hampshire's state constitution and allow voters the opportunity to ensure that abortion stays legal in the state and that patients continue to have access to necessary reproductive care.
With the current legal landscape that we're faced with, this is one of the most effective tools we can use to ensure that these reproductive liberties remain in place for granted staters. And I just want to speak to why that this is effective in that the compelling state interest element of the constitutional amendment subjects the state to strict scrutiny, whereby the legislature would need to establish that there is an extremely important reason to enact a law that would further restrict reproductive rights, and that lawmakers would also need to prove that there are not any other possible ways to address the state interest without infringing on this right to reproductive freedom. We've already seen in response to Roe's overturn, states take proactive measures to protect reproductive liberties, including California, Michigan, and our neighboring state of Vermont, passing their own state constitutional amendments to ensure that these reproductive freedoms are protected. And I just want to wrap up by stating that abortion bans pose life-altering consequences for pregnant individuals, whether it be the health risks that they might be faced with, needing to continue a pregnancy, more difficulty escaping poverty, perhaps not being able to hold on to a job or continue their education. And ultimately, reproductive freedom is an essential freedom to fulfill the promise of equality and self-determination. So I recommend that the committee move forward with this CACR and ensure that granted staters have the opportunity to protect reproductive liberty as a central freedom and a dignity as everyone deserves, the power to decide for themselves if and when they want to have a child. Thank you.
Questions for this witness? Seeing none, thank you. Ms. Toffey, and next will be Maggie O'Neill.
Good afternoon, everyone. My name is Jocelyn Tofik. I live in Dover, and I'm here currently to support CACR2. None of what I'm about to tell you is anyone's business, and I do feel resentful feeling like I have to come down here today to tell this to a room of strangers. But that's how important I think this amendment is. In 2004, when I was 26, I had an abortion. I had a 2-year-old daughter and lived with her father in a home we owned in Dover. I was in my second year of college, and I had been on birth control and using it fully as directed with no user errors confirmed by my gynecologist. We knew we did not want another child. We could not afford another child, nor could I have finished my degree, as the inherent risk to my health would have been too debilitating. My first pregnancy was fine until it wasn't. At around 34 weeks, I went preeclamptic, and I hemorrhaged immediately after giving birth. 100 years ago, I would have died. In 2004, my odds were better, but they were certainly not zero, especially here in America with the worst maternal mortality rate among all wealthy countries. Preeclampsia is still one of the leading causes of pregnancy death in the United States. Bleeding out accounts for 75% of all pregnancy deaths in the United States. Not only that, the rate of preeclampsia in the US has increased by 25% in the last 2 decades. Maternal mortality rates overall for all conditions are increasing year over year in the US. There are so many good reasons to constitutionally protect a woman's right to decide what happens to her own body, but the one I really want to focus on is that pregnancy entails a statistically measurable and significant risk of death. Who is this or any government to tell me I am required by law to risk my life in a forced pregnancy? It's insane. Although the risk is very much real, a history of preeclampsia and hemorrhaging after birth would not preclude me from having another child. It would be a risk, but by many state standards would not be considered imminent threat enough to allow for termination in more legally restrictive environments. This is why constitutionally protecting my right to decide if I live or die pregnant is important. An average of 24 pregnant people in America will die for every 100,000 live births. That's one pregnant woman dead for every 4,167 who get to live. If you are Black and pregnant, that statistic explodes to 1 pregnant woman dead out of only 1,818 pregnancy survivors. If you are over 40, which I am, that number is now 1 dead woman for every 926 who get to survive that pregnancy. Those are good odds for a Powerball ticket. So my question is, who gets to determine what is too risky for me? Who gets to say what odds of death I am forced to accept? Me or my government? I'd very much prefer it be me. These numbers from the CDC do not even include the leading cause of death for pregnant people in America. Because the leading cause of death is not considered a medical result of complications due to pregnancy. Because the actual leading cause of death for pregnant women in America is homicide. The horror of that. Pregnancy can be and often is lethal. And when it is lethal, as in the case of bleeding out, there is usually no warning. I had no indicators prior. My pregnancy nearly killed me. So who gets to decide for me when I will risk my life and how and for what? It should be me who decides when I choose to risk my life. When the odds of surviving forced pregnancy or any pregnancy are this bad, the government should not and should never have the power to force me to be pregnant against my will. The government's duty at its very foundation is to protect my very basic right to live. Please approve this amendment for public vote and let the people of New Hampshire decide when and how and for what they want to risk their life. Thank you.
Questions for this witness? Seeing none, thank you. Maggie O'Neill, and next will be Nicole Lyman.
Good morning. My name is Maggie O'Neill, and I'm a proud resident of Newmarket, New Hampshire, and I'm here today to voice my support for CACR2. I attend church nearly every Sunday, as I have done most Sundays through my life. And as a Christian American, I recognize the rightful separation of church and state, as well as the pluralistic nature of our society. Our tradition of protecting religious liberty predates our independence as a nation, actually. My faith calls me to hold compassion and love for all people and to afford them the dignity to make decisions for themselves according to their own needs and circumstances. And it's not just my personal belief either. After the fall of Roe, the Episcopal Church stated that they uphold the conscious rights of pregnant persons to determine whether they want to continue a pregnancy. They have called since 1988 on state and federal governments to take, this is a quote, take special care to see that individual conscience is respected, and that the responsibility of individuals to reach informed decisions in this matter is acknowledged and honored. I trust people to make their own decisions when it comes to the deeply personal and complex experience of pregnancy and reproduction. I am grateful every single day that I was able to access abortion care when I needed it. Abortion care is life-saving health care, which all persons deserve access to. These decisions should be left to individuals according to their needs. I urge you to support this constitutional amendment to protect this right. Thank you.
Questions for this witness? Seeing none, thank you. Nicole Lyman, and next after Ms. Lyman will be Evan Ringo, I believe.
My name is Nicole Lyman, a Dover resident and New Hampshire native. I am here today to share with you my personal story in hopes that it will inspire an understanding of the importance of Bill CACR2. My first child wasn't planned. I was terrified. I was only a year into my sobriety, and although I was clean, I was going through a period of my life where I was struggling with depression, joblessness, and having a steady home. Despite what you may think about pregnancies being obvious, I was totally unaware I was pregnant till I was 4 months along. The pregnancy was not easy. The father of my child was extremely mentally abusive. I needed to do everything I could to get away from him. If ever the factors were aligned in my life to choose abortion for convenience, this would have been the time. I can't imagine not having that choice available to me. Having that sacred right to choose for my own body was immensely important to the decision-making process. Essentially changed me to be a better person. I was able to confront my fears, and after everything was considered, I made the very difficult decision to have the child and raise her essentially on my own in the face of some pretty difficult odds. Just a few months after my daughter was born, I was diagnosed with postpartum depression, and at the same day also found out I was pregnant again. Amazingly, I was a small percentage of people who had birth control fail. My life was nearly in shambles. I was getting out of an abusive relationship, the stress of being a new mother, struggling with income, and finding a place to live nearly cost me my sobriety and nearly cost me my life. I chose to terminate the second unexpected pregnancy so I could save my health and move on with my life to be a good, healthy mother. There's no question I made a lot of choices, but the most important part of the process was that I had the freedom to do so. One of the most heartbreaking moments thus far, being a mother, was receiving the news of the overturn of Roe v. Wade from my 13-year-old daughter. One of the most, when she gave us the news in the car, she had tears in her eyes. She looked terrified. I was not even aware she knew how serious this was till this moment. Something happens to a mother when she sees her child feels unsafe. I made a promise that I would fight this so she could feel safe and have the same freedoms to her body that I had. It's crazy watching my daughter grow into this independent human with independent feelings, making her own choices that she will grow from. She's going to make mistakes. We all are. We are human. We are flawed. It's important for us to have the choices when it comes to body autonomy, no matter what the reason. Please support Bill CACR2. We need not forget the history of what life in our culture was like pre-Roe. I would really love to see my home state stand on the right side of history with this one. Thank you.
Questions for this witness? Seeing none, thank you. Evan Ringo, I hope I've got that right. And the next witness after that will be Nico Anasterik, I believe. I hope I'm pronouncing those correctly.
Hi, can you hear me? Cool. Hi, I'm Evan Ringo. I'm from Pelham. Would like to start talking about some of the non-abortion aspects that this could protect. In 1952, Britain chemically castrated one of the greatest computer scientists of history, Alan Turing. The power to chemically castrate by the state is currently in law in a number of states here, and that this protection would help against that. And considering how often states have wrongfully convict people and put them on death row, only later for it to be overturned, I'm very worried about that, the state having the power to chemically castrate or force sterilize someone. I also am aware of how easy it is for me as a man to go get a vasectomy, and the number of barriers that are in place for a woman to try and get her tubes tied. And having this protection would make it a lot easier for laws to come in place and for suits to be brought so that women would have the same access that a man does to make these choices proactively to, prevent abortions from happening. Similarly, there are a number of cases where people have tried to restrict birth control access, which again makes it proactive so that abortions don't have to come up. On the abortion issue, I as a libertarian, I believe that your right to your body is the fundamental right. You don't really have any other rights if you don't control your body. That's the kind of the basis of it. All of your property rights go away. If you can't control yourself, you can't control anything. So if the state is willing to take over your choices in that, then really they're pretty much able to take over your choices with anything. So I just would urge you to let people make the choice on this, to let our citizens vote, because that's kind of the whole point of having freedom, is letting people speak their mind. And by not letting them vote, you're basically saying, hey, we don't trust you to speak up and think for yourselves. So maybe don't do that.
Thank you. Questions for this witness? Seeing none? Nilo Anastarsic.
I got it.
I'm sorry if I'm.
It's all good.
And next after that will be Susan Richmond.
Hello, my name is Nico Anastasia. I'm from Portsmouth, and I'm here today to speak in support of CR2. I rarely speak publicly, and I'm here simply in support of the women in my life. I strongly believe that women should have the right to choose whether or not to have an abortion. While I may not personally be able to experience the physical and emotional toll of pregnancy and childbirth, I can certainly empathize with difficult decisions that women face when it comes to their reproductive health. There are many reasons why a woman may choose not to have an abortion that we have heard today. Whatever that reason, it is ultimately the women's decision to make, not mine or anyone else's. Critics of abortion often argue that it is immoral or goes against religious beliefs. However, I believe mortality is subjective and everyone has the right to their own religious beliefs as protected in our Constitution. It is not fair or just to force someone to adhere to a specific moral code, particularly when it comes to such a personal decision. Furthermore, denying women access to safe and legal abortion services can have devastating consequences. It can lead to dangerous back alley procedures, increase maternal mortality rates, and perpetuate gender inequality. It is unfair to force women to carry a pregnancy to term against their will. In conclusion, I believe that it is important for men to support women's right to choose when it comes to their reproductive health. We should not seek to control or dictate what a woman can or cannot do with her own body, but rather trust and respect her ability to make the best decision for herself and her future. Access to safe and legal abortion services is essential for women's health and autonomy, and we must work to ensure that these services remain available and accessible for all who may need them. Please support Bill CACR2 for women of New Hampshire.
Questions for this witness? Seeing none, thank you, sir. Susan Richmond, and next after Ms. Richmond will be Erica Revere, I believe, or Reverez.
Okay. Thank you, Chairman Lynn and members of the committee. I speak in support of CACR2. I went to high school, as did my husband, when prior to Roe v. Wade, and a female colleague of my husband's in high school jumped off the high school roof, killing herself because she did not have an option of another way to end her pregnancy. So I'm here to stand up for the women who have not had choice and who will not have choice if their right to abortion is taken from them, and they will resort to some method or other, and it could be back alley or self-inflicted abortion if there's not legal, medical, safe means. Thank you.
Thank you. Questions for this witness, please? Seeing none. Erica, and I think maybe it's Perez. I'm sorry.
It is Perez.
Sorry.
Thank you.
And Kathy Holmes will be next. Ms. Perez.
Good morning, Chair and members of the committee. My name is Erica Perez. I'm from Manchester, New Hampshire. And today I'm speaking in support of CACR2 because I think reproductive rights should be codified into our state constitution. I want the security of knowing that anyone from my state that chooses to have an abortion can have one simply because they need one, without the red tape of law following them around or trying to intervene. The fact is that abortion is legal in New Hampshire before 24 weeks for now. We have no guarantees. We have nothing protecting us from the people who represent us one day deciding that we should have a 6-week abortion ban, which is an actual bill that's come up for the past 2 years at least. I want the people of New Hampshire to decide. I think that's fair. Put abortion on the ballot and see what the people of New Hampshire really want. The thing is, we aren't just talking about reproductive rights. We're talking about people's futures. We're talking about people escaping abuse. We're talking about teenagers who aren't ready to be parents. We're talking about freedom. Do we have it or not? Do you believe in autonomy or not? Again, please support CACR2. Thank you.
Thank you. Questions for this witness? Seeing none, thank you. Kathy Holmes, and next will be Sophie Mara.
Okay, I have my stopwatch going. I think I can do this in 1 minute. Thanks to that tall representative who had the cell phone trouble. I hope he submits a written testimony because I would sign my name to it. He so succinctly said all the things that I would say. I just have 2 things to add. One is I thought Senator Deborah Altshire had an excellent case for issues like ivermectin and vaccine, and I'm going to look it up on the live stream and get that information. But the last thing I want to put out there is a phrase that my husband came up with years ago. Why doesn't anybody say this? Pro-choice. That's pro-choice. Before the act, not the fact. Women have a choice, but with freedom comes responsibility. That's it.
Thank you. Questions for this witness? Seeing none, Sophie Marrow, and next will be Mary Rose McLaughlin. Marrow.
Good morning. Can you hear me okay? Great. My name is Sophie Merrill. I'm a constituent from Portsmouth, and I'm really glad to be here today to show my support for CACR2. I volunteer with the Lovering Health Center and with the Reproductive Freedom Fund of New Hampshire. And my primary role is supporting patients in aftercare, providing emotional support, and just holding space for folks as they recover. And every patient and their experience is different, but it is always an honor to support people in this way, and I'm really proud to play a small part in helping folks to access the care that they need. I'm proud of my friends and my fellow volunteers who are here today and who are here every day in solidarity with each other. I'm proud of centers like the Lovering and their commitment to safe, compassionate, and inclusive care. And I am the most proud of patients in New Hampshire who advocate for themselves and show tremendous bravery in the face of fear, uncertainty, and unnecessary obstacles. So I'm glad that we're here today to talk about how we can remove those obstacles. I'm glad that my reps are listening to the vast majority of Granite Staters who believe that abortion should be legal in all or most cases. We are one of the most supportive states in the country when it comes to reproductive freedom, so I'm glad for the opportunity to correct the fact that New Hampshire is the only state in New England without protections for abortion. Because the bottom line is that reproductive freedom is a prerequisite to being a full, free, and equal citizen. It is a foundational, essential liberty without which none of the others can exist. If the state can tell me if, when, and how I become a parent, I am not free. If the state can take that choice away from me, I cannot participate equally in society. And if my doctor needs to double check with a lawyer or a politician before providing care, I am not safe. Until we protect reproductive rights, not only are we not safe, but we are out of step with our tradition of respecting folks' privacy and personal decision-making. And we will continue to waste time and resources fighting regressive legislation rather than working towards a better, healthier future. The right to safe, accessible reproductive care is a fundamental human right and must be decided by the voters. Thank you for your time.
Thank you. Questions for this witness? Seeing none, Mary Rose McLaughlin, and next will be Omer Ahern.
Okay, good morning, members of the Judiciary Committee. I hope you can hear me
You
okay.
need to get up close to the mic. Thank you.
Thank you. My name is Mary Rose McLaughlin. I'm a student and a law intern from Sullivan County. As you know, CACR2 proposes that an additional section on reproductive freedom be added to the New Hampshire State Constitution. CACR2 states that an individual's right to personal reproductive autonomy is central to the liberty and dignity to determine one's own life course and shall not be denied or infringed on unless justified by a compelling state interest achieved by the least restrictive means. Saying that an individual should have a right to personal reproductive autonomy is completely good and true. However, this amendment should not be added to the New Hampshire State Constitution because it implies that the current laws against infringing on reproductive freedom are not enough. The amendment being proposed implies that abortion will perfectly ensure reproductive freedom and the ability to choose one's course of life. This is false. CACR2 will have the complete opposite effect. Reproductive freedom, defined as a person's freedom to choose when they wish to have a child and who they wish to have it with, is already protected in New Hampshire RSA 632A. Abortion takes away another individual person's reproductive freedom and autonomy, and most importantly, another life. Abortion infringes on liberty, dignity, autonomy, and most especially the future course of life of the fetal human being. Therefore, because this amendment implies the legality of abortion, it should not be added to the New Hampshire State Constitution. Thank you.
Thank you. Questions for this witness? Seeing none, thank you very much, ma'am.
Thank you.
Omer Ahern, and next will be Julie Ledoux.
Thank you, Mr. Chairman. My name is Omer Ahern Jr., and I am from Wentworth, Grafton County, New Hampshire. I am one of 7 children. I am the father of 4 children and the grandfather of 8 grandchildren. I ask this committee to oppose CACR2. To me, this is about saving precious lives of human beings. I do believe that life begins at conception and ends at natural death. As humans, we can decide what we do. We are not animals. So people already do have reproductive autonomy. Decisions and choices are not always easy, but they do have consequences. If a person does not want to have a baby, just say no before doing the act of creation. Even if the pregnancy is caused by a criminal act and the woman, after thought, does not want to have the baby, a second crime is not justified in any way, taking the life of another human being. There are many families who would love to be able to help women in these situations. And there are medical providers who will also help. The mother saved the life of the baby, and then this family or these families would raise the child who can grow up to be a great benefit to our republic and our society. I'm also an attorney, and in my law practice over the last 44 years, I would have married couples come into my office and ask me to help them find a baby that they could adopt, love, and raise in a loving family. But they were not there. Babies are needed. Please save lives and oppose CACR2. Thank you very much.
Thank you, sir. Questions for this witness? Seeing none, thank you. Julie Ledoux, and after that will be Ash Draper.
Thank you. I'm coming from Hollis, New Hampshire. There's no way this is not going to be emotional and subjective to one degree or another. But I work with post-abortion survivors who are horrified and traumatized by what they've been through. My husband, when he was studying to be a physician, assisted in a procedure, dilation curettage, and watched as a living human being struggled inside the womb and was hacked to pieces. And he pulled out body parts. You can't have a foundation for anything if you build it on a false assumption. There's no foundation for freedom or love or care or anything we believe in if we don't understand what is essentially human and why we must protect it. And I want to ask those of you women who've been hurt to please forgive us, because you did deserve better care. I personally support an organization that will fly women from anywhere in the country to be cared for completely through 9 months of pregnancy, given everything they need. This is the kind of thing we need. I have a lovely spiritual daughter who went through an abortion because she didn't believe she could survive. I found out afterwards, and I told her if I had known, I would have done absolutely everything I could to save her and her child. And if it really, really was an issue of the choice of her life or the child's, I would have chosen her. The reality is you had a senator stand right there and talk about essential constitutional liberties who was ill-informed about something called common law and essential natural rights. She said something about autonomy and the sanctity of a person, but she didn't realize that the natural rights she referred to in our Constitution, the formation of those relied on something called maxims of law that come from the 17th century. And the maxims of law that informed John Locke and the formers of the constitutions, our state constitutions, and our essential idea of what is human and what is sanctified to protect comes from maxim of law, which is, let me just find it here and read it to you. Maxims of Law 58C, he who is in the womb is considered as born when his benefit is concerned. That is the foundation for natural law and common law that were the foundations of our Constitution. Everything else is going to have to flow from our reality and our acceptance that humanity is messy, that we will die when we try to care for one another. It will hurt, it will cost us, we will fail. But if we think a human baby is 3/5 of a person, like they thought a slave was, and we don't move past that, we will never build anything that will create a foundation of truth to build all our other values on. Constitutional amendment is not something to just throw around. If you don't build from the right foundation about what is human, what deserves protection, you won't build true essential health care for women. We've failed. It's time for a new thing. But we can't build anything good and true and lasting and compassionate and truly free if we don't understand what is essentially human and must be protected at all costs. We're in a painful time. We're in a painful time. We're going to have to rethink so many things. We failed so many women and so many babies. But you don't build what is good and true and lasting on a foundation of lying about what is essentially human from the moment it is conceived.
Thank you. Questions for this witness? Representative Horgan, did you have a question?
First of all, well, I hesitate to ask it, but you're hearkening back to John Locke's time, and I'm not sure if I'm familiar with John Locke. I'm not. In his time, was reproductive health something that was handled exclusively by, or primarily by men, or is that something that was considered at the time to be kind of within the women's sphere of influence?
My point was simply that when these matters were being considered, that even our forefathers and the people who wrote the Constitution understood there was an issue of life in the womb. And believe me, abortion was very much an issue. It always has been, the issue of life and death. It's always been messy. It's always been difficult. It's when we somehow just assume that somehow what creates essential freedom is a woman's right to choose. And we forget the foundation that freedom is based on the value of humanity. We've got to go all the way back to the beginning. Right. And our founders actually thought about these things. They really did. So I believe that senator was pretty much misrepresenting the idea of natural constitutional law.
Other questions for this witness?
Well, then, the Constitution, like it says, what they wrote was all men are created equal, and I guess the role of men and women has changed a lot, but actually all our men are born equal, so why did they do it born instead of conceived?
Well, I just was taking issue with the fact that you had a senator who came here and stood on constitutional law, and you could say, well, then maybe we shouldn't listen to her because what she quoted was written by men. I think it's just important that we understand that our founders understood how deeply important it was to know who is human and why that matters in the womb, and why we can build from that something better that serves everyone.
Thank you.
CR2 isn't it?
Thank you. Other questions for this witness? Seeing none, Ash Draper.
My name is Ash Draper. I am a Chester resident and New Hampshire native. I am a Yale-trained midwife. I work in a community health center in Manchester and help bring babies into the world at Elliott Hospital. I am here speaking for myself, and I am here in strong support of CACR2, a bill that supports the reproductive decisions of all. At least 10 times a day, I am witness to the trauma and difficulty life brings to so many. My patients are not here today due to the many barriers, some of which include the inability to get time off from work, not having someone to watch their children, not having access to reliable transportation, or simply not speaking English. So I am here today to speak for them and their families. I see how difficult reproductive decisions are without the government posing barriers. I can confidently say, as an individual and as a healthcare provider, that it is your duty as representatives to support individuals in helping to make active decisions for themselves and their families. As we know, only an individual knows the best situation for themselves, the best decision for themselves at that time in their life. Please vote to protect these families and making decisions that are best for them by codifying this constitutional right. Someone just a little while ago suggested the idea of just saying no. I wish I could invite this person and others who feel this way to shadow me for one day at work, or even just an hour. You would see this is not an option for so many. While I would love to share the details of stories of why saying no just doesn't work for all, I know it would keep you up at night, and I know I only have 3 minutes to speak today. I only heard of this hearing last night, so I didn't have time to quite prepare the statement I would like, so I hope this suffices. It's hard as a healthcare provider to be present in vital hearings like this one today when you are busy on the ground doing the work, caring for individuals and their families, their fetuses, and their babies. Many of my colleagues are overwhelmed and overworked, ensuring that they provide quality sensitive care to all individuals, so they don't have the capacity to wait to speak here today. I have written testimony I will also submit, and I just want to offer the space for questions now or at a later time.
Thank you. Questions for this witness? Seeing none, thank you very much, ma'am.
Thank you for your time.
I don't have any other pink cards. Is there anyone else who wishes to testify on CACR2? Yes, you need to submit a card. You need to submit one of the pink cards, and you can speak first and fill it out. You can speak first and fill it out later, okay?
I wasn't planning to speak, but this session moved me. My name is Catherine Haraki. I live in Hampton, New Hampshire. Statistically speaking, 1 in 5 pregnancies end in an abortion. That means that of these 5 great men behind you, these framed leaders, one of their wives most likely had an abortion. But why did that matter then? Because what women didn't matter then. They weren't considered. So what they did didn't matter either. It wasn't worth making legal or illegal. And I couldn't help but think what a coincidence it was that abortion didn't become illegal until around 1829, the same year, within a year, when the first women's strike, which happened in Dover, New Hampshire, when 800 mill girls left the factory because of terrible conditions. And what a coincidence that the moment women start asking for some rights, other rights start getting taken away. So this discussion isn't about right or wrong. We're all sinners. And if this was about right and wrong, we wouldn't have a governor, we'd have an Ayatollah. This is about wants. I want reproductive rights. She wants reproductive rights. He wants reproductive rights. And some of you want reproductive rights as well. That's what we want, and that's what we're here discussing. And I will go even so far as to say that by saying no to CRC2, it's not only carpetbagging a philosophy that doesn't belong in New Hampshire. I will go so far to say, after hearing some comments today, saying no to this to me might be saying that you're trying to compensate for your own sins and perversities. So my wish today is for you to think very carefully about New Hampshire's history, New Hampshire's wants, and look into your own soul and make the right decision. Thank you.
Questions for this witness? Seeing none, thank you. Anyone else who wishes to speak on CACR2? Seeing none, I'm going to close. Oh, yeah, please don't forget to fill out the pink card, okay? Seeing no other witnesses desiring to testify, I'm going to close the hearing on this. And we've been going now for over 2 hours, so I'm going to take a brief recess before we resume by taking up HB 271 FN. So we'll, all right, so we'll take a brief recess. How about when we say, why don't we say 10 minutes? Take a 10-minute recess. Yes. Oh, okay, sure. Yes, I'll distribute this to everyone. Thank you. Oh, yeah. Great.
No.
Oh, you want to?
But I'm guessing.
Well, you know what? I took all the reps and or the former reps, you know, just trying to, yeah.
I just, well, you didn't say four.
No, I didn't say former, but I kind of fixed it.
But that's okay, because I got, it's interesting. It's interesting.
Yeah.
If you talk very succinct.
Right.
People hear it. That's very nice.
Sweet.
Sweet. I got a lot of comments on that.
Yeah. All right. No, I didn't. Sorry. All right. This is the House Judiciary Committee. I'm going to call it back into session to hear House Bill 271 FN. I'm first going to recognize the sponsor. And because she is the sponsor, she may speak for however long she needs to speak to tell us about the bill. After she speaks, I will, because of time and because of the number of people who have indicated a desire to speak, I will impose a 3-minute limit on other people that wish to speak. So without further ado, I would recognize the prime sponsor, Representative Marjorie Smith. You're not. No, not.
To try.
Okay, thank you.
The sound system is terrible. Let me set the stage, Mr. Chair. My name is Marjorie Smith. I'm honored to serve on this committee. This is my 13th term. During those 13 terms, I have served on 2 major policy committees only, Judiciary and Finance. And I have chaired each of those twice. So the connection between Judiciary and Finance is one that is very close to me. I care about policy, procedures, and politics in the Greek sense of the word, trying to bring people together to solve common problems, not the same goals as partisan politics, which I have never been good at. Every 2 years, House Bill 1 is the budget, House Bill 2 is what we refer to as the trailer bill, and House Bill 25 is the capital budget bill. That happens every 2 years. The trailer bill is the bill that is created to provide any language necessary for the numbers that appear in House Bill 1. That is the only material that is supposed to go into House Bill 2, language which makes the budget work. I am stuffy and I'm old-fashioned. I believe in doing what we are supposed to do within the legal structure that we, as a nation and a state and a legislature, have established. 2 years ago, in complete violation of policy, practice, and procedures, a section was included in House Bill 2 that had absolutely nothing to do with the budget. There had been no assignment to a policy committee, no hearing, no relevant committee action, and no public dollars involved. Let me repeat that. No public dollars involved. The House and the Senate passed the budget bills and the governor signed them, saying he objected to the language that I object to here, but he had no choice because the budget had to pass. Now let's think about that for a moment. That was an interesting statement on the part of His Excellency for two reasons. The first is he claims to respect the rights of women to control their own bodies, to make their own choice. And he repeats that as he goes about the country now, having an opportunity to present himself to voters in other states. He talks about being pro-choice. And the other reason this is interesting is not just 2 years before the governor acted on his right to veto the budget, and then a new budget was formed. He knew from his own experience that he didn't have to sign a budget bill that was anathema to him if he had wanted to follow policy, procedure, and practice. Since then, there have been multiple efforts to try to stop the damage done. And some, but not all, of the most egregious components of this section have been repealed. Specifically, the removal of the intrusive and medically unjustifiable requirement for ultrasound tests, and also by adding language which acknowledged the possibility of fatal fetal abnormalities. Today, you will hear in bills before us some other efforts to try to erase more of the language that never should have become law. I'm not interested in a change here and a change there. In this case, what I'm looking forward to is tabula rasa, a blank slate that would then make it possible for us to construct new language following an appropriate legislative process to accomplish what an overwhelming percentage of voters support, as indicated by their actions across the country in states that are thought of as red and states that are thought of as blue. The right of people to decide for themselves how to control their own bodies. I've had 2 children, and I've had my time in an obstetrician's office. Never have I been in an office big enough to accommodate the patient, the doctor, and 424 legislators. We legislators have no business practicing medicine. We are trained in many fields, but we are not trained as medical professionals. We are not subject to censuring if we violate medical procedure. We are not trained or equipped to take the place of those with determining appropriate medical behavior and enforcing those regulations administratively and judicially. Medical professionals are under the supervision of people who know how that should be conducted. When I was first elected in 1996, I was asked why would I want to join a legislature that had not had a Democratic majority in the history of time, or at least modern time. My answer was that I believed not in the Democratic platform or the Republican platform, but in the concepts of the libertarian that had long been the force that governed the state of New Hampshire, a classic libertarian philosophy that respected the right of the individual to live free of unnecessary government intrusion and respected the principles of civil rights and civil liberties. The corruption of House Bill 2 in 2021 violated that tradition, and we have a chance with this bill to erase the blight that exists because of the inappropriate action of this legislature. I hope you will consider supporting this bill, which tries to undo something that should never have been done in the first place. And I thank you very much.
Thank you, Representative Smith. Questions for the sponsor? Representative Greason.
Thank you, Mr. Chair, and thank you, Representative. How are you this morning?
I'm happy to see you, Representative.
Oh, goody. Given the level of misunderstanding regarding the provisions of the Fetal Life Protection Act, before we vote to repeal it or not, I thought it would be beneficial if everyone knew what the actual law says. So would you please explain what the law actually says, including any provisions in the law that might prevent someone from inadvertently running afoul of the law?
That's a very good question, and what I should have done is to have the text with me. Perhaps someone else does. But I can tell you that one of the most egregious remaining sections is that which basically permits anyone to bring, like a vigilante squad, to bring charges against medical professionals that can result in felony convictions and fines and obviously loss of license. That is something that is absolutely appropriate to be done by medical professionals who are violating the law and violating the ethics of being a medical professional. I have no problem with that. My problem is that that should happen in a due process, logical way, a way that we have constructed over the years. And for medical professionals, they cannot get a license unless they pass certain tests, training, whatever. They have to periodically get new training, not training provided by the legislature, but by medical professionals. If there is a complaint to be made, there is a body against which that claim can be presented of medical professionals who can say, yes, this is a perfectly appropriate act under the circumstances, or no, it isn't. And yes, this medical professional should be punished, I'll use that loosely, in some way. It might be to have more training. It might be to go through a period of supervision. It might be to lose the license. All of that is perfectly appropriate, as long as that is performed by the people who should do that. And that is the people whose job is to make sure that doctors do what they should do, just as we have people who make sure that lawyers do what they should do, or that contractors do what they should do, not 424 legislators who wanted to make a political issue out of something that is not a political issue, that has to do with personal individual rights.
Mr. Chair, if I may follow up, please, because I don't think I got a complete answer on that. Is that the only thing that this law, the Fetal Life Protection Act, does, is penalize doctors for performing an abortion? Or are there other provisions?
Well, there have been other provisions. Is former Representative Welper still here? Representative Welper and I served together on the Judiciary Committee. And I was chair, and I asked Representative Welper to be my clerk. There's never been a better clerk. Maybe in the future there's going to be, but in the past there never was a better clerk. Representative Welper and I could not disagree more on this issue. But last term, we came together, and the two of us helped to bring a bill through the House and then the Senate that dealt with the inappropriate use of ultrasound tests. Subsequent to that conversation, the Senate, on the basis of superb testimony by people from across the state, agreed that there was the concept of fetal abnormality and that there should not be a denial of the right for someone to end a pregnancy. So those are two changes. There is another change remaining, and I'm actually not sure how I feel about it, but I think, to be honest, I must acknowledge it to you, and that is the restriction of 24 weeks. I'm not sure that is I'm not sure that it's an inappropriate specification, and I say that for a number of reasons. There's virtually no doctor in this state who would perform an abortion even as late as 24 weeks unless there was another overriding reason, such as a fetal abnormality, the life of the mother. So on that sense, I'm not so sure it's disastrous, but on the principle of having this in House Bill 2, that's where I have problems. It did not belong. It shouldn't have come in that way. And if, in its wisdom, the legislature constructed a new, that's fine, but they ought to do it the right way. You have a bill, you bring it to a policy committee, the policy committee debates it. There are procedures, there are processes, and we go through it that way. I think, Representative, that covers all of the components, but if you know of something else that I haven't mentioned, I hope you'll remind me.
I most certainly will.
Thank you.
Other questions for this witness? Yes. I'm sorry. Oh, yes, I'm sorry, Representative Andrews.
Thank you, Mr. Chair. Just one question. Has any parts of this bill ever been challenged in court?
Any parts of this bill been challenged in court? I'm drawing a blank right now, Representative, and I hope that you could ask that question of people who have much more knowledge than I do.
Other questions for this witness? Representative Greason. Oh, I'm sorry. Who?
Representative Perez had a
Oh,
question.
Representative Perez. Yes, please.
You use the term vigilante with doctors. So under this bill, then later you mentioned that doctors could refuse to perform these abortions. I'm confused by that. What would these vigilantes be doing to these doctors? Would it be if they did not perform the abortion, or if there was some type of something that happened at the abortion, or if they performed an abortion at 30 weeks? I don't understand where the doctors would be prosecuted. Thank you.
Thank you very much. for asking the question. You know, we always say that, and we don't necessarily mean it, but we always say thank you for asking the question. Sometimes we just assume you didn't ask the question, but it's a fine question. I don't believe I ever said anything about a doctor refusing to perform an abortion. What I did indicate that is under current medical practice in this state, doctors who who specialize in certain areas, including, by the way, obstetrics and gynecology, do not necessarily have the equipment or the experience to do the very, very rare act of performing an abortion later in pregnancy. So it's not a question of refusing, it's a question of a doctor understanding exactly what his or her training has prepared him or her to do, and making sure that anyone who is going to perform a medical procedure has the necessary training and experience. That can happen, for example, in a state like Massachusetts, where at the large hospitals, pregnancies that have gone on and are running into terrible trouble, that's where people go. In terms of my use of the word vigilante, it was right for you to pick up on that word. It's not a polite word, and it's not a word that I would ordinarily use. But I'm using it in this sense because it is someone who is not directly involved in the situation. In other words, not the pregnant person, not anyone else the pregnant person chooses to involve, whether it's a partner or a parent or a religious consultant, and of course the doctor, but someone who was not involved, who chooses to come in and determine that what had happened was not appropriate. And it is that person who, in the relevant section in House Bill 2, is given this authority. And I think that although the word is not a polite word, the closest parallel that I could come up with is vigilante.
Other questions for this witness? Representative Greason.
Thank you, Mr. Chair. The current law says that there are no restrictions whatsoever on abortions for the first 24 weeks. And then a woman may obtain an abortion after 24 weeks under certain conditions: rape, incest, fatal fetal anomalies, and health of the woman. There are no provisions in the law to even determine whether or not the baby's at 24 weeks, or, as by your own statement, that the ultrasound provision has been stripped out. So that is actually not part of the law. So there's no provisions at all regarding that. So given that, is it not true that abortions performed after the first trimester are in fact of significantly greater risk to the woman herself? So this Fetal Life Protection Act is actually also a pregnant woman's life protection act.
Well, first of all, Representative, as I say, I don't have the full text in front of me, but I beg to differ with you. I don't think that all of the exceptions that you noted are in fact in that legislation. I could be wrong, and therefore I ask you to let someone who follows me, who has direct access to that text, to say what's accurate. I have no problem at all claiming a vagueness in that. Second, my point in all of this, with all due respect, is that I don't think that you or I, whether as a man or as a woman, as someone who is pro-choice or in whatever that means, and I don't think any of us have the right to decide for someone else how to control their own lives. I don't need the government to decide that the way to protect a woman who is who has the possibility of getting pregnant should be determined by the government. I think that the woman should know And I say woman, and we understand that as we come to better understand gender and sex issues, that might not be the exactly right word, but you know, I've been using that word for a long time, so it's hard to change. Um, the government has no right to be making this determination. I think at the moment that a pregnancy has developed to the stage where, in fact, the embryo, the fetus, has left the woman's body and is able to function on its own outside of the woman's body, at that point, the state, I believe, has an interest. And I would hope they would do what happens in almost every other industrialized state, and some states that aren't, that the state has a program to, for example, have people immediately go to the home and say, how are you doing? Can we help you? Do you need some help with how to nurse? Do you need, you know, oh, I see the toddlers wandering around. Could I prepare a peanut butter and jelly sandwich for them? All of those kinds of supports are a way for the state to send a message to a family where there's a newborn that the state cares, the public cares about you and your family, and we're going to do everything that we can to help. That's at the point that the fetus is independent physically of the pregnant person. And up until then, when the fetus cannot survive on its own, it is, to me, not yet in a state where the government has an interest.
Other questions for this witness? Seeing none, thank you very much.
Thank you for your courtesy.
Next, I'm going to call on former Senator Tom Sherman.
Thank you, Mr. Chair, members of the committee. For the record, my name is Tom Sherman. I am from Rye, New Hampshire. I'm representing myself. I'm a former state rep, state senator, and actually physician as well. As a practicing physician and a New Hampshire state senator, I spoke against and voted against the first abortion ban in our state's modern history, which circumvented the standard legislative route for passage of policy by being attached to the last budget bill signed into law by Governor Sununu. Today, I'm speaking in support of HB 271, which would repeal that ban. The abortion ban from its outset was a solution in search of a problem that actually put the health of both the pregnant woman and the fetus at increased risk. Elective abortions are not performed in New Hampshire. I'm sorry, elective late-term abortions are not performed in the state of New Hampshire, period. On the other hand, there was ample testimony raising concerns about the ability of the medical community to respond to situations in the third trimester threatening the health of the mother or the fetus, for which there were no appropriate exceptions in that bill, which increased the risk for both the mother and the fetus. We actually do have the capacity to provide state-of-the-art maternal fetal medicine subspecialty care in the state of New Hampshire, and our teams have been recognized as being among the finest in the country, both at Dartmouth and at the Elliott. But these teams, under this bill that was signed into law by the governor, actually puts these providers at risk of facing criminal and civil penalties. Providers of these services at Dartmouth Health have expressed concerns that this would actually put their patients, that's the pregnant women, their lives at risk. Under this ban, a woman facing a tragic complication of her pregnancy actually has to wait with her medical team for appropriate care until they and possibly their attorney believes that her life is threatened. The exception in the bill, to answer one of your questions, is for the life of the mother. There is no exception for the health of the mother. As a doctor, I recognize that this delay of care actually increases the mother's risk of death. They also reported that the threat of these penalties have had a chilling effect on the specialty practice of appropriate high-risk care known as maternal fetal medicine. Their practice has been recognized nationally for their excellence and regionally as an essential component of all obstetric care. That means every level of OBGYN care in the eastern half of Vermont and in the northern and western half of Maine, in addition to New Hampshire. That's the referral base for Dartmouth Health. The ban's provisions for felony prosecution in the state of New Hampshire for the appropriate practice of medicine is a real threat to the ability to recruit and retain these specialized providers, and as a result, to the continued ability of Dartmouth Health and the Elliott Hospital to provide these services, not just in New Hampshire, but across the region. And remember, there is no exception in this ban for rape and incest. I join the vast majority of Granite Staters who recognize abortion as an essential component of health care. As such, deciding whether or not to proceed with an abortion is an intensely private and personal process between the pregnant patient and their doctor or nurse practitioner. Leaving this decision in those capable hands by passing HB 271, you will restore not only the freedom of all Granite Staters to make their own health care choices, but also the ability of our own highly specialized providers to actually protect the health and life of both the mother and the viable fetus, both in the individual clinical situations and also in order to ensure the viability of our maternal fetal medicine programs in New Hampshire. This bill that was run through the budget was a mistake. We keep spending your valuable time trying to repair the damage, correct the mistakes, and oddly enough, in a bill that was brought forward to protect the life of the fetus, to actually turn around and change that bill over and over again to protect the life of the mother and the fetus. That bill, that ban needs to be repealed. And as Representative Smith said, you need to start over. If you believe there should be a ban, make it one that does not threaten the lives of pregnant women, the lives of their fetuses, and the viability of some of the top programs in maternal fetal medicine in the country. Thank you. I'm happy to take any questions.
Questions for this witness? Yes. Excuse me. Go ahead. I'm sorry.
The way the law is written in New Hampshire, would this be an accurate assessment? I'm not sure if it is or not, and maybe you can answer this, maybe you can't. If, say, after 24 weeks, I, as a pregnant woman, went to another state that would take care of the abortion, say it was in a case of an in vitro, like there was multiple births and you had to downsize and there wasn't the ability to do it here in this state. I went to the other state, had the downsize of the one child, came back, that was life-threatening to the other baby or myself. If I came back to this state, would I be prosecuted as a mother, as a woman, for having that baby taken.
So if I have the question, if you were facing, for example, a threat to your health,
Yes.
not your life yet, so something like preeclampsia in the third trimester, and you know that that could get worse and that it's progressing, but the attorneys at your hospital, along with the team of doctors, can't definitively say that it is life-threatening, which is the exception in New Hampshire. If you go to another state to get the care that you believe you need, I think that's, I actually don't know if you could be prosecuted if you came back into the state, but since the physician who performed that, or the provider who performed that, is out of state, then they could not be prosecuted that I know of. In other words, the law that's there now, actually the felony conviction is of the provider.
Other questions for this witness? Yes, Representative Andrews.
Thank you, Mr. Chair, and thank you, Mr. Sherman, for taking my question. Do you know if the current abortion law has been or is currently challenged in any court?
I don't know of any challenge.
Other questions for this witness? Seeing none, thank you very much, sir.
Oh, there's one more.
Oh, I'm sorry. Whoop. Representative Perez, sorry.
Thank you. What is your practice?
I'm your favorite kind of doctor, so I hope you all are up to date on your colonoscopies. I'm a gastroenterologist. It's good for your health.
I have another question, if I may. So if we repeal this law, we would go back to no law.
Correct.
And that would mean that anyone in the state of New Hampshire could have an abortion at any time for any reason, with no limitation, up to birth. And do you not see the concern about the life of the mother at that point? I worked in a recovery room, and I actually took care of mothers. In late-term abortions, it was very similar, and I'm not saying it's the same, but very similar to post-C-section care and delivery. And did you feel that going back to no law is the way to protect women here in New Hampshire?
Well, first of all, that's not what I said. So we have lived with the protections of Roe versus Wade since the early 1970s. Prior to that, if you talk to some of the OBGYNs who are still around from prior to that, they saw the complications of illegal abortions, many of which the women died of sepsis, they died of hemorrhage. But what we've seen since the early 70s is we don't see what you've described in the state of New Hampshire. It's not a thing. There are not providers in the state of New Hampshire licensed by the Board of Medicine who perform elective late-term abortions. And I said that early in my testimony. So I'm not sure where you were practicing, but in New Hampshire, it is such a high-risk procedure. It would be like me going and doing routine colonoscopies on 90-plus-year-olds. We don't do that. It's not a thing. So that is, we have lived without an abortion ban in the live free or die state for decades, and we have not seen what you're describing.
Representative Perez, follow-up.
I was saying I should have said when the life of the mother was in jeopardy, and it was here in New Hampshire. And my question to you is, without any law, where did mothers who wanted late-term abortions go to have their abortions? If you said they were not being done here in New Hampshire, or were they done illegally? My concern is if we eliminate this completely, are we going back to kitchen table abortions for people who want them?
No, we're actually going back to the way we were 2 years ago in New Hampshire. Before January 1st, 2022, for the last 30 years, that's where we're going, or maybe 40 years. I can't do the higher math. That's where we're going. Doctors in New Hampshire don't perform elective late-term abortions. They do very rarely do the necessary and appropriate medical procedure to save the life or to preserve the health of the mother. That's where we were before January 1st, 2022. And if they wanted an elective abortion, my understanding is that there are only a few places in the entire country, and there are none in New Hampshire where you can go for an elective third trimester abortion.
Representative Stapleton.
My question is that, do we have any statistics that indicate whether this bill has resulted in physicians being deterred or otherwise attracted to New Hampshire because of this bill, in either case?
Well, I would ask a question and a response. As a physician, so maybe it's a little rhetorical. If I had a choice of going to Vermont to practice gastroenterology, and I could do it freely using standard of practice and the Board of Medicine as my guide, or come to New Hampshire where doing everything appropriate in the practice of my medicine, I could end up with a jail term of 7 years and a $100,000 fine, loss of my career, and all the other things that go along with not even just a felony conviction, but a felony charge. Where do you think I would practice? They have 3 providers right now approaching retirement in the 7-physician maternal fetal medicine program at Dartmouth Hitchcock. I would never come to New Hampshire under the threat that this ban presents. That's my own personal opinion as a physician.
I thank you for relating that, but my question was, do we have statistics that show that this bill has resulted in physicians being deterred from coming to New Hampshire to practice?
I guess the answer, I don't know of any felony charges having been brought yet, but I can guarantee you that the threat alone, which is supposed to be a deterrent, right? It's not just a deterrent for doing inappropriate medical care in the 3rd trimester. It's a deterrent for doing appropriate medical care. And it's a deterrent from any of us thinking about New Hampshire as a good place to set up an OBGYN practice.
Representative Tur, I believe you had a question?
Yeah, thank you, Mr. Chairman, and thank you, Dr. Sherman.
You bet.
I guess my question is, in the absence of this and across medical care in general as a physician, the conduct of providers is governed by a range of other strictures from the Hippocratic Oath from the beginning to standards of care in the various professions, and then also within each organization and maybe beyond the medical ethics boards that I presume would potentially have an interest in a case like this if it were to be presented. Could you say a little bit more about how these parameters sort of work and have worked in the past.
Sure.
And I guess, well, let me leave it there, actually.
So I've practiced in multiple states, and it's slightly different from state to state, but the governing principle in healthcare is, the oath, the Hippocratic Oath, our training, and then following standards of practice. And standard of practice is pretty well delineated for each of our specialties for how we practice. Deviations from that, especially where they end up causing harm, are brought before the Board of Medicine. If they cause a death or if there's that level, it can even go as far as being criminally investigated. So there's already a mechanism, as Representative Smith was talking about, there's already a mechanism for what happens when you practice inappropriate care. That can be inappropriate prescribing. It can be a procedure that you're not doing appropriately. And in every state, there is that mechanism. I believe that that mechanism has, for the most part, it's not perfect, but none of these systems are perfect, whether you're a lawyer or a doctor or a businessman or any profession. But it really is geared toward the protection of the patient and the life of the patient and the well-being of the patient.
Representative Kutab, did you have a question? All right. Any other questions for this witness? Seeing none, thank you very much.
Thank you. Good to see you all.
Representative Janine Notter, please. Oh, yeah, and I'm going to call on former Representative Kurt Wolpert next.
Good afternoon, Mr. Chairman and members of the committee. Hillsborough 12th, is what I represent. I was on Judiciary last term, and we all got along very well, even though we don't agree on this issue, and we never will, no matter what we say to each other. So 2.5 years ago, when I knocked on doors and we talked about abortion, most of the people that I talked to would say by the 3rd trimester, oh yeah, by then that's too late. So we only passed late-term abortion. This time around, this campaign season, I couldn't believe how many people think that we banned abortion or all 9 months. Either these people were lied to or they're just completely misinformed. I don't know where they got their information from, but it's only the 3rd trimester when the child can survive outside the womb. If it's so rare, then why repeal it? I remember sitting on this committee and asking an abortionist, well, how often do you have late-term abortions? And she said, oh, it's very, very rare. And I'm like, well, how do you know? I've sponsored the statistics bill. We don't have any statistics in New Hampshire. We don't know who's doing abortions, how many, even we couldn't even get past it as aggregated statistics, by county, so that to protect, if somebody has one, you don't want to find out in a small town. So I'm losing my train of thought here, but I also wanted to mention a woman named Gianna Jensen. Maybe you've heard of her. She's one of the leading pro-life activists in the country. In the 1970s, her mother underwent a saline abortion, and Gianna survived. And it is only because the nurse working at the clinic called an ambulance that this woman went on to live. She has cerebral palsy and she has some other issues from the saline that burned her. But I first met her, I talked to her on the phone when she was a young teenager, and I interviewed her. I had to get through her mother first on the phone. It was very difficult. I had to convince her that I was a friendly and not someone was going to be mean to her. And then I met her here in New Hampshire. I think it was in Manchester, and I interviewed her again. We talked about rape and incest. There's a woman in New Hampshire who's written a book. She's also been very outspoken. Her name is Darlene Pollock. Her mother was raped. She's the product of that crime. She herself was raped. Her daughter is a product of that crime. But she knew that killing the baby wasn't going to make what happened to her go away. And the last thing I want to say is we had a former representative, I don't know how many terms ago it was, but he stood at the well and said, in the case of rape, if someone has to die, why not kill the rapist? Thank you.
Questions for this witness? Representative Horgan.
Thank you. I just have a,
Oh, sorry, did you have a question?
yes.
Oh, okay.
Actually, I have a process question, which, what? Oh, he's not taking it.
Oh, no, she doesn't want to take any
Oh,
questions.
I understand, yeah.
All right,
I can leave.
Representative Kurt Wolper.
I'll wait for the exec session to bring up.
All right.
what I-
Thank you, Mr. Chairman. For the record again, my name is Kurt Welper. I live in Stratford, and I'm here speaking for myself. And I
You
want
need
to
to get a little
confine
closer to
myself,
the microphone.
I'll confine myself to the process of passing the Fetal Life Protection Act, because what I've heard here just makes my ears burn. House Bill 625 came to the Judiciary Committee. It had a public hearing. It was voted inexpedient to legislate to the House floor. That vote was overturned by a vote of 192 to 161. It was moved ought to pass. That vote succeeded on a vote of 191 to 160. Oh, I get that backwards. The overturn was 162 to 190. So we overturned the committee recommendation of inexpedient, and we voted, the House voted it ought to pass 191 to 160. It went to the Senate. The Senate had a hearing. And then things become murky, because it never got under the heading of House Bill 625. It never got a hearing in a vote in the Senate. What it did get was amended to move it into part of HB 2. That amendment was thoroughly debated on the Senate floor. So just to be clear, the House Bill 625 had full procedures in the House and in the Senate. And then HB 2 went to the House. It went through Committee of Conference with the Senate, and it was voted ought to pass by both bodies. So I think that's 6 votes of the House and Senate to approve House Bill 625 or the Fetal Life Protection Act in these walls. That's the full Monty, they call it, right? And it went to the governor, and he did sign it, and he did not approve of it. But he signed HB 2 anyway, and we'll leave that with that. And ever since, he's been trying to get it modified. The other thing, I've been a lot of discussion about the actual construction of the bill, and you're going to hear more about that later. The only thing I want to say is that when House Bill 2 passed, House Bill 625 passed, the constitutional order was that any abortion ban had to be later in the pregnancy at a viability standard, which 24 weeks met, and it had to have 2 exceptions: for the life of the mother and for the health of the mother. Both were included in House Bill 625. Thank you.
Questions for this witness? Representative Horgan.
Thank you, and this gives me a chance to ask what I wanted to ask the previous member, and you gave a pretty good explanation of the legislative history of it. And the governor gave a budget address yesterday, just like he did 2 years ago, and 2 years ago, this was not in his initial budget proposal, but then it goes to the House and Senate. It's a very lengthy process, and lots of things creep into the budget trailer bill. But so is the governor totally powerless while the House and Senate are working on it, or does he have some influence either publicly and or behind the scenes over what is or is not included in the final product that is then sent to his desk in June?
Yes.
Thank you. Yes. So,
All right. Next question. Is there any other questions? Thank you very much. I'm next going to call on Kayla Montgomery, please.
Good afternoon, members of the House Judiciary Committee. My name is Kayla Montgomery. I am the Vice President of Public Affairs for Planned Parenthood of Northern New England and Planned Parenthood New Hampshire Action Fund, and we support this bill before you, House Bill 271. So 3 points for you today about why New Hampshire's abortion ban should be repealed in its entirety. First, the current law has an exception to abortion after 24 weeks in the case of a fatal fetal diagnosis. And that critical exception was added to this body just last year. Now, some lawmakers have questioned why someone would need an abortion later in pregnancy if not for a fatal fetal diagnosis. And to be perfectly clear, no one wakes up at 8 or 9 months pregnant and just decides they no longer want to be pregnant. That doesn't happen. But the fact is that every pregnancy is different, and that our bodies don't always follow black and white laws. And that is why blanket abortion bans don't work. Carving out exceptions also creates a legal gray area, and we know this because with Roe gone, we are hearing of more sexual assault victims, including children, who are denied abortion care at all stages of pregnancy. And prior to Roe falling, these absolutely horrific examples, like the 10-year-old in Ohio last year, would have remained under the radar because these survivors would have been able to get care in their home state. And these stories, they're heartbreaking and they're cruel, but they're an awful reality. And we should not have to hear firsthand from these patients to understand that this happens. We should instead have compassion and respect and allow doctors to help their patients make these incredibly complicated decisions. And second, the current abortion restrictions impact our healthcare landscape at a time when chaos and confusion around the full range of reproductive health and rights reign because of the overturning of Roe v. Wade. The current law criminalizes our providers who are exercising their best medical judgment. I think we can all agree that New Hampshire is home to world-class doctors and hospitals who are highly trained and experienced in their fields. So should our state be sending its citizens in these complex medical situations out of state to get the care that New Hampshire doctors are trained to deliver? And finally, the state of New Hampshire has a long bipartisan history of supporting privacy around reproductive health. It was a New Hampshire Republican-led legislature that repealed 3 pre-Roe laws 25 years ago. And it was a New Hampshire Republican-led legislature that was the first in the nation to urge the FDA to approve medication abortion back in 1991, citing, quote, "The issue is freedom of choice in medical treatment," unquote. The state of New Hampshire has a proud history of trusting doctors and women and families in these complex decisions to do what's best for them. The state government should not be reaching into these decisions. People must have the freedom and privacy to make their decisions about their pregnancy in consultation with their doctors. So we urge a vote of ought to pass on 271 and trust women and doctors to make these private decisions without government interference.
Questions for this witness? Representative Perez.
Thank you. I have 3 very quick questions.
Sure.
Prior to Roe versus Wade, up to what gestation does Planned Parenthood perform abortions? After Roe versus Wade, up to what gestation does Planned Parenthood now perform abortions? And do you know of any abortions being denied to any of the Planned Parenthood clients since this abortion?
Thank you for the question. So
Abortion after 24 weeks is out of the scope of Planned Parenthood practice. To be perfectly clear, that is care that happens in a hospital setting. That's care in New Hampshire that would happen at places like Dartmouth or the Elliott. It does not happen at Planned Parenthood. So, as a representative of Planned Parenthood, it is not within our scope of work. Planned Parenthood in New Hampshire, we have 4 sites in New Hampshire. 2 perform abortion, 2 do not. Manchester performs both medication abortion and in-health center abortion up to 15.6 weeks. In Manchester, it's 15 weeks, 6 days. And in Keene, it's medication abortion only, which is up to 11 weeks. Now that's at Planned Parenthood in New Hampshire. Planned Parenthood of Northern New England is the affiliate, and that is Maine, Vermont, and New Hampshire. In Vermont and Maine, the health centers go a little bit later gestation, but in Manchester, that's where it is. That was the case before Roe fell, and that is also the case now. That didn't change with Roe falling.
Right.
And I'm sorry, I forgot your third question.
Representative Stapleton, I think you had a question.
Thank you, Mr. Chair. Thank you for taking my question. In the case of rape victims, including children abused, why would we wait until the 3rd trimester to resolve or answer that issue, thereby creating a greater risk for the women involved?
Yeah, thank you for that question. And there's no easy answer here because this is complicated. Anyone who is a victim of sexual assault is dealing with a tremendous amount of barriers. Barriers including maybe not knowing that they're pregnant, not sure how to get the care they need, not sure where to get the care, not be able to afford it. There's many, many different reasons. That is true for any victim or any survivor of sexual assault. But when you add the fact that there's potentially minors in this situation, and we know that there are minors who are in these situations, these barriers become overwhelming. How can we expect a child to navigate the healthcare system? So unfortunately, the reality is that sometimes people can't get the care that they want when they know it. Sometimes it takes them longer because of these barriers. And that's true. That was true before Roe falling, and that's especially true now when half of our country is experiencing these abortion bans.
Thank you.
Representative Manners.
Thank you, Mr. Chair. Ms. Montgomery, we heard conflicting testimony about the exceptions in the Fetal Life Protection Act, and I was wondering if you would clarify your understanding of what the exceptions are. Thank you.
Certainly. So RSA 329:44 is the RSA. You can look that up. So the exceptions, as it is now, as the law is currently today, there's an exception for maternal life, and there's a very narrow exception for physical health as well. And then, of course, there's the fatal fetal diagnosis, which was added last year. And those are the exceptions. And that's it.
So am I correct that as you just said, there is an exception for the health of the mother, even if it's not a threat to the life of the mother? It has to be a significant threat to the health, but there is a health exception in the current law.
There is a life exception, and there is a very narrow physical health exception, which lists some things. But I think it's important to remember when it comes to exceptions is that there's a lot of legal gray areas because counsel at one hospital might view it differently than counsel at another hospital. And these are, of course, moments, when you're dealing with these moments, minutes count. And so that's why there's a tremendous amount of gray area. And that's why just removing that barrier altogether would be a better approach.
Right. Other questions for this witness? Yes, Representative Greason.
Thank you, Mr. Chair, and thank you for taking our questions. You said that at the Manchester clinic where they perform actual physical abortions, you go out to 15 weeks and 6 days.
Correct.
How do you determine that it's 15 weeks and 6 days versus 16 full weeks? How do you actually know the gestation of the baby?
Certainly. So there's lots of different ways, and there's we offer patient-centered care, so every situation is going to be very different. Medication abortion, which I said is offered up to 11 weeks here here at our health centers in New Hampshire. If someone comes in and they know exactly the date of their last period, they are low risk. Maybe they know that they're 8 weeks, then they can have their medication abortion. If someone's not sure the date of their last period, that's generally the biggest factor in not having the date for your pregnancy, then you could do an ultrasound to figure that out. But every situation is going to be different. Every pregnancy is going to be different, and we're going to work with each patient to decide what's best for their care.
Other questions for this witness? Seeing none, thank you.
Thank you.
I'm next going to call on Bob Dunn. Oh, I'm sorry. I'm going to call on Representative Sellers. I got out of order, and Bob Dunn will be next. And I'm going to ask everyone, please. It's now 12:30. We're supposed to start the hearing on the third bill in half an hour. No one has had lunch yet, so I'm going to ask you to please keep your remarks to 3 minutes, and I'm going to enforce that, okay? Thank you.
Thank you, Mr. Chair and committee members. I will only take less than a minute, I hope. I want to just state a couple things. I actually agree with Representative Smith. I don't think anything should be stuffed into a budget, and even though there's a process for reviewing and triple checking it, your yays are yays and nays are nays, and let's move forward and let the governor actually sign it or not sign it. All right. However, now on the next thing is Honorable Sherman. He mentioned something about there are no abortions actually after 24 weeks or that point on. I'm saying we don't track abortions. We don't even know how many we do in the state. So how does he know, and how do we know that? Does any of you have any numbers on how many abortions we do? I've seen guesstimates of 2,200 a year, and I probably think they're taking that because of the other states that allow abortions and number of people in our state. They're just guesstimating that we do 2,200 a year. So therefore, I do want to make sure, because I didn't say it on the last one, I oppose this bill. All right, I think right now it's in place and it's working, and we should move forward. And I also oppose the last bill. Thank you.
Thank you. Questions for this witness? Seeing none, Bob Dunn. And the next person up will be Danielle Pimentel. Mr. Dunn.
Thank you, Mr. Chair and members of the committee. I'm going to keep this very short. I've got written testimony. I'll defer to what I said earlier, except, and I'm Bob Dunn, the Public Policy Director for the Roman Catholic Diocese of Manchester, representing Bishop Peter Labashi in the diocese. And I'm going to quote from Roe v. Wade. This is what Roe said, and I think sometimes this is often forgotten. In Roe, the court recognized, and this is a quote, the state's important and legitimate interest in potential life, and the court determined that, again, quote, if the state is interested in protecting fetal life after viability, it may go so far as to proscribe abortion during that period, except when it is necessary to preserve the life or health of the mother. And so the law that's in place today is consistent with Roe. The law was, remember, enacted before Dobbs was ever decided. So it was consistent, I think, with the constitutional situation that was in place 2 years ago. And so the law that is in place today was consistent with what Roe allowed, and we think it would be inadvisable to go back to a situation where there was absolutely no limit, abortion for any reason up to birth. Thank you.
Thank you. Questions for Mr. Dunn? Seeing none, thank you. Ms. Pimentel, and then the next one up will be Allison Bedell. And I'm just, I direct this to the other members of the committee. Given the time, if some of you want to go have lunch, go right ahead. I'm going to stay, and maybe what I'll do is after the sort of first group of people who may decide to have lunch, do that. When you get back, I may ask someone to take over for me for a few minutes while I go have lunch. But please feel free to do that. And we'll hear next from Ms. Pimentel.
Thank you, Mr. Chairman and members of the committee. My name is Danielle Pimentel. It's a pleasure to speak with you again this morning. As I stated earlier, I serve as policy counsel at Americans United for Life, which is a national law and policy nonprofit organization with a specialization in abortion, end-of-life issues, and bioethics law. And I will try to be brief given the time constraints. I urge the committee today to oppose HB 271 because it removes necessary protections for the health and safety of pregnant women and unborn children and is inconsistent with New Hampshire's legitimate interest in protecting human life. If HB 271 is passed, abortion on demand up until birth will be allowed in New Hampshire, which will subject women to higher risks of health complications as well as maternal deaths. Only 6 states explicitly endorse abortion on demand, and New Hampshire should not become one of those states. It is well known that abortions carry a higher medical risk when done later in pregnancy, and 10% of women experience immediate complications from abortion that can be life-threatening. After 8 weeks gestation, the risk of death increases by 38% with each additional week. Because HB 271 would allow abortions on demand up until birth, more women will experience life-threatening complications from later-term abortions, which will likely also increase the number of maternal deaths. The women of New Hampshire deserve better than to be subjected to later-term abortion procedures that threaten their health and safety in that way. New Hampshire also has a legitimate interest in preventing fetal pain, as noted by the Supreme Court in the Dobbs decision. If the Fetal Life Protection Act is repealed and abortions are allowed up until birth, that will leave unborn children who can experience pain from abortion unprotected. Current medical science has firmly established the existence of pain in preborn infants on or before, or at least by 20 weeks gestation. So given the substantial evidence that preborn babies experience pain by at least 20 weeks gestation, if not earlier, it is well within New Hampshire's legitimate interest to oppose this bill in order to minimize fetal pain as much as possible. Lastly, I'll be brief in my last point. HB 27 would also get rid of the ultrasound requirement. The Fetal Life Protection Act requires that an ultrasound be performed if a woman is at 24 weeks gestation. And these are important protections because they enable a healthcare provider to accurately date the gestation of the baby, which protects the woman by ensuring the appropriate abortion procedure is performed. My last point is there are numerous states have enacted strong pro-life laws, after Roe v. Wade was overturned. There's at least 3 other states that maintain enforceable limit on abortion at 24 weeks. 18 states have protected life at conception, and 3 states protect life after a heartbeat has been detected. So by rejecting HB 271, New Hampshire will be joining numerous states to continue having laws that affirm life.
Thank you. Questions for this witness? Seeing none, Allison
Thank you.
Bodell, and the next witness will be Michelle Silly Foisey. Oh, that's fine. That's fine. All right. Yes, please.
Hi, my name is Allison Bodell, and I'm a resident of Hooksett, New Hampshire. And I'm here in support of little babies in the womb. I oppose the repeal of the Fetal Protection Act. I think if you knew more about fetuses and abortions, you would want to repeal it too. Let me explain what happens when abortion is done. I have to warn you that, and I think I gave you all a copy of this, so I'll kind of keep it kind of brief, but I have to warn you that it is very graphic. To perform an abortion, the mother is given anesthesia. The doctor then uses an instrument called a forceps, which are actually just big tweezers. They enter the womb, and they start pulling out pieces of the baby, the fetus. First, it's usually the feet because that's the position that the fetus is in at the time. At the time, the babies are in that position at the time. So they pull one leg, and then they pull the other, and then they pull the arms, and finally, when they get to the head, because it's not really a birth, that kind of a thing, the canal is very small. So they have to squish the head and break the head, and the brain comes sizzling out. It's, like I said, it's very graphic. So that's basically it. And I think she had talked about having pain, and I was wondering if you thought about if the fetus does feel pain. Well, has anyone ever heard of Dr. Ben Carlson? He is a pediatric neurosurgeon, and he specializes in preborn babies. For example, works on co-joined twins, also known as Siamese twins. He's discovered that fetuses do wince in pain when he would attempt to do their surgeries. All of his tiny patients after that would receive anesthesia for all their surgeries, just like their mother. So in closing, my hope is that you realize that fetuses are tiny living babies, not just masses of cells, and that we should repeal this act. Is there any questions?
Thank you. Questions for this witness? Seeing none, thank you very much. Michelle Foisey, and next will be Maura Casey. Great, thank you.
Good afternoon, Mr. Chair and House Judiciary Committee. My name is Michelle Silly Foisey. I live in Temple, and I am here today in support of HB 271, repealing the Fetal Life Protection Act. Before telling my daughter Kayla's abortion story at 22 weeks due to a fatal fetal anomaly to the New Hampshire House Judiciary Committee last February, I had never told our story in public. Over the last year, I have had the honor of meeting people from all over the state while advocating for reproductive rights. Through my own storytelling, I have in turn heard many stories of abortion. Stories of relief for their life and future ahead after having an abortion, stories of loss of dearly wanted pregnancies, and stories of self-love after enduring a horrifying sexual assault. On this journey, I have learned that Granite Staters overwhelmingly believe in and support legal and safe, accessible abortions for all. But New Hampshire's abortion ban puts politicians between patients and providers. 18 years ago, I sat with my husband in the perinatologist's office. We were devastated by the news we had just received. We learned that our second child, who we desperately wanted, had no chance of surviving outside of my body due to her fatal anomalies. Though my heart was crushed, I felt the most incredible compassion and empathy from our medical provider. Listening to him explain our options with the patience and understanding he exemplified with us on that day is something I will never forget. The relationship we developed in a very short amount of time was a bond I cannot describe and a trust that cannot be felt without living the experience itself. Without my provider's expertise, I firmly believe my life would not be as it is today as a mother of 6 living children. A medical provider that has the burden to share the horrible news that a wanted pregnancy will not have the outcome once dreamed of deserves compassion as well. All medical professionals enter the world of medicine with the desire to help others and, as their oath states, to do no harm. New Hampshire's abortion ban criminalizes doctors for doing their job and working with their patients to get the care they need, just as my doctor did on that fateful day. As a person who has had an abortion later in pregnancy, I understand the complexity of reproductive health care. Families in New Hampshire can face harrowing circumstances.
Ma'am, you're at the 3-minute mark, so can I ask you to finish up, please?
And may have to make difficult choices. Letting Kayla go from the body that was not able to sustain her life outside of mine was our way of setting her soul free. For me and my family, choosing abortion was a true act of love. Last year, the New Hampshire legislature took an important step to mitigate some of the harm caused by the state's abortion ban, adding an exception for fatal fetal diagnoses. However,
You're really kind of going over the limit now, ma'am. I really need to have you finish up, okay? Please.
Okay, I apologize. Studies show that survivors of rape, incest, and sexual assault can experience delayed decision-making due to trauma. HB 271 removes barriers to care for patients who need not to disclose their personal circumstances with an arbitrary time limit.
Granite staters know
No,
what's
no,
best.
no, I'm sorry, ma'am. You really are
Thank you
way
for
over.
your time.
Thank you. Are there questions to this witness? Seeing none, thank you. Next, I'm going to call on Maura Casey, and the next witness after that will be Peter Hogan. Ms. Casey.
Yes. Hi, my name is Maura Casey. I live in Manchester, New Hampshire, and I'm here in support of House Bill 271. Can you hear me okay?
Yes.
Okay. I never thought that I would be affected by the politics around abortion. Ron and I wanted a baby very badly and were thrilled when I finally got pregnant last year. Unfortunately, after the first trimester, our joy and excitement turned to shock and grief. Neither of us had heard of trisomy 18 before, but now I know that it is a rare, severe, and life-threatening genetic condition. Even though we hoped it wasn't true, both a blood test and an ultrasound confirmed the diagnosis. We had an incredibly hard decision to make. If I stayed pregnant, the most likely outcome was a stillbirth, which I honestly was terrified of. If my pregnancy was brought to term, the baby could die from heart and/or breathing problems during the birth. If by some miracle the baby was born alive, it would be a short and painful life, probably lasting only a few days. We would never want to put a baby through that. I also didn't want to put myself through the trauma of a stillbirth. On the other hand, I was worried about having an abortion. I was mostly scared the baby would feel pain. I was already attached to this baby and wanted to do right by it. I learned that the baby wouldn't feel anything and made sure that the remains would be handled respectfully. I learned that the baby wouldn't feel pain by medical providers, not the internet. Although I had so many confusing emotions going on, I'm completely confident that the decision to end the pregnancy was the humane one. After the surgery, it took time to process and grieve. Unfortunately, our ability to go through that process was derailed when we got the bill for $16,293, which later increased to $22,744. Prior to getting that bill, I hadn't even considered that it might not be covered by insurance. I tried to appeal based on the severity of the baby's diagnosis, but was again denied. I hope that sharing this story helps people understand that people have abortions for many reasons. Abortions can be incredibly sad, scary, and painful. Women need to feel safe when they're making these difficult and personal choices. Please consider that abortion isn't cruel. It can be a way to decrease suffering of fetuses, babies, and potential parents. Please consider passing HB 271. Thank you.
Questions for this witness? Yes, Representative Perez.
Excuse me, at how many weeks did you have your termination of your pregnancy?
It was 14.
14 weeks? And how would this bill that you would like to see go away have prevented that from happening?
I think that health insurance and politics are very closely intertwined. So I think that my health insurance likely was affected, my private health insurance was likely affected by the politics around abortion.
I'm sorry.
I think that politics and health insurance are intertwined in some ways. And I think that my health insurance made the decisions not to cover my treatment because of politics, political reasons. I don't know more than that. I'm not a politician, so I'm sorry, I'm not going to take any more questions. Thank you.
A follow-up, how would this bill have stopped you from having that abortion?
Right. All right. Other questions? All right, thank you. Peter Hogan, please. And next will be Omer Ahern.
My name is Peter Hogan. I'm a high school student in Sullivan County. House Bill 271 seeks to repeal the Fetal Life Protection Act, which restricts abortion after 24 weeks. If this act is repealed, it will allow a woman to have an abortion at any stage of her pregnancy. At 24 weeks, a human person is able to survive outside the womb. Their heart has already been beating for 18 to 19 weeks. By week 7 of the baby's development, the brain begins to take shape. By week 10 of their life, their eyelids, nostrils, and mouth have already begun to form. By week 15, the baby will be able to hear. These are just a handful of things that a person in the womb can do. The thought of repealing the Fetal Life Protection Act should be unthinkable. The restrictions that are now in place are not enough to protect a person in the womb, so to repeal them would only infringe upon the right to life of an unborn person even more. In 24 of the 50 states of our country, abortion is highly restricted. And out of those 24 states, half of them have outlawed abortion completely. There are only 10 states in which abortion is completely unrestricted or protected by the law. New Hampshire needs to defend the right of unborn humans, and the only way it can start is by upholding the Fetal Life Protection Act. Thank you.
Thank you. Questions for this witness? Seeing none, thank you, sir. Omer Ahern, and next is Laura L. Azam.
Thank you, Mr. Chairman. I ask the committee to oppose House Bill 271-FN. I reiterate my remarks from earlier this morning. I agree with the remarks of Representative Sellers and this young man right here. Again, I urge the committee to oppose House Bill 271-FN. Thank you, and I yield the remainder of my time.
Thank you. Questions for this witness? Seeing none, thank you, sir. Laura L. Azam, and next will be Phyllis Woods. Is Laura L. Azam. Is Miss L. Azam here? Do not see her, so I will call on Phyllis Woods next.
Thank you, Mr. Chair, members of the committee. I'm Phyllis Woods from Dover. I can recall being on that side of the committee as a former member of Judiciary, and Judge Lynn testifying on this side. So this is bringing back a lot of kind of memories for me. One of the memories that I'm having is what confusion some of the members might be having with the testimony that you're hearing. First, we're hearing that late-term abortions from 6 months on never happen, but yet we don't want to make them illegal. It may be the case that we are not doing late-term abortions here now, but if this law that protects late-term abortions is repealed, I submit that we may have an influx of people coming from other states wanting to have late-term abortions. Right now, we have unrestricted abortions up to 6 months. As you know, the repeal of this ban would make unrestricted abortions right up through the 9th month totally legal, which is out of the mainstream of what the people in this state, I believe, want. 43 states currently have restrictions on abortions at 6 months or even earlier. So we would be quite the exception. We would be joining perhaps 7 other countries in the whole world, including North Korea and China, who have absolutely no restrictions on abortion. As I looked to the committee when you were all here, I could ascertain that you would probably be quite evenly divided on this issue. But I would suggest that you will have common ground between you. And I think in 3 areas you will find a lot of common ground. Number one, I believe that you and I and all the members of the committee agree that choice is important. Being free to make our own decisions and our own choice is an American tradition. So we believe in choice. But I also believe that none of you believe in unrestricted choice. You have to think about this. Our responsibility as citizens and voters, and your responsibility as lawmakers, is to have laws in place that restrict choices that harm ourselves, our neighbors, and our culture. We don't have unrestricted choice. None of us would say it's your free choice, that incest is a free choice, or rape is a free choice, or murder, or any other things that activities that we
Ms. Wood,
restrict.
you're pushing up against your time. I wonder if I could ask you to sort of sum up, please.
Okay. First we have choice. The other thing that I think we all have in common is that we appreciate the sanctity of life. We do want and to value life. If any of us saw somebody at the side of the road that had been hit by a car, you would rush to help them. If you were on a suicide line, you would try to talk somebody out of committing suicide. If you saw somebody wanting to jump off the bridge, you would try to protect that life. The last thing that I think we have in common is that we all care about women. This law is not going to be something, if we have a late-term abortion, that's going to be in the best interest of women. No one wants to have a woman, and this is my final point, no one wants to have a woman give birth or to deliver a dead baby. That is not only not in the best interest of the unborn child, but it's certainly not in the best interest of women. So I implore you, please vote no on House Bill 271 so that we have some protections not only for the unborn, but for the women. And thank you for your time.
Thank you very much, Ms. Wood. Questions for this witness? Thank you very much. Next, I'm going to call on Mary Ann Cooper, and after that will be Sheila Marshall. Ms. Cooper.
Thank you, committee members. My friend Phyllis Woods worked so hard, and I appreciate your work that you do on this committee and all others. I do rise in opposition for 271. I worked very hard during the decision-making on the Fetal Life Protection Act. I wrote to the governor when I knew he was not really fired up about it, and I wrote to the representatives that worked so hard. I think we all know that if there are defects in the Fetal Life Protection Act as it is today, that will be worked on, you know, but please do not vote inexpedient to legislate on 271 FM. Thank you for being here.
Thank you. Questions for this witness?
Let you know.
Seeing none, thank you very much.
I just want to say, I'm Sheila Marshall. And
Yes.
That high school young man and that gentleman there have expressed everything that I would have said. I'm against this bill. So thank you very much.
Thank you. Any questions for this one? No. All right, thank you. So next, I'm going to call on Roy Dennehy, and after Mr. Dennehy will be Beth Guerra. I believe I've got that right. Mr. Dennehy.
Thank you for your time. I'll just make it quick. Roy Dennehy, I live in Windham, and I'm life director for the Knights of Columbus, and I represent approximately 7,000 brother knights here in New Hampshire, and I oppose House Bill 271 FN, and I will end by saying that this is a huge human rights issue here, in the human rights of the unborn child. And I've heard a lot of terms here today, but the term of the fetus is brought up many times. The fetus is a child, it's a human being, and we need to keep this bill intact in order to protect the unborn. Thank you so much.
Thank you, Mr. Dennehy. Questions for Mr. Dennehy? Seeing none, thank you. Beth Scarer, I hope I'm not mispronouncing that.
Scare.
Scare, I'm sorry, Ms. Scare. And next will be Karen Reed. Ms. Scare, go ahead.
Hi, thank you for taking my testimony. My name's Beth Scare, and I'm a mother from Nashua.
I'm here to speak in defense of New Hampshire's Fetal Life Protection Act, which protects healthy babies just a few weeks from being born, from being killed in an abortion. In my testimony, which is on your desks, I included a picture of an abortion at 23 weeks, a week before the Fetal Life Protection Act kicks in. So you can see the gruesome procedure here. And as another person testified, I included the steps of an abortion, a late-term abortion, which I won't repeat. And as you can see, this is a gruesome procedure. Who here on the committee, or who among any of those testifying in support of repealing the Fetal Life Protection Act could stand to watch such a bloody procedure? Medical professionals who perform these abortions have to harden their hearts to the inhumanity of what they are doing. Many workers who've left the field confess that they became suicidal after participating in these procedures. And despite what some of the other people said, it cannot be used to save a pregnant mother in the case of an urgent medical condition, because these abortions take multiple days to open up the cervix wide enough to extract the fetus. And because of the size of the baby, these procedures are dangerous to the mother's health. And I'm grateful to Dr. Sherman for pointing that out in his testimony. And also, he was very wrong when he said it didn't allow for the health of the mother. It allows currently for serious risk of substantial and irreversible impairment of a major bodily function. So a late-term abortion is just a very serious risk for the mother, and we need to protect the mom and the baby by keeping the Fetal Life Protection Act in place. And the reason that Planned Parenthood and the other abortion businesses are so determined to repeal it is because it draws attention to the inhumanity of abortion. It's the same reason that Planned Parenthood fought tooth and nail against the passage of New Hampshire's fetal homicide law, because both the fetal homicide law and the Fetal Life Protection Act demonstrate that the baby is human and deserving of protection. Please vote inexpedient to legislate on HB 271 to protect innocent babies from a gruesome death and their mothers from physical harm, and the abortion workers from the serious mental health repercussions of participating in these inhumane procedures. Thanks.
Questions for this witness? Seeing none, thank you very much, ma'am. Next is Karen Reed, and after that, Ian Ewing, please.
Thank you,
Ms.
Mr.
Reed.
Chairman and members of this committee. I'll keep this short. My name is Karen Reed. I'm a representative for Hillsborough District 27, Deering and Francistown, but I am here speaking on my own behalf today. I oppose House Bill 271 because as a nurse for 30 years, 30 years ago, I took an oath to do no harm. That rule has not only guided my professional practice, but how I live my life as well. I stand before you not to change your mind or convince you that I am right, or to, but more to give you something to think about tonight when you're alone with your own thoughts on the way home, or when you really have to do some soul searching. I have been present when life entered the world with all its energetic sparkle and excitement, and I've had the honor and privilege as well to be there as life left in its quiet release or in its abrupt and tragic end. It is easy to take a life that you cannot see and have no feelings for, but taking a life is a slippery slope. When society kills its children, what is the next logical step? The old and infirm? All you have to do is look at our neighbors to the north, Canada, who now practices MAID, medical assistance in dying. They're looking to expand that to anyone who seeks this service, young, old, or just down on their luck. Take a moment to Google Ezekiel Ram, Emmanuel Ram's brother. Ezekiel was the health advisor for President Obama. And he was a bioethicist who believed that in the name of social justice, that anyone under 14 or over 50 wasn't deserving of care, that healthcare rationing was something that was an option. If you have a moment, watch the movie The Giver or read the book. The movie had Kurt Russell and Katie Holmes. It was a story of a world where only the perfect got to live. Babies who were not perfect were disposed of, and everybody lived in their similar perfect commonness. So under that, insight, when you go home and look at your family album, your aunts, your uncles, your mother, your father, your grandparents, who is deserving to live? Who would have been not made it if abortion or healthcare rationing does become a reality? So I guess my point being today is to allow one segment of the population to be aborted. It's opening up to a society that doesn't value life in general, and we run the potential of becoming a country and a state that does not value life and becomes more of a culture that accepts death as a normal outcome. Thank you very much.
Thank you. Questions to this witness?
No questions.
Seeing none, thank you. Next, I'm going to call on Ian Hewitt, and after that will be Dick LaLuna. I hope I pronounced that correct. LaLune, sorry. All right, Mr. Hewitt.
Thank you, Mr. Chair, and thank you, representatives, for giving up your lunchtime to hear both sides of this issue. Ian Hewitt appearing for Cornerstone in opposition to House Bill 271. We appreciate that this bill is honest and consistent in what it represents, but it will surprise no one that Cornerstone opposes forthrightly legalizing abortion weeks or hours before birth for any or no reason. I wanted to make myself available to answer any legal questions about our law in New Hampshire, which, by the way, had full hearings in both houses of the legislature as a standalone bill and received majority votes in both houses as a standalone item before being signed by the governor. But I did want to first bring 2 points to your attention. I've heard a number of things today that were demonstrably false, but I don't expect I'll be able to answer all of them unless you all have a lot of questions. First of all, Massachusetts, until December of 2020, had a felony 6-month abortion prohibition, which had no exceptions for fatal fetal anomalies, and being a 6-month abortion prohibition, like most late-term abortion laws that have ever existed in the country, did not have an exception for rape. Most criticisms you'll hear of our law can be resolved with that fact alone. If our law is extreme for some undefined reason, was Massachusetts's law extreme before 2021? If our law is going to cause physicians to flee from New Hampshire, did that happen in Massachusetts in 2020? Of course, last year, the legislature added a fatal fetal anomalies exception to our law, which Massachusetts did not have before December of 2020. And so our law is now more moderate than a law that existed in the Commonwealth of Massachusetts less than 3 years ago. Secondly, as far as the views of the people of New Hampshire on this issue, poll after poll at this point has shown 60 to 65% of people in New Hampshire support some limits on abortion, including a majority of unregistered and independent voters, and depending on the poll, between a quarter and a third of Democratic voters. In fact, polls show that the more information is given to people being polled on what our law says, the more supportive people are of the law. A March 2022 poll found that when our law is accurately described as, quote, a prohibition at 6 months of pregnancy with exceptions for the mother's life and physical health, it does not have even majority opposition among Democratic voters, and 24% of New Hampshire Democrats support or strongly support it. Typically, what you'll hear people on the other side of this do is they'll say that a majority of people in New Hampshire think abortion should be legal in quote unquote all or most cases, but consistently when you look at those polls, whether it's Pew or American Values Atlas, you will see that what people have done is they have combined the plurality that supports moderate restrictions and nothing further with the minority that supports unlimited abortion up to birth, papering over this really unquantifiable moral gulf.
Mr. Hewitt, you're kind of,
most and all.
you're at your time. So if you want to, I'd ask you to sum up if you would, please.
Well, if you're giving me an additional sentence, Mr. Chair, I'll just say that when you hear that statistic, all or most, bear in mind that most people in that category are more aligned with this law than with those trying to repeal it. I would be happy to take any legal questions about the law or abortion law generally, if I may, Mr. Chair.
All right, thank you. Questions for this witness? Seeing none, thank you, Mr. Hewitt. Next, I'm going to call on Dick Laloon, and then next, after that, will be Representative Potenza.
Good afternoon. My name is Dick LeBlum from Derry, New Hampshire. First of all, I want to point out to everybody here, I'm here for self. I'm not here to point fingers at moms that might want to have an abortion, nor applaud women that want not to have an abortion. We're not here to judge. But I am here. My parents, by the way, had 13 kids, you know? And my aunt had 13 kids, so you guess you know where I stand on the issue. I oppose HB 271. This seeks the elimination of the recently passed Fetal Protection Act, recently passed by our aspiring presidential hopeful governor. It was signed by him. A bill that allowed abortion up to 24 weeks, and yet here to where we have some trying not only to eliminate and recall the 24-week Fetal Protection Act, but to allow abortion all the way up to birth. There were over 1 million abortions in our country last year. Can anyone here tell me how these abortions have anything to do with women's health? Or being pregnant these days is unhealthy and inconvenient to one's lifestyle? And why even when abortions are allowed up to 24 weeks, then it is necessary to try to repeal the 24 weeks. The bottom line, is it because the bottom line, like organizations such as Planned Parenthood profit much by every abortion and donate much to political entities that result in favorable legislation that help Planned Parenthood and other such organizations to blossom financially? No, I am not a radical Christian conservative. As you can see, I think I look normal, don't I? No response. And yes, I will always pray for my opponents to have a change of heart, always. Help and support parents in need. There are organizations, by the way, like Real Options in Manchester and Nashua, Birthright, Gianna's House. They help and advise pregnant women, hopefully to advise them in the direction of birth of their child. Almost done. As for me, I will always speak for the babies yet to be born. Hopefully, a voice for the voiceless, a voice for reason and love for the unborn babies. I have one final question for you to ponder. If you believe in God, that is, if you do, what side do you think he's on? Thank you, and God bless you all.
Thank you.
Thank you.
2 minutes and 58 seconds. That's pretty good. Pretty good. Questions for this witness? Thank you. All right, next I'm going to call on Representative Potenza, please. And the next witness after that will be Kathy Holmes. Representative Potenza.
Thank you, Chair. My name is Representative Kelly Potenza. I am in Stratford District 19, Rochester's wards 1 through 4 and 6. I had a couple different things prepared, but I'm just going to actually speak from my own personal experience in speaking with thousands of people actually in Rochester during my campaign. I knocked on every door. It didn't matter whether they had an R by their name or a D by their name. And I told people the truth. And I believe that this law that's currently in place, so that's I strongly oppose, of course, this repeal, is very minimal. We're just like Massachusetts. It's still extremely liberal. 1 month, 2 month, 3 month, 4 month, 5 month, 6 month, for any reason whatsoever. It's only in the 7th, 8th, and 9th month. And I told people the truth. And especially, I'm a pro-life person, and I told them that I was pro-life, but I spoke with pro-choice people, and I know I won their vote because I told them the truth about what the law was on the books. And there's been a lot of things here that have gone on during the campaign, and it was a lot of heated rhetoric. And nobody ever told people the truth about what the law was. And some of the people that I talked to that were adamantly pro-choice were like, wow, 6 months? And I turned their minds. I turned their hearts. And I think if we just focus on that, I don't understand why we are wanting to repeal something that is truly common sense. Also, I guess throughout this hearing, it has been repeated multiple times that this health exception is narrow. That's not the truth. Right now, the health exception that we have is exactly the same as the parental health notification law that has been on the books for 10 years. I repeat, it has been on the books for 10 years. So it is not narrow in the regards with the health exception. It's exactly the same as what we have now. That's pretty much my testimony. I know you guys have been hearing a lot, so if you have any questions.
Thank you very much. Questions for this witness? Seeing none, thank you. Kathy Holmes, and then Jason Hennessy next.
Thank you. I hope to keep this under 2 minutes. What is the driving force that's pushing later and later abortions? It's money. It's always money. The left has successfully muzzled Project Veritas, which exposed the industry of selling baby organs. The organs they get the most money for are the late-term ones. In the video, Planned Parenthood lady was advising, crush the head so that you don't damage the organs, they'll be more valuable. But the powers of the government, which are really people, they have caved, they've stifled the truth in the video and even confiscated stuff from his house. Now, my question is, how can the left be against slavery but in favor of selling baby parts? And if some of you could share my thoughts with the absent ones when you are debating, then I'll appreciate that. Thank you.
Thank you. Questions for this witness? Seeing none, thank you. Jason Hennessy, please.
Thank you, Mr. Chair. My name is Jason Hennessy. I'm the president for New Hampshire Right to Life, which is the largest dedicated pro-life organization in New Hampshire. And there's been a lot of amazing testimony. Just for the record, we're against HB 271 in case anybody was confused about that. I just wanted to relate this to a story that you've probably heard in the news that is probably disjoint in your minds. And that is the story of this baby that was born in a tent outside in December in Manchester. And what happened is that this baby was born outside in the freezing temperatures. And there's a lot of heart swell concern about this baby. The first responders got involved. They searched for this baby. After some hours, they found him. They brought him to the hospital, and thank God he was fine, as far as I know. But I want to ask you the question: if we pass HB 271 and repeal the FLPA, all that heartfelt protection or desire to protect this baby that we have in society wouldn't have applied to him just 1 week before. So I want to ask you the question, what's the difference between this baby just hours, literally hours after he's born and 1 week before? So, so in this case, there were charges brought against people who hindered the first responders looking for that child. And, the late-term abortions that are covered by the FLPA, which are 6 months and beyond, that baby is closer to being born than they were to being conceived. So repealing this would legalize abortion through birth. Every level of human civilization that is applicable here today disagrees with repealing this. If you look at the statistics, the New Hampshire Institute of Politics poll from August of last year said over 70% of New Hampshire agrees with abortion restrictions at some point. This is the most moderate, latest point you could have it. If you look at the United States, 43 states, according to a pro-choice research group, Guttmacher, have protections at this place or earlier. So the vast majority of the states. And if you look at the world, last I checked, there were only 7 countries that don't protect the preborn children at this stage or earlier. Amongst those are those known for tragic other human rights violations like China and North Korea. So one thing I wanted to address, the statistics there's not a lot of statistics, but there are a couple states that do keep statistics on the reasons for late-term abortions. The stats that we do have show that the majority of them are actually elective. They wouldn't fall into rape, incest, or health of the mother, or fetal anomaly kind of classification. So if New Hampshire is like the rest of the country, that's probably the case here as well. The FLPA protects not just a baby's life, it also protects the mother's life. As you heard, late-term abortions are very, very risky. And you
Mr.
can...
Hennessy, you're kind of getting over your time. I appreciate it if you'd sum up, please.
Okay, thank you, Mr. Chair. I will sum up quickly. So no mother in New Hampshire is required to raise the child. New Hampshire has a safe haven law, and you're welcome to look into that. If protection of life is the primary purpose of government, this fits with the ethics of the vast majority of citizens in this state, in this country, in this world. I hope you will please follow your conscience and vote in expedient to legislate on HB 271. Thank you.
Thank you. Questions for this witness? Yes, Representative Stapleton.
Thank you, Mr. Chair, and thank you for taking my question. It was an interesting term you used, the choice of the baby to be born. If we repeal this protection, do we not obliterate that initiative, if not choice, at least the initiative in nature for the child to be born? And does that comport with personhood, being a person in the 14th Amendment of the U.S. Constitution?
Thank you, Representative. I am not a lawyer, but as an armchair reader and lover of the U.S. Constitution, I do believe that you can't take away somebody's life without due process. And so especially a viable child would be recognized by the vast majority of Americans as a person in deserving of rights.
Thank you.
Any other questions for this witness? Seeing none? All right, thank you very much, sir.
Thank you, Mr. Chair.
I have no other pink cards, and so let me ask, is there anyone else who desires to testify on HB 271? Seeing none, I'm going to close the hearing on HB 271. And I'm going to ask my vice chair, Representative Wallace, if he will take over and introduce the hearing on the next bill, House Bill 88. I'm going to take a short break. Thank you.
Okay, we'll now open the committee hearing on House Bill 88, and we call Representative Alexis Simpson.
Thank you, Mr. Chair.
Good afternoon, everyone. My name is Representative Alexis Simpson. I'm from Rockingham District 33, representing the people of Exeter, Stratham, Newmarket, and Newfields. I'm honored to introduce HB 88, the Access to Abortion Care Act. Since we introduced this bill last year, the Roe v. Wade Supreme Court decision is no longer the law of the land. Since Roe v. Wade was overturned, I have heard from my constituents and people across the state that they are scared. They aren't sure if they are protected here in New Hampshire and if they will have access to the care they need. And even more so, they're scared of what the future looks like for their children and grandchildren. It may seem that these fears are overstated, but most of my constituents watch the national news. They've watched as state after state across the country has banned abortion early in pregnancy before people even know they're pregnant, and in some cases banned abortion completely. In a time when people are uncertain about so many things, the cost of housing, electricity, and childcare, to name a few, losing control over your body and the ability to make decisions about the security of your family's future is scary. As a mother myself, I understand those fears. There's no decision more critical than if, when, and how to start and grow a family. I want to be really clear about what this bill does and does not do. This bill does not change any current abortion laws. It does not change the 24-week ban at all. It does not change the parental notification law. Instead, it puts into state law that the state cannot further restrict or interfere in an individual's ability to access abortion. Currently, there's a legal void regarding the affirmative right to an abortion in New Hampshire. There's nothing that grants granite staters abortion rights. There are only restrictions, and the restrictions are clear. New Hampshire is one of 3 states where abortion is legal but not protected. And New Hampshire is the only state in New England without this affirmative right. Our neighboring states all have this type of statutory language on their books. It may be worded slightly differently, but Maine's law, for example, is almost identical to this bill's text. Let me quote it. It is the public policy of the state that the state not restrict a woman's exercise of her private decision to terminate a pregnancy. End quote. And then their specific ban on abortion is listed there. Similar to Maine's language, in HB 88, the Access to Abortion Care Act, we have included the current abortion laws, though we've used the RSAs as reference. New Hampshire does not have explicit state protections for abortion. The Access to Abortion Care Act adds clarity on where we, the legislature, stand and what our intent is for abortion laws in New Hampshire. Indeed, perhaps this bill wasn't needed when there was a federal legal framework for abortion rights, but all that has changed with the overturning of Roe. We have an obligation to our constituents, the overwhelming majority of whom believe that decisions about reproduction and abortion care belong to pregnant people and the people who provide them care. Granite staters are looking to us, their elected officials, right now for clarity and security. Access to abortion care up to 24 weeks is legal in New Hampshire, and we should reassure our constituents by securing this in statute. Passing the Access to Abortion Care Act will show the people that we understand what is at stake and that we trust them and their doctors. Thank you.
Any questions for Representative Simpson? Representative McBeath?
Thank you. Thank you for taking my question, Representative Simpson. So I just want to clarify, so this bill will do nothing, it will not repeal the 24-week ban that Governor Sununu signed into law 2 years ago. Is that correct?
Thank you for the question, Representative. You are correct. This does not change the 24-week abortion ban in statute.
Thank you.
Representative Greason.
Thank you, Mr. Chair, and thank you, Representative, for taking our questions. In the bill, lines 13 and 14 say, an individual injured as a result of a violation of this chapter shall have a private right of action in superior court against the state for injunctive relief arising from the violation. Would this not then prohibit a doctor from refusing to perform an abortion against their conscience?
Thank you for the question, Representative. I believe that under the enforcement section of the bill, you're pointing to lines 13 and 14, that this is actually just against the state, an actor of the state, not a private actor, which a doctor would be unless they were employed by the state, I would presume.
Representative Tripp.
Thank you for taking my question. During your presentation, you made the statement that in New Hampshire, abortion is legal but not protected. Could you explain what you mean by that?
Yes, thank you for the question, Representative. So right now, abortion is legal up to 24 weeks. The 24-week ban starts right then, but there is no place in the statute where it is a protected right.
Thank you.
Yeah.
Any further questions for Representative Simpson? Seeing none, thank you. We now call Senator Perkins Corca.
Good afternoon, Chairman and members of the committee. I am Senator Rebecca Perkins Quokka, here to represent District 21, which is the city of Portsmouth and the surrounding towns, in support of HB 88. In 2021, I was a first-term senator and one of two young moms in the chamber. As many of you may remember, the same term, new abortion restrictions were passed into law through our budget. I was just around 24 weeks pregnant when we first debated this bill. I was experiencing firsthand how frightening it is to think you won't be allowed a full range of medical care that was available to you when you started a journey. No future parent should ever again have to worry that their rights will be taken away. Last year, this same bill, the Access to Abortion Care Act, was introduced to guarantee the right to abortion before 24 weeks in New Hampshire. Months later, the Supreme Court leaked the eventual Dobbs decision that overturned Roe, leaving folks across the country vulnerable. It didn't take long for many to lose their rights. Today, around 20 million people have lost access to abortion in their home state, including 1 in 3 American women of reproductive age. In New Hampshire, there is nothing giving the affirmative right to an abortion prior to 24 weeks in this chamber. Nothing to prevent what is happening across the country to reach our state too. The overturning of Roe versus Wade means that the entire legal framework for reproductive rights no longer exists. New Hampshire is one of 3 states where abortion is legal but not protected, as we just heard about, with new court cases starting to come out, including one that could affect a form of abortion in every state, including New Hampshire. We need to fill the void on our books. For a state that prides itself on local control, we must enact a New Hampshire solution before one is imposed upon us. Last session, we tried to do just that. We garnered bipartisan support in this chamber, but ultimately fell 1 vote short in the Senate. Some of my colleagues said we needed to wait for the Supreme Court to act before we took action. For many, a world without Roe seemed impossible. For many more still, the idea that abortion could ever be illegal in New Hampshire seemed impossible. I, for one, at this point, am not willing to wait and see any longer. We must act now to ensure the women of New Hampshire are protected. This bill is not radical. It does not even change state law or amend parental notification. Instead, it makes good on something that 71% of Granite Staters support: access to reproductive health care. It's also about respect. It's about respect for the women who bear the important responsibility of carrying our society's children and for their right to personal physical autonomy. We are women, mothers, and pregnant people, and when we are pregnant, our ability to be complex, highly intelligent decision makers doesn't change. I urge you to support and not to pass recommendation on HB 88, and I'm happy to take any questions. Thank you, Chair.
Any questions? Seeing none, thank you.
Thank you very much.
We now call Senator Whitley. And you've asked for 10 minutes. Maybe shave it down a bit.
Oh, 10 minutes? I don't need 10 minutes. Pardon me.
Thank you.
Thank you, Mr. Chair. Good afternoon, members of the committee. For the record, my name is Becky Whitley, and I'm honored to represent Senate District 15, which includes the communities of Bow, Concord, Pennacook, and Hopkinton. Thank you very much for welcoming me to your chamber, and I'm here to testify in support of HB 88. So I'm going to talk a little bit about the legal background about how we arrived at the need for this bill. So as many folks know, 50 years ago, Roe v. Wade was decided by the U.S. Supreme Court and made abortion a constitutional right in all 50 states. The Supreme Court later affirmed that decision in the Casey case. These rulings gave people the right to access abortion legally in every state, although of course that didn't mean that everyone had the same amount of access. Just last year, the Supreme Court overturned 50 years of legal precedent when it decided the Dobbs v. Jackson Women's Health Organization case. The overturning of Roe v. Wade in the Dobbs case means that the entire constitutional framework for reproductive rights no longer exists. It was wiped clean. There's no longer a federally constitutionally protected right to access abortion in our country. That means that the legal landscape across the country and in New Hampshire without Roe v. Wade is recklessly unclear. In the Dobbs case, the Supreme Court left the issue of reproductive rights squarely with state legislatures and with state politicians like me and you. Well, here we are. It's our turn to act, and it's our turn to listen to the vast majority of Granite Staters who support the rights that we had under Roe v. Wade. Our constituents are watching us, and they're waiting for us to act. Many states like Missouri have tried and are continuing to try to restrict patients from accessing abortion in other states. The Texas abortion ban includes a bounty hunter provision allowing essentially any individual, anywhere, to seek a civil lawsuit against anyone who aids and abets an abortion, which is a provision that has not been struck down by the U.S. Supreme Court. Local municipalities across the country are also attempting to pass local ordinances, including to restrict medication abortion, as seen in Minnesota. This bill before us, HB 88, would give New Hampshire a legal leg to stand on, not if, but when another state tries to reach in. 2 years ago, the New Hampshire legislature passed a law banning abortion at 24 weeks with very, very limited exceptions. As part of that law, which is now RSA 32949, that law states nothing in the subdivision shall be construed as creating or recognizing a right to abortion. That means that in New Hampshire, we do not have a law protecting access to abortion before 20 weeks. But the passage of HB 88 would put this right explicitly into state law. Just to be crystal clear, the bill before you does not amend the 24-week ban. It does not amend parental notification. It simply addresses the legal void in our state laws and provides clarity for nearly half of our population. New Hampshire is one of 3 states where abortion is technically legal, but not protected. This legal gray area is confusing and disconcerting to Granite Staters as they look around the country as millions and millions of women lose access to their reproductive freedom. Granite Staters need these protections, and we need them now. There is an urgency and often a panic when I talk to my constituents and my contemporaries. What is going to happen in New Hampshire? Do New Hampshire politicians value freedom? Will they step up to protect my right to determine my own future? This bill would make it crystal clear to Granite Staters and to a future New Hampshire Supreme Court what the intent of this legislature is. We have a void on the books, an unresolved status. There is nothing in New Hampshire law that any judge can point to which says the intent of New Hampshire law and the legislature is that abortion is legal up to 24 weeks. The only clarity in New Hampshire law is the restriction to abortion. Do we want to be a state that starts with the presumption of the unknown? Because that is where we are right now. As we speak, 25 million people have lost access to abortion in their home state, including 1 in 3 American women of reproductive age. This is staggering and something I never thought I would see in my lifetime. I'm scared, and the women in my life are scared that we won't have the freedom to determine our own futures and the course of our lives, that we will that the rights to bodily autonomy will be taken away from us, that we will be forced to carry pregnancies against our will. It sounds dystopian because it is. Thank you very much, and I respectfully ask for the committee's support of HB 88, and I'm happy to take any questions.
Representative Tripp.
Thank you for taking my question. The previous speaker made the same statement that you did, that in New Hampshire, the abortion is illegal but not a protected right. Could you please explain to me how House Bill 88 will make it a protected right?
Yeah, thank you very much for that question. This is the confusing area, right? The reason why we say it's legal is because there are no current restrictions. The only restrictions on abortion are at that 24-week period. But there is nothing in state law, and in fact, existing law says it very clearly. There's nothing about the right to access abortion up to 24 weeks. Our law is silent.
Follow up? I know that Representative Gleason asked this question earlier, but I must not have been listening. On lines 13 and 14, there's a statement that an individual suffering an injury could blah, blah, blah. Could you please explain what kind of injury is covered in this?
Yep. So thank you for that question. So the bill is very simple. Lines 8 through 11 give the right. So this is very typical statutory construction. That part of the bill gives this right? And the right is freedom from governmental intrusion up to this 24-week point. That's the right. Government, you can't interfere. And then the second portion, you have a right. Your right means nothing unless it's enforced. So it's not a penalty, it's an enforcement mechanism. My right was violated. This gives me the legal authority to enforce that right. So, and it's I just want to be very clear and reiterate the fact that this is only related to governmental action. This is not related to private action. This is governmental action, which again is typical statutory construction. The right is freedom from governmental intrusion, and this is how you exercise that right.
Thank you very much.
Thank you.
Representative Perez.
Thank you. Not legal. I'm not legal, so I apologize. So again, I'm going to do the legal. So you're saying right now, the law says you can have an abortion. It doesn't say you can have an abortion up to 24 weeks. It only says when you can't have an abortion. Is that correct?
That's correct. And then specifically in statute now, as of 2 years ago, the law also states specifically, and this is a quote from RSA 32949, nothing in this subdivision shall be construed as creating or recognizing a right to abortion. So it's very clear that there is no right to be free from governmental intrusion when a woman seeks an abortion up to that 24-week period.
Have we had any problems with it?
Access to abortion, I mean, I can't speak to that. I'm surely the providers will be able to seek that, but certainly around the country, we have seen states rushing in to create those restrictions.
I understand that, but
Yeah.
have you heard of any women who have had their right to have an abortion up to 20 stopped from having that happen?
I think I'll have to defer that question to our providers in the room, but thank you for that.
Okay.
Thanks.
Representative Beth.
Thank you, Chair, and thank you for taking my question, Senator. Just because it's been the whole thing about going to the Superior Court for injunction. So what somebody would do, I don't know if you could explain what that is. So if somebody's prevented from Could you explain the injunction part, what that does, or?
Yeah, well, it's been a while since I've been in a courtroom, but right. So the enforcement mechanism, and you'll see that online, 13 and 14, is that if someone believes that their right was violated, that the government intruded on their rights as described in 8 through 11, they have the ability, they have the authority under the statute to go in superior court and file an action. So that's what it is. And then the second part is, this is very typical language too. If you have an enforcement mechanism, if you have a right of action, then you also have this ability to get injunctive relief. So that means injunctive relief means government, stop. You're not allowed to intrude. Thank you.
Thank you.
Any other questions? Seeing none, thank you.
Thank you.
We now call Representative Notter. Up next will be Representative Phillips.
Thank you, Mr. Chairman, and good afternoon again, members of the committee. I stand in opposition to this bill. I made a promise to advocate for innocent human life, and if we don't speak for them, there is no one to speak for them. And that is all I'm going to say on this bill. Thank you.
We now call Representative Mary Hawken Phillips. Next will be Danielle Pimentel.
Hello, Representative Mary Hacken Phillips from Grafton County District 12, which is the towns of Hanover and Lyme. So I'm here as a co-sponsor of HB 88. I'm here to urge support for this bill, and I'm only here to speak about 2 issues today, although I feel very strongly about a breadth of them. The first issue is purely professional. Many of my constituents are the state's best leading OBGYNs, practitioners, and healthcare professionals. I'm here to report that they're quite anxious about the current state of our law. They feel threatened, in fact, by the 24-week abortion ban, the criminalization that goes along with their practicing, and the requirement in law to disregard the national standards of care, in particular against their oath to do no harm. Denying abortion care is a very, very real harm that we're talking about. The tool of abortion access that has helped make it possible for many of these leading abortion care providers is actually being denied to their patients, and they find that very difficult to digest. You know, the ability to have that tool in your pocket as a young professional in training for these medical professions is what enables them to become women leading their field. And, you know, it's a real kick in the seat to not be able to protect your own patients in the same way. I implore this committee to please relieve these professionals of their fears of being prosecuted. Please pave a clear pathway for these professionals to practice the best peer-reviewed medical guidelines by codifying this law, this right to abortion care up to that 24-week deadline. During our current workforce crisis, let's incentivize the best OBGYN professionals and healthcare providers to work in New Hampshire. Allow them to give them the best care to their patients as well. They can't be here today. Obviously, they're attending to our Granite Staters' needs, so I'm here to relay that message. As a member of House Finance, I've been briefed several times by the New Hampshire Department of Business and Economic Affairs, and specifically, I'd like to speak to Commissioner Taylor Caswell's statement that of the 5 strategic goals of the BEA, number 1 is to retain and recruit a modern workforce. This bill would support BEA's mission, by supporting New Hampshire's best OBGYNs and healthcare professionals and practicing the nation's best medicine. The second issue I'm here to speak about is a financial and economic issue. In House Finance, I'm also briefed by Brian Gottlieb, the Director of New Hampshire's Economic and Labor Market Information Bureau, on the outlook for New Hampshire's labor and market economy. According to Brian, the state's biggest challenge to growth is the labor force shortage. And he estimates that we're about 8,500 workers short from pre-pandemic levels. So that 8,500 workforce shortage, the biggest group that he can point to for a drop who's not back yet to the workforce are women between the ages of 25 and 34. Among those women, that category of women, these are the most likely ages for women to be reproducing. So we're talking about a huge piece of the workforce shortage that you can incentivize to return to the workplace by giving them this tool. This abortion access will allow them and empower them to control their own family planning, explicitly through this abortion access, to choose how many mouths they'll feed, how many seats at their table they'll need to pull up, how many spots in childcare they'll need to secure. Let's be frank. Giving full determination of your family's makeup is a financial consideration. This is a decision you have to make every day. And if we want to reach full economic growth as a state, then we're going to need to incentivize giving this specific group of women back into the workforce. So as you know, there's a lot of moral, ethical, religious, legal arguments for why this bill is needed, but I want you to remember that there are financial and professional real implications to supporting this bill, especially if we want to reach that full workforce potential here in our state. Thank you. I'm happy to answer any questions. Yeah.
Thank you. Questions for this witness? Yes.
Thank you, Mr. Chair. Thank you for taking my question. Do you find that these professionals that you're working with alongside, are they looking for other positions outside of the state of New Hampshire?
Thank you for the question, Representative. I know that there are folks here from healthcare providers in our state who can speak to that with more direct factual examples, but I can tell you anecdotally, having close personal relationships with many of professional women providers in our state, that this is a major issue on the forefront of their mind, and it has not ebbed since the moment that Roe fell. This is something that they are continually worried about for not only themselves as working professionals of maternal age, but maternal reproductive age, but also as mothers, as wives, as grandmothers. So, please don't discount these real tax-paying, I would say highly tax-paying citizens in our state and their needs.
Thank you. Other questions for this witness? Yes, Representative Stapleton.
Thank you, Mr. Chair. Thank you for taking my question. If the right to an abortion is not currently inherent within the New Hampshire Constitution, doesn't it really require a constitutional amendment to be ruled on in a ballot initiative by the people of New Hampshire rather than just the legislature?
Thank you, Representative, for the question. And my best answer to that is that this is not a constitutional request. This is a statutory request. And as you know, there are plenty of federal laws that are reduced to statute that support fundamental rights across our country that are not included in, the Bill of Rights, for instance. So, just off the top of my head, I think about workers' rights, OSHA concerns. I think about just anti-discriminatory clauses for accommodations. None of that is included in our Constitution, but there are federal rights that are protected under federal law, so in statute.
Thank you.
So, other questions for this witness? Seeing none, thank you very much. I guess next we have Danielle Pimentel, and then next, after that, will be Representative Sellers.
Mr. Chairman and members of the committee, my name is Danielle Pimentel, and I serve as Policy Counsel at Americans United for Life. Thank you again for allowing me to testify. This is my third time, hopefully third time's the charm. This legislation has grave implications similar to the amendment that we heard earlier today proposed, grave implications on future health and safety protections for women, as well as conscience protections for healthcare providers, which is why I urge you to oppose this bill. HB 88 will prevent New Hampshire from enacting abortion regulations that purportedly interfere with an individual's decision to have an abortion. As a result, this bill severely limits New Hampshire's ability to enact health and safety protections for women that are being alleged to interfere with someone's right to have an abortion. For example, as I stated earlier in my earlier testimony, New Hampshire does not have an informed consent process for women undergoing abortions. And informed consent safeguards provide women with material information to guide them in their abortion decisions, which is vital given that many women may be considering abortion because they are being forced either by a partner, family member, or sex trafficker. So informed consent safeguards provide women with material information that let them know that there are other resources available to them, that they are supported, and give them other options such as giving birth or giving up their child up for adoption, etc. However, HB 88 would likely prevent the state from passing these kinds of safeguards. Further, HB 88 raises serious concerns for conscience rights, as Representative Greason mentioned earlier, because the bill has no language that would ensure the protection of healthcare providers' conscience rights, so healthcare providers that have moral or ethical objections to abortions. Instead, the HB 88 would result in physicians being forced to perform abortions regardless of these objections, and also prevent this state from enacting legislation that would protect healthcare providers' conscience rights in the abortion context. Instead of increasing abortion protections, as this bill purports to do, the focus should be on strengthening informed consent laws and health and safety protections for women, especially given that women are increasingly rejecting abortion and choosing life. The current abortion rate is nearly half of what it was in the 1980s after Roe v. Wade was decided. And even prior to the court deciding Roe v. Wade, women have been steadily gaining access and esteem in the workforce and have been continued to choose life and carry their pregnancies to term. And so for these reasons, I strongly urge the committee to oppose HB 88. Thank you. Any questions, I'm happy to answer.
Thank you. Questions for this witness? Seeing none, thank you very much.
Thank you.
Representative Sellers, and then next will be the Reverend Heidi Heath.
Thank you, Mr. Chair, and thanks again, committee, for hearing what I have to say. I'm just looking up here I have two things with this bill, and I just want to bring it up to you. Probably actually more, but two things that's coming to my eye. One is, to me, this is, again, we come down to the lawyers or the attorneys. I'm saying the attorneys are going to have a blast with this. They finally found somebody that has deep pockets. It's called the state of New Hampshire. One misstep, and they're going to get millions of dollars from us, just one. So for that one reason, that's one reason I'm opposed to this bill. But the other one is, you look at line 9 and 10, excuse me, and it says, it basically shall not restrict or interfere with an individual's exercise to their private decision to terminate a pregnancy. Again, the word interfere, does that mean if we create a bill or that becomes a law 8-10 years from now without repealing this law, we're indirectly interfering with that person to have a pregnancy? So this is just an accident waiting to happen if this actually passes. The other part of this, and I guess it's the third part, is terminate. Well, that's why I was looking up on my phone again, because I'm not an English major, but it does say terminate. It says bring to an end. Bring to an end. Bring to an end is another word. Bring to an end of what? They're talking about a pregnancy. That means you must be talking about something that's living. All right, it's not a thing. It's not it's not a fetus. It's a living being, a human being. It's also, I want to say, an infant. Now you think an infant is just after birth. It is not. You look up the word infant. In Latin, it means infan, I-N-F-A-N, which means speechless, on one that can't speak. That is a preborn that's not born yet, all right? So someone, whoever's writing this bill here, to me, I'm sorry, and I don't mean any disrespect, but plain English, it's a joke. This is just a joke.
Thank you. Questions for this witness? Seeing none, thank you, sir.
Thank you.
Reverend Heidi Heath, and after her will be Liz Canada.
Honorable members of the committee, thank you for hearing my testimony this afternoon. I am the Reverend Heidi Carrington Heath, and I come before you today in strong support of the Access to Abortion Care Act. I'm coming to speak with you today in two capacities. I am an ordained Christian minister, and I have served in multiple ministry roles now for over a decade, including as a labor and delivery, NICU, and postpartum chaplain. Today, I am also here representing a coalition of interfaith clergy from across New Hampshire. We are bringing to you a letter asking for a vote of ought to pass on this bill. We represent more than half a dozen religious traditions and hundreds of faith communities across the Granite State. Access to abortion care is an essential part of all of our religious beliefs and all of our practices, as is true for the majority of the world's religious traditions. This bill would enshrine into law critical protections for women and birthing people across the Granite State. Healthcare is an essential human right. Abortion is healthcare, no more and no less. It is a fundamental bedrock of making sure that citizens of any state can make appropriate healthcare decisions in conjunction with their medical providers, their clergy, their therapists, and other trusted supports, free from shame, interference, government pressure, or more. As a practicing Christian, I am pro-faith, I am pro-family, and I support abortion access. I do so not in spite of my faith, but because of it. My faith compels me to stand with those who seek safe and legal access to this care. Abortion is healthcare. Abortion can be life-saving. What could be more faithful than that? I honor the sometimes complex and compassionate choices that pregnant people seek to make. Moreover, I am a deep supporter of the principles of religious freedom upon which our country was founded. Each of us is guaranteed the right to make our own choices according to our own religious beliefs, and not to be required to conduct our healthcare by the principles of someone else's ethics. My Christian faith encourages me to look out for those who may be left behind by those in power. So I come before you today in support of the Access to Abortion Care Act. For these reasons and many more, I urge you to vote ought to pass on HB 88 and abide by the values of freedom and choice that New Hampshire has claimed as our own for centuries. People of faith and people across the Granite State are counting on your leadership. Thank you for hearing my testimony today.
Thank you. Questions for this witness? Yes, Representative Greason.
Thank you, Mr. Chair, and thank you for your testimony. Are you aware of any other medical procedures to which anyone has a statutory or constitutional right to access?
I would offer that there are many medical procedures to which folks have a constitutional right, and statutory requirement is not the word I use, but statutory right to access. But I'm not a lawyer and I'm not a medical professional, so I can't speak to the details of the law.
Other questions for this witness? Yes, Representative Stapleton.
Thank you, Mr. Chair, and thank you for taking my question. You mentioned that you represent a number of interfaith organizations. Is the Catholic Church or any of its parishes aligned with that particular organization?
Signed on to the letter that I mentioned to you today, no, sir. And we will provide you with a written copy of that letter electronically so you have access to all of our information.
Yes, please.
My hearing is not good,
Sure.
and I'm having trouble with the reverberation. Did you say that there were or were not some Catholic churches that or aligned with what you've just spoken about?
The letter that I spoke about today, which I assume is what you're asking about, no.
Right. Thank you.
Sure.
Other questions for this witness? Seeing none, thank you very much.
Thank you.
Liz Canada, and next will be Courtney Reed, I think. Yes, Liz Canada.
Good afternoon. Hello again. My name is Liz Canada. I'm the Advocacy Manager at Planned Parenthood of Northern New England and Planned Parenthood New Hampshire Action Fund, and we're here in strong support of House Bill 88. As you've already heard, New Hampshire does not have anything in state law protecting or recognizing a right to abortion. We are the only state in New England without anything in state law. I heard mention earlier of Massachusetts, for example. They have statutory protections for abortion in Massachusetts. Vermont has statutory protections as well, and they recently passed the constitutional amendment. So now they have both statutory and constitutional protections in Vermont. Across the country, there are only 3 states where abortion is legal but not protected, and New Hampshire is one of them. This bill before you would put into state law the recognition. This bill does not amend the 24-week abortion ban. It does not amend parental notification. It simply addresses the void in our state laws, which is particularly critical now that Roe v. Wade has been overturned and there is no longer a federally constitutionally protected right to abortion. Passage of this law would provide legal clarity. And as you've already heard, since Roe v. Wade was overturned, over 25 million people across the country have lost access to abortion in their home state, including 1 in 3 women of reproductive age. Abortion bans have created a domino effect in our country. Patients have had to travel out of their own state, but only if they can find childcare, if they can take time off of work, and if they can afford it. And then they have to travel farther as bans take effect. They have to travel later in their pregnancies. And they travel to states like here in northern New England because they see this area of the country as safe for them. So this bill in front of you is an opportunity to show Granite Staters that abortion will remain safe and legal until 24 weeks in our home state. This bill, again, doesn't change any of the current laws. They remain intact. This only changes the fact that we do not have a statute recognizing the right to an abortion. We know that the majority of people in New Hampshire support the right to access abortion, free of government interference. We also know that no one in New Hampshire wants the government of another state to interfere with what happens here in New Hampshire. Other states are attempting to pass laws that would reach beyond their own borders and into New Hampshire. Again, we're only one of 3 states that has an abortion ban but no protections on the books. You can change that. House Bill 88 is a win-win. It provides critical assurances that our state will not alter course now that Roe v. Wade is gone, but instead will enshrine into state law that we value and support an individual's personal and private decision-making in accessing the health care that they need. And we urge you to vote ought to pass on House Bill 88.
Questions for this witness? Representative Perez.
Thank you. I have a question for you. By doing, again, I'm not legal, so I apologize. By doing this, if the state decided, let me back up a little. It's my understanding that when abortion was made legal, it was initially the first trimester, I believe. Correct me if I'm wrong. And then I believe it was in the 1990s that it was changed to a quote, a viable fetus, which at that time was approximately 24 weeks. And that's where the 24 weeks has come from. Again, correct me if I'm wrong. If we do this with this bill, does that mean if things change dramatically and say a viable fetus is at 15 weeks and the people, okay, because I believe in the people, wanted to change the present statute, they would not be able to change it?
Thank you for that question. So 2 pieces that I want to address in what you said. So 24 weeks is not the same as the viability standard that we have seen. So it's a fixed mark in the calendar. 24 weeks is that hard, firm line. Now, the question about can a future legislature, is what I think is what you're asking, can a future legislature amend it? That's true for any bill. Any bill can be changed in the future as, a legislature dictates. What we know, in every state in the country, even where abortion is outright banned, it is unpopular to have abortion bans in those states. And so a future legislature would have to come to terms with how the people of the granite state of New Hampshire would want them to change any abortion ban. So that is the response for sure.
Yes.
So, again, not legal, kind of black and white. Would this prohibit in any way the state changing the present law or any part of the present law at any time? It's a yes or no, please.
The legislature can pass laws and amend laws as they wish. We do know that states like Missouri are trying to pass laws that would reach into other states like New Hampshire and try to affect patients here and providers here. And so this type of legal clarity would be really helpful in that type of circumstance. Sure.
Representative Stapleton.
Thank you, Mr. Chair. Thank you for taking my question. In the same vein of the prior question, but with a little variance, the bill does provide exception under RSA 329:43 to 329:50 and RSA 132:32 to 36. If the law were to change by addition of additional RSAs in a restrictive sense, does that not represent a problem for this bill and a conflict of law? And therefore, this really should be a constitutional issue rather than a statutory one?
Thank you for the question. So to that last point, the good news is you have a constitutional amendment to vote on, CACR 2, which we also support. The constitutional amendment would go to the voters in November of 2024. This would take effect immediately. So that would be, a major value for Granite Staters to know that that has been effective immediately. But both things are really important to have in place, like we see in Vermont, both statutory protections and constitutional.
Thank you.
Other questions for this witness? Seeing none? Thank you.
Thank you.
Courtney Reed, I'm sorry. Courtney Reed, and then next will be Representative Megan Murray.
Thank you, Chairman. Sorry, I don't have the best handwriting.
That's okay, no problem. Neither do I.
Yeah, thank you. I'll try to keep my testimony short, as we've already heard some pretty robust statements from supporters of HB 88. My name is Courtney Reed, and I'm here with the ACLU of New Hampshire. And I just want to reiterate that last month we should have been celebrating what would have been the 50th anniversary of Roe v. Wade. And unfortunately, we're in a cloud of legal uncertainty about what reproductive rights are protected, especially in the state of New Hampshire, where we don't have a constitutional protection for the right of abortion, and we don't have anything in statute that protects reproductive freedoms either. And just to kind of put this in a context of the national scale, we've seen 66 clinics across 15 states stop offering reproductive care. 12 states have banned abortion outright since Roe's overturn, and as many as 1 in 3 women of reproductive age have lost access to abortion in their home state. And we've seen a lot of these attacks on reproductive liberties take place through incrementalism. In Texas, for example, a 24-week abortion ban was issued in 2005. Since then, in 2013, the state issued a 20-week ban with few exceptions. In 2017, the state placed burdensome and targeted restrictions on reproductive health centers. And in 2019, the state issued more restrictive policies. In 2021, the state finally issued a 6-week near total ban on abortion. So where the Granite State is now is where Texas was in 2005. We currently have a 24-week abortion ban with limited restrictions that was passed 2 years ago, and there will always be politicians eager to chip away at abortion access like we've seen in Texas. Yet, By passing legislation like HB 88, we would act in favor of what we already know, where Granite Staters who have been polled show overwhelming support for abortion protections. And every ballot initiative, even in deeply red states this past November, strongly went in support toward protecting abortion rights. So Granite Staters right now are concerned and worried about their continued access to abortion, which, according to the American Medical Association and other medical communities, is an essential part of reproductive health care. So it's time to make explicit that abortion is protected, and by this law, we would be affirming that there can be no more incremental attacks on abortion as it stands through statute. And this legislation is an affirmative protection of abortion that doesn't change anything under state law at where we are now. So I'd like to urge the committee to pass HB 88. Thank you.
Questions for this witness? Yes, Representative Greason.
Thank you, Mr. Chair, and thank you for taking our questions. Since you represent the ACLU, perhaps you will have a little bit more information. Are you aware of any medical procedures to which anyone has a statutory or constitutional right to access?
Yeah, thank you for your question. I would also like to leave the answer to that to medical experts that might be more familiar with it, but I can say I'm fairly certain that there are not any medical procedures that have restricted access to them in the ways that abortion does. Thank you.
Anyone have any other question? I guess the one question that I have is you say that this would offer some protection from politicians basically change, but if this is just a statute, isn't it, this only offers protection until the statute is changed, and a future legislature would have the ability to change it at will, would it not?
Yeah, that's correct, Representative. Thank you for your question. I just want to speak a little bit more to that in that by passing this bill, we would be honoring what an overwhelming number of Granite Staters have supported through polling, which is a protected access to abortion and other reproductive health care. The ACLU has also testified in support of the constitutional amendment, which protects that right to a greater extent. But like we've seen in states like Massachusetts, there are a multitude of ways to make sure that reproductive rights are protected, and through statute is just one of them. Thank you.
Thank you. Other questions for this witness? Yes, Representative Stapleton.
Thank you, Mr. Chair. Thank you for taking my question. On your very nice handout here with a lot of facts and figures, on the back page, you have one particular item: protecting abortion access is part of the battle for racial equality. Can you explain how that is, even though we know that the Black population is a large proportion, a larger proportion of abortions, elective abortions, than in other racial segments?
Yeah, thank you for your question. One thing that comes to mind with that is that there's been some research that demonstrates disparities in maternal mortality rates should abortion be restricted nationwide. For example, I believe 21% or 24% will be the increase in maternal mortality rates in general. But when we look at the increase of maternal mortality rates among Black women after abortion access is stripped away, that bounces up to 33%. In general, there are racial disparities in maternal mortality and health risks when it comes to carrying out a pregnancy. And there's also a lot of research that shows it's more difficult to escape poverty, which is something that's racialized. And I'd like to give you some more information that can speak to that bullet if you'd like to communicate further about that.
Thank you.
Other questions for this witness? Seeing none, thank you very much.
Thank you.
Next, I'm going to call Representative Megan Murray, and the next witness after that will be Josie Pinto.
Good afternoon, honorable colleagues. For the record, my name is Megan Murray. I come before you in support of House Bill 88 as a co-sponsor, woman, and mother who represents the towns of Amherst and Milford. For the first time in my lifetime last year, a federally and constitutionally enshrined right was taken from me and many others across the nation. So many worked for decades to make sure that equitable access to safe care existed as women worked to gain equal rights on so many fronts, including access to abortion care. This is not a partisan issue. So many Granite Staters support the position of protecting access to abortion care and have doggedly worked towards that for many generations.
Yeah, could you just get a little closer to the microphone?
Sure.
Thank you. Thanks.
Regrettably, the fall of Roe via the Jackson v. Dobbs case has set up a patchwork of state-by-state policy positions that vary widely, leaving equity and access to abortion care in the balance. It is now up to us, the state of New Hampshire, to make the promise we must that access to abortion care is a right. The bill would provide legal strength to the right to an abortion. It changes none of the statutes already set forth in law. And HB 88 is at a minimum the least we can do to provide assurance to those seeking abortion care here in New Hampshire. My constituents want high-quality OBGYN doctors and services. Leaving abortion care unprotected here means that providers may leave and practice elsewhere. It could leave a void in reproductive health care options if we do not send a clear message that abortion care is protected in law and stated in statute. HB 88 ensures that access to abortion care is so vitally important and remains a private decision that families with their medical providers make together. The reasons for an abortion and an individual's medical and personal circumstances are many and unique. No two circumstances are the same. We as a community must ensure that we are not creating environments where practitioners are hesitant to provide critical care, and that from an equity standpoint, we are allowing the most vulnerable populations to access their care safely, affordably, and privately with the protection of the law firmly alongside of them. I urge ought to pass on HB 88. Thank you.
Questions for this witness? Yes, I guess I just have one question. Could you, it's a little unclear to me, candidly, the purpose of this bill. So I guess what I'm wondering is, let's assume that the Fetal Life Protection Act as it exists right now remains in effect. Because as I understand it, this bill doesn't purport to change that. So could you give us an example of what in other words, if the Fetal Life Protection Act remains in effect and is not to be changed by this, can you give us an example of what would change if this were enacted or not enacted? What's the risk that you're worried about if you have this bill or don't have this bill?
Thank you, Representative, for the question. My concern is that we do not have anything currently in state statute like HB 88 that sends the message that access to reproductive care is a state right, clearly and defined as defined in the statute.
Okay, all right. Other questions for this witness? Thank you very much.
Thank you.
Josie Pinto, and then next will be Michelle Silly-Foisey.
All right. Hello again, legislators. My name is Josie Pinto. I'm here as a lobbyist and the executive director of the Reproductive Freedom Fund of New Hampshire. And I'm here to express my strong support for HB 88 relative to access to abortion care. As our organization deals with the fallout of half of our country banning abortion, there has never been a more important time for us to proactively protect the right to abortion here in New Hampshire and prevent our rights from being chipped away at over time. Despite personal opinions on the topic, abortion is an incredibly safe medical procedure. The residents of our state deserve to know that despite what the Supreme Court has decided or what other states decide in these coming months and years, they will be guaranteed access to abortion up until the 24-week ban that has already been put in place. To be clear, as we've discussed, HB 88 wouldn't change anything about the existing law that is currently on the books, but it would solidify it, giving Granite Staters a clear answer to where our laws stand and easing our fears that we will not see a 24-week ban turn into a 20-week ban, then a 15-week ban, and so on.
If we, as Granite Staters, truly believe in bodily autonomy, medical privacy, and the rights of all Granite Staters to pursue liberty, we must codify the rights of all into law so that we can then begin the true work of ensuring equal access and true reproductive and maternal justice. I urge you all to vote in favor with the majority of Granite Staters saying that they want the right to abortion to be affirmed and protected here in New Hampshire. I urge you all to support this bill. Thank you.
Questions for this witness?
Thanks.
Seeing none, thank you very much. Michelle Silly-Foisey, and next will be Omer Ahern. Thank you.
Good afternoon, Mr. Chair and House Committee. My name is Michelle Silly-Foisey, and I live in Temple, as I said earlier today. I am here today in support of HB 88, the Access to Abortion Care Act. A year ago, I told my daughter Kayla's story, our abortion story, for the first time in public in this very room in support of HB 1609 to add a fatal fetal diagnosis exception to our state's abortion ban. I spoke of being a mother of 7 children, including my daughter Kayla, who I lost 18 years ago due to a fatal fetal anomaly. Our abortion was at 22 weeks. December 10th, 2005, Kayla was delivered stillborn after our termination the day before. As we held her in our arms for several hours, we said goodbye to the little girl that we continue to love with all of our hearts. Kayla was found to have a deletion in her 15th chromosome that was not detected until after our abortion. Our amniocentesis results returned a month after our termination, when I would have been 26 weeks pregnant. This timeline is the reason that I began to tell our story in support of the fatal fetal anomaly amendment added to the abortion ban instituted last year. It is clear that in these incredible complex situations, decisions should be left to a pregnant person and their doctor. I am here today to urge you to protect the right to an abortion before 24 weeks in state law. Since Roe v. Wade was overturned last summer, our country's reproductive health care landscape has been in disarray. 1 in 3 American women have lost the right to abortion in their home state. While abortion remains safe and legal in New Hampshire before 24 weeks, we are the only state in New England without a proactive protection for our abortion rights. Granite Staters are now susceptible to out-of-state attacks on their health care. In New Hampshire, we don't let other states dictate our rights. I did not make the decision to have an abortion with ease nor uninformed. Though we had only hours to make our decision, those hours were filled with gathering information and asking many questions. In the days that followed, I continued to ask questions along the way, and together with my physicians, we made the best decision for our family. Not once did I look to my state legislators for advice, opinions, or medical knowledge. I trusted in my physicians' expertise and the information that we had. New Hampshire residents are capable of making thoughtful decisions about their own health care in consultation with their loved ones, faith, and medical providers as they see fit. New Hampshire's elected officials should not turn their backs on our state's tradition of trusting the people of New Hampshire to make these decisions. In the face of national uncertainty, you have the ability to take proactive action to ensure abortion remains safe and legal in New Hampshire before 24 weeks. I urge you to support HB 88. Thank you for your time.
Thank you. Questions for this witness? Seeing none, thank you very much.
Thank you.
Next, Omer Ahern, and then next will be Bob Dunn.
Thank you, Mr. Chairman. Thank you, members of the committee. I urge the committee to oppose House Bill 88. Quite simply, I believe House Bill 88 will put chilling effects on what little the state of New Hampshire can do to protect human life. It must not become law in New Hampshire because we want to protect human life. And also, New Hampshire is part of a republic that is based upon Judeo-Christian principles. And one of those principles in the Bible is beware of false prophets. Oppose House Bill 88. Thank you.
Thank you. Questions for this witness? Seeing none, thank you, sir.
Thank you, Mr. Chairman.
Thank you. Bob Dunn, and next will be Sandra Denoncourt. Mr. Dunn.
Thank you, Mr. Chair, members of the committee. Once again, I'm Bob Dunn, the Director of Public Policy for the Roman Catholic Diocese of Manchester. And on behalf of Bishop Peter Labashi, I'm here today to respectfully oppose HB 88. I won't repeat everything I said this morning, and I've provided written testimony here today that explains why we oppose the policy. And I think also today, both in your questions and in the answers, it's become abundantly clear what the sort of procedural issue with this is, that this is what I would respectfully say is an HB that wants to be a CACR. And so with that, I would urge you to vote this down. Thank you.
Questions for this witness? I take it, Mr. Dunn, I think, am I correct that what you sort of mean by what you just said is that if we pass this bill, it's good only until somebody decides to, until some legislature in the future decides to change the law?
Exactly. It's trying to sort of enshrine policy into perpetuity, but it can't do that because the legislature is always free to do it. So if the legislature decided to do something in the future, which is what the folks who sponsored this are trying to prevent from happening, it would have no impact because the legislature would simply repeal this and replace it with the new legislation.
Thank you. Other questions for this witness? Seeing none, thank you, sir. Sandra Denoncourt, and next will be Pat Gloa.
Hi, good afternoon. Good afternoon, Mr. Chairman and committee members. Thank you for the opportunity to provide both written and oral testimony.
Can I just ask you to get a little closer to, yeah. Thank you.
You're welcome. Thank you for the opportunity to provide both written and oral testimony today in support of House Bill 88. I'm Sandra Denoncourt. I'm the Executive Director of the Joan G. Lovering Health Center in Greenland. The Lovering Health Center is an independent, nonprofit health center that's been serving New Hampshire citizens for over 42 years. We provide abortion care. In addition to accessible contraception care, sexually transmitted infection testing, treatment and prevention, and preventative health screenings, all of which are central to our mission. The Lovering Health Center is one of only 2 independent nonprofit reproductive and sexual health centers providing abortion care in New Hampshire. The second is Equality Health Center right here in Concord. After Roe v. Wade was decided 50 years ago, New Hampshire citizens were afforded affirmative legal protection that allowed advocates, medical providers, and healthcare centers like ours to develop a safe, effective, accessible, patient-centered, and evidence-based system of abortion care that has compassionately and professionally served your constituents for over 45 years as they make important personal medical decisions. I wanted to focus my testimony today on 2 considerations. The first is that RSA 329, sections 43 through 50, explicitly do not protect the right to abortion, as you've already heard. RSA 329, section 49, makes that clear in its very specific one-sentence text. Nothing in this subdivision shall be construed as creating or recognizing a right to abortion. I believe it's inaccurate and misleading for any person, lawmaker, or politician to say or imply that abortion before 24 weeks gestation is protected in New Hampshire. It is not. With the lack of federal protections as of June 2022, the time to provide protection is now. It is not inappropriate, in our opinion, to do this now as a House bill while considering the possibility of a constitutional amendment in the future. The second consideration is about the precedent that is set by RSA 329, sections 43 through 50. If lawmakers have determined that access to this medical procedure and access to an abortion is important enough to legislate with restrictions, then it must be important enough to recognize with legislative protection. I've heard lawmakers and other folks in this state insist that there is no intention to restrict abortion further in New Hampshire. Intentions and reassurances are not the legal protection that your constituents need and deserve. The Access to Abortion Care Act upholds New Hampshire values by putting into law that the state cannot further interfere in the right to access abortion. House Bill 88 also provides an enforcement remedy if that freedom is violated. This levels the legislative landscape by making it clear that New Hampshire protects abortion access up to 24 weeks. The June 2022 U.S. Supreme Court Dobbs decision makes it critical that New Hampshire actively protects the right to abortion for all citizens. Millions of Americans are already impacted by increased restrictions or bans since this decision, and there are bills proposed annually in New Hampshire that seek to further restrict abortion access and bills that seek additional interference in this private medical decision being made by your constituents and their healthcare providers. We ask you to vote ought to pass on House Bill 88. Thank you.
Thank you. Questions for this witness? Seeing none, thank you.
Thank you.
Pat Gloa, and then next would be the Reverend Allison Pat Gloa? Ah. Ms. Okay, here we go. Thank you.
My apologies for the delay.
No problem.
My papers want to go walkabout today, so I had to retrieve them. I hope that I have a stack of copies of this testimony to leave with yourselves. I just have to find it. They want to hide on me. My name is Dr. Patricia Gloa. I'm a board-certified family physician. I've been in practice in New Hampshire since 1980, and I've been affiliated with Dartmouth-Hitchcock Medical Center in Lebanon since 1995. I started out practice in the North Country in the Woodsville area. I have practiced full-scope family medicine, including 30 years of delivering babies, which was one of the high points of my life. I have also been an abortion provider for about 40 years, which has also been a high point in my life, feeling as I do that I'm saving women's lives by doing so. I have worked with women in all aspects of their experience of pregnancy. I also work in the areas of sexual violence, child sexual abuse, and domestic violence. I'm here to speak in support of HB 88 relative to reproductive rights. This bill is very important to protect the rights of New Hampshire's women. Any pregnancy is a major life event with lifelong consequences for the person involved. Pregnant people understand that carrying a child will also carry obligations for many, many years to come. It's not just about getting to the point of birth. It's about all of the mothering that's involved afterwards. In addition, they understand that the circumstances of pregnancy may result in them being unable to mother a child in a safe and loving manner. The person may have serious health concerns. They may have a very unstable economic and/or social situation. They may be involved in substance abuse or misuse, which could jeopardize a child's health during and after a pregnancy. They may not have a supportive partner. Indeed, they may be in an abusive relationship, which jeopardizes the child as well as the woman. They may have been raped or subjected to incest. They may be a student or a member of the military working to improve their life circumstances such that they could securely and happily support a child in the future. They may already have the number of children who they feel that they can support emotionally, physically, and financially. They may have children with special health needs that make it impossible for them to take on the responsibility of another child. They may be unhoused or even incarcerated. They may have experienced a failure of their contraceptive method. There are as many circumstances as there are pregnancies. Pregnant people need to be trusted to make the best decision for their lives and the lives of their families without interference or mandates from legislation. People want to be good mothers at the right time and in the right circumstances. I thank you for your time and consideration of this critical measure designed to safeguard the rights appropriate to our citizens.
Thank you. Questions for this witness? Seeing none, thank you, ma'am. Reverend Allison Palm, and next will be Jake Berry.
Thank you so much for hearing my testimony. My name is Reverend Allison Palm, and I am a Unitarian Universalist minister serving the Unitarian Universalist Church of Nashua, as well as a resident of Nashua. I'm here to speak in support of HB 88, the Access to Abortion Care Act. As a Unitarian Universalist minister, I firmly believe in the inherent worth and dignity of every person, and that each individual has a right to make decisions about their own body and their own life. This belief extends to the issue of abortion access. People who seek abortions, as you've already heard today, are often faced with difficult and complex situations, including financial hardships, health concerns, or unwanted pregnancies resulting from sexual assault or a coercion. No matter what the situation, all pregnant people deserve access to safe medical care without fear of shame or reprisal. My faith tells me that every body is sacred, including and especially those bodies that can carry pregnancies, and every person has a right to holy agency over their bodies. We are in a crisis moment when it comes to abortion access in this country. Since Roe versus Wade was overturned in June, abortion access has been chaotic and confusing. In this post-Roe world, Granite Staters deserve a law on the books that affirms their right to access abortion care and prohibits the state from further interfering with that right. My faith compels me to support bodily autonomy and freedom of conscience, and access to safe and legal abortion is essential to upholding those values. As a faith leader who cares deeply about the well-being of the people of New Hampshire, I urge you to support House Bill 88, the Access to Abortion Care Act, and protect these sacred rights here in our state. Thank you.
Questions for this witness? Seeing none, thank you. Jake Berry, and next will be Emma Zajano.
Good afternoon, Mr. Chairman, honorable members of the committee. My name is Jake Berry. I'm the Vice President of Policy at New Futures. As many of you know, New Futures is a nonpartisan, nonprofit health policy and advocacy organization. I don't want to repeat too much of what's been said here this afternoon, but I do want to emphasize New Future's strong support for this bill, HB 88, as well as HB 224, which you'll hear later today. Simply put, reproductive care, including abortion, is a critical component of overall health care. Access to abortion directly impacts the current health and future well-being of our women, children, and families. We believe it needs to be protected in statute. Data shows that women who give birth or after being unable to access abortion report more life-threatening complications like eclampsia and postpartum hemorrhage. They report more chronic conditions like headaches or migraines, joint pain, and gestational hypertension. Women who are denied an abortion are less likely to have the money they need to cover basic living expenses like food, housing, and transportation. And children who are born as a result of inability to access abortion are more likely to live below the federal poverty level. Poverty and other adverse childhood experiences are known to negatively impact brain development and can follow children throughout their lifetimes. In summary, abortion is a needed part of healthcare. No doctor or medical professional should be fined or penalized for providing these procedures, and women and families across our state should be able to rest assured that we are not looking to further restrict access to abortion in the years to come. For these reasons, we ask that you support HB 88 and as well as HB 224, and both ought to pass. And with that, I'm happy to take questions.
Thank you. Questions for this witness? Seeing none, thank you.
Thank you.
Emma I hope. I'm sorry, Emily Zajano. And then next will be Ovid Young. Yes.
Good afternoon, Chairman Lynn and honorable committee members. My name is Emily Zajano, and I ask you to support HB 88. I am a pediatric emergency medicine physician. My adult life has been dedicated to saving children's lives, but I could not save my own daughters. I had 2 abortions. My story is of my love and my heartbreak, but the value is in my body and my choices. This was my first pregnancy and very much wanted by my husband and I. We were shocked and thrilled when our first scan at 12 weeks showed 2 babies. However, the ultrasound also showed I had a uterine anomaly, a potentially life-threatening condition. The twins were in 2 different areas of my uterus. More studies suggested I was safe and we would have our baby girls. We chose names. I marked the date on my calendar when they would be 29 weeks and very likely to survive. At 16 weeks and 4 days pregnant, I woke up with pain that became sharp, severe. It hurt to breathe. I was ultimately sent to a Boston hospital. My husband and I sat in a dark room where monitors showed the ultrasound images, turned on during happy scans, turned off during the sad ones. They were off for ours. The news was worse than we could imagine. The left side was a previously unrecognized rudimentary horn, and the uterine wall had ruptured in 2 places. This fetus had no chance. My womb was literally broken. On the right side, the baby had a congenital heart defect, which would require surgery and functioning lungs to survive, if she could make it to viability in my broken womb. These findings changed everything. To save my life, I needed surgery, and one of my daughters inside needed to be removed. In surgery, they saved the unicornate uterus, and the fetus on the right was still there. But it was clear that allowing the pregnancy to continue would put me at a huge risk. For 2 weeks, I sat on the couch, tried to heal from surgery, and loved my baby as hard as I could. I grieved. We went to Boston for the appointment the next day, or the day before the DNC, the abortion. We were there for medical care. We were there to save my life. We were there because this was the most appropriate decision for our family. We were there because we needed to be there. My abortions saved my life. My abortions allowed me to have more children. My abortions allowed me to continue my work to save your children's lives. I appreciate that the legislature acted last year to add a fatal fetal diagnosis exception to the New Hampshire abortion ban. However, we also need to protect access to safe and legal abortion in New Hampshire state law. As a doctor and as a patient, I understand just how different every pregnancy is. Granite Staters and their medical providers need all options available to them. Please pass HB 88 and protect access to safe and legal abortion.
Thank you. Questions for this witness? Seeing none, thank you, ma'am. Ovid Young, please.
Did you say Dr. Young?
Dr. Young, yes.
Yes. Judge Lynn, it's a real honor to speak before you and your
Thank you for being here.
Committee. I want to say thank you for the work that you do. It's hard work trying to make our state better. My name is Dr. Og Young. I'm a retired obstetrician gynecologist who trained, practiced, and taught Dartmouth medical students for over 40 years in Concord. I'm the past president of the New Hampshire Medical Society, and I remain a member of the General Council representing the obstetricians and gynecologists in our state. I'm here testifying for the New Hampshire Medical Society. The majority of my colleagues, my past patients, and the majority of New Hampshire women to support House Bill 88. Politics obviously crept into our judicial branch of our democracy in June when the Dobbs-Jackson decision overturned Roe v. Wade, taking away the right of privacy in deciding about a woman's health, her fertility, and her future. The result is that now 1 in 3 reproductive age women do not have access to abortion in their home states. The inevitable result is that affluent women will continue to have safe abortions, crossing state lines if necessary. But marginalized and less affluent women will not have access to preventive services, and they will resort to unsafe abortion. I'm old enough to have seen the consequences of unsafe, illegal abortion performed by unskilled providers in non-sterile conditions. My first admission onto the gynecologic service as an intern almost 50 years ago was a young woman with a septic abortion. We gave her fluids, IV antibiotics, took her to the operating room, removed a foul-smelling uterus filled with pus, and 2 days later watched her helplessly die, leaving 3 motherless children at home. If my feelings about legalized abortion were ambivalent at that time, they have never been ambivalent after. The stark reality is that abortions are going to happen. They're going to take place. We cannot go back to the times where desperate women of limited means seeking unsafe pregnancy terminations is happening. Everything that we can do for women to give them control over their bodies and fertility enhances their health and makes our world a better place. We must protect the privacy of a woman and her care provider when it comes to pregnancy. This decision is deeply personal and very difficult, one that should remain the prerogative of a woman and her care provider, not to be usurped by lawmakers. I encourage you to join all of the other New England states, Vermont, Maine, Massachusetts, Connecticut, Rhode Island, by codifying abortion, protecting a woman's right to terminate a pregnancy. We must make it clear here in New Hampshire that we are a state that values privacy, that values freedom, that values individual decision-making by passing House Bill 88. Thank you.
Thank you. Questions for this witness? Yes, Representative Manos.
Excuse me. Thank you, Mr. Chair, and thank you for taking my question, Doctor. We heard testimony earlier today that the provisions in current law that penalize doctors and punish doctors are discouraging physicians from learning and becoming proficient in abortion and reproductive health care in New Hampshire. And I was wondering if the medical society, the New Hampshire Medical Society, had a position on that, or whether what you've observed in your long years of practice.
Well, first of all, emphasize that I can't speak for all members of the society. There are some physicians who are not in favor of abortion. But as a society, and remember Roe v. Wade was passed on this principle, all physicians respect the privacy, the private relationship between a patient and a physician. And so the society is supporting this particular bill. Now, you mentioned that we have fewer and fewer residents trained in termination of pregnancy, and you're absolutely right. It's a problem, and we're trying to address that problem. We don't ever make anyone perform an abortion who doesn't want to perform an abortion or even train to perform an abortion. But we're trying to address that particular issue.
Other questions for this witness? Yes, Representative Turin.
Thank you, Chairman. Thank you, Dr. Young. Given that all the other New England states have protections like this in place, and given your history running and participating in OBGYN practice as well as your role on the medical side, what are your thoughts in terms of whether or not having this provision in law puts New Hampshire at a difficult, I'll call it competitive advantage for attracting the necessary workforce?
Yeah. Well, as I understand it, abortion is legal in New Hampshire right now, but we don't have a law that says it's legal. I'm sorry. As I understand it, abortion is legal in New Hampshire, but we don't have a law that codifies that. It would be like making a law, making walking legal. We don't need a law to do that. But our feeling is that with abortion, it's a very controversial issue, and we do need a law to declare that it's legal, for women to know that it's legal, for physicians to know that it's legal. That's really why I think we have this Protection Act.
Other questions for this witness? Yes, Representative Greason.
Thank you, Mr. Chair, and thank you, Doctor, for your testimony. You had mentioned a concern that we might go back to, I think you referred to them as dirty abortions. I may be wrong on the terms, but the idea being back alley abortions, unsafe, coat hangers type.
Illegal, non-sterile abortion.
Yeah, exactly. Are you aware that in the years immediately preceding Roe versus Wade, that the same number of women died during abortion procedures by licensed medical professionals as unlicensed medical professionals?
Well, I can tell you that the World Health Organization reports that there are 22 million unsafe abortions per year in the world. It's probably underreported. And I can tell you that there are hundreds of thousands of injuries because of these unsafe abortions and tens of thousands deaths because of unsafe abortion. You've ever performed an abortion, you know it's not a simple procedure, and having a sterile environment is extremely important. I can't imagine that there wouldn't be a much higher rate of complication and mortality if we just have back alley procedures.
Other questions for this witness? Representative Perez.
Thank you. I have a question since this is your expertise. What do obstetricians now consider perhaps a viable fetus? At what age is a fetus? I know it depends. There's a lot of things. I was in the medical field. But I know in the 1990s, when the law was changed, it was 24 weeks, and that's where all the 24 weeks have come from. But that was a long time ago. What is considered perhaps a viable fetus in today's medical world?
It's a moving target. When I was a resident, we saved a few 28-weekers. Now we're actually saving a few 24 to 25-weekers. Before 24 weeks, we're certainly not saving a baby.
All right, other questions for this witness? Seeing none, thank you very much, Doctor. Next, I'm going to call on Patricia Mullen, and next will be Anya Morehouse. Great, thank you.
Hello. Hello. My name is Patty Mullen. I'm a resident of Sunapee, New Hampshire, and I am here to support House Bill 88. I'm going to ad-lib a little bit. I guess for me personally, as a woman who is obviously past the age of having to deal with pregnancy, I think about my daughter and other women. And as I see this nation chipping away day by day by day the rights of women, I am more and more aware of how important it is that we do everything we can to enshrine whatever rights we have left. So although my story isn't exactly in relationship to this House bill, the reason why I'm here is because of my own feeling of the necessity to make sure that women in this state feel safe and that they know that there is a statute that will take legislation to chip away at it rather than to continue to chip. So this is my story. My mother had 4 daughters. My sister Deirdre, 18 months later, I arrived, considered an Irish twin. 7 years later came the twin girls. My father was an alcoholic abuser and a traveling salesman. 3 months after the twins were born, my mom discovered my father had 2 other wives. The next few years found us on welfare, living in the projects, and once the 5 of us were homeless. Mom remarried when I was 11. She married a New York City fireman with a shield, not a badge. In New York, it's a shield. And I express that so that you understand how little I was protected because this New York City fireman had a shield. I do not say his name. I call him the evil one. The evil one bought a nice home and moved the 5 of us in. The 4 girls spent the rest of our childhoods being raped, beaten, emotionally, mentally, spiritually, and intellectually tortured. We would call the police. He had a shield. My sister died from suicide this past July, my Irish twin. She was a brilliant woman, graduated from Fordham as an adult with her MSW and a 4.0 average after raising 3 brilliant children. Deirdre started having memory issues at 62. It turned out Deirdre had multiple traumatic brain injuries. The dementia was rapid. She hated losing her mind. The evil one used to grab us by our hair and bang our heads against the walls of the floor. If we were on the floor, he would kick us with his steel-toed fireman boots. I have had a baseline MRI to check my brain. Deirdre died from the beatings. My sister Deirdre tried to protect the three of us. She saved my life when I was 16. My period was 2 weeks late. I was terrified. I was always terrified. I told Deirdre, and she took me for a urine test. By now, I was 3 weeks late. In New York, abortions were legal prior to Roe v. Wade. I found out I was pregnant at 8 weeks. Her first words to me were, "Jesus Christ, Patty, if he finds out you are pregnant, he's going to beat you to death." I knew this was literally the truth. We scheduled an abortion. It would be 2 weeks. Those 2 weeks were the longest weeks of my life. By the time I had my abortion, I was 10 weeks pregnant. Everyone in this world has their own personal reason to choose abortion. My reason was abject fear of being beaten to death. The freedom to choose saved me. One of my therapists once told me, in 30 years of practice, my childhood was the worst she ever heard. I am here today speaking to you only because I had an abortion. If you think I am overly dramatic for any reason, just think of my sister who died from multiple brain injuries this summer. I have a daughter now, a beautiful, educated, kind, and generous young woman. I cannot fathom why she should be denied access to the reproductive health care that literally saved my life. I knew what was best for me at 16. No one was protecting me. The choice I made was the first time in 16 years that I was actually able to protect myself. Access to abortion must be available to women. Each of our lives and circumstances are different, but no matter our reason, each of us must have access to abortion personally, behind closed doors, free from government intrusion and interference. No one else knows our stories. None of you knew me or what was best for my life. Reproductive rights saved my life. Abortion saved my life. And if this bill is not passed, we run the risk of continuing to chisel and chisel and chisel. And maybe someday some woman will get beat to death. Thank you for hearing my testimony.
Thank you. Questions for this witness? Seeing none, thank you. Anya Morehouse, and next will be Jason Hennessy.
Good afternoon. My name is Anya Morehouse, and I'm a student in Sullivan County. The proposed House Bill 88 states, because it is vital to the equality and liberty of all individuals, the state shall not restrict or interfere with an individual's exercise of their private decision to terminate a pregnancy, except as in provided in RSA 329.43 through 329.50 and RSA 132.36. I would like to focus on the blatant hypocrisy and disparagement toward women implied in the phrase, vital to the equality and liberty of all individuals. The very wording used here implies that abortion is necessary for women to be free and equal to men. Nothing could be more belittling. There is an assumption behind this way of thinking that equality lies in what we do rather than who we are. Women are equal to men in that they are endowed with intrinsic dignity and worth. Preborn babies are equal to already born men and women in that they are endowed with intrinsic dignity and worth. women cannot be viewed as equal on the condition that they have the option to kill their preborn child. Preborn children cannot be viewed as equal on the condition that they are wanted or convenient. If House Bill 88 is passed, New Hampshire will not only promote the violence and barbarity that is abortion, but promote a misogynistic and discriminatory agenda that tells women the only way they can succeed is through ending the life of their child. Rather than make this a reality in our state, I urge you to focus your efforts on creating an environment here where women facing unplanned pregnancies are supported and given the means necessary to lead successful and fulfilling lives without abortion. Reject this bill and promote bills that truly uphold the dignity of all, the equality of all, and the liberty of all. Thank you.
Thank you. Questions for this witness? Seeing none, thank you. Jason Hennessy, and next will be Devin Quinn.
Hello, my name is Jason Hennessy, and I'm here again as the president of New Hampshire Right to Life. We oppose this bill, HB 88, for two main reasons. The first one is that in our analysis, this is essentially a meaningless virtue signal. So I'm humbled to be surrounded by accomplished lawyers here. I only took undergrad civics, but in my undergrad civics class, we were told that a legislature cannot bind a future legislature other than through the Constitution. And so if you pass HB 88, any future legislature can just repeal it. Alternatively, if the legislature decides to keep it, what it'll mean is that all the pro-life bills will then be more difficult, will be more longer, because they'll all contain a clause that amends the exceptions to add itself into there. So in terms of protections for abortion rights, this doesn't do that, as far as we can tell. From the second point, I guess just to bring that back a little bit more, I actually didn't hear any examples from anybody of cases that they would think that this would get you anything, whether it's lawsuits against the government or something like that. I didn't hear any strong examples. The second one is the subject matter itself of abortion. Throughout most of history, abortion has been seen as being something bad. It's in the Hippocratic Oath. It's in almost every major religion throughout history. And so at this point in stage, what we'd be saying is we want to enshrine something that most of history and most religions say is evil, the killing of an unborn child. So is that the thing that we want to leave? Is that the legacy that we want to leave to the people who come later? So as I mentioned before in the testimony, over 70% of New Hampshire agrees with abortion restrictions at some point. This legislation does not reflect that consensus here. One of the things I wanted to address is that if there's any confusion of rights, of where abortion rights are, when abortion's legal, when it's not legal, I would suggest a web search. While I was sitting over there, I just did a search of abortion laws New Hampshire, and some of the top hits, like Planned Parenthood and Wikipedia's website, say things like abortion remains safe and legal in New Hampshire, or abortion in New Hampshire is legal up to the 24th week. So if there's any confusion, Google's your friend. And that is the rest of my testimony. Thank you, Mr. Chair.
Thank you very much. Questions for this witness? Representative Horgan.
Just very quickly, I mean, I'm not a lawyer either, but your point about not binding a future legislature, but doesn't this also apply to acts by state government that aren't specifically authorized by by one of those two, by an RSA? And I don't know whether or not you think that's implausible, but I think am I wrong in thinking that it's plausible that the state might do something to restrict rights, even if it's not specifically authorized by either of those two RSAs, that it might go beyond So in your experience, does the state ever go like beyond what appears to be specifically authorized by the law, or do they always like stay colored, like stay totally within the lines of the law?
Thank you, Representative. I'm not completely sure I understand your question. Is it along the lines of could an agency through rulemaking or something restrict rights or something like that?
Yeah, I think so. But I think, is it possible? Do you think so you're saying it's unlikely the state would ever take any action to restrict the laws unless we specifically passed an RSA authoring to them, or is it conceivable the state might, do things that aren't specifically authorized by the RSAs?
So I'm not a lawyer, Representative, so I'd have to defer on that.
All right, other questions for this witness? Whoop. Yes, Representative Perez.
Thank you. Now I'm completely confused. So, when this bill was presented to us, I specifically asked if this bill would prohibit us at a later time from changing the RSA. And I was told blatantly, no, it would not. But then I have heard testimony after testimony saying, or at least what I'm hearing, is that if at any time we wanted to lower the limit of 24, we wouldn't be able to do this. So now I'm confused and I want to hear the other side of the story. I do not want anything I'm asking if doing this is going to legally or protectedly going to limit the legislature from changing the present bill without having to completely eliminate it and start all over again.
Thank you, Representative. My understanding is that you can't bind a future legislature without a CACR. That you can't prohibit a future legislature from amending any law without a constitutional amendment.
Other questions for this witness? Seeing none, thank you very much.
Thank you, Mr. Chair.
Next, I'm going to call on Devin Quinn, please.
Okay. All right. Thank you.
Good afternoon, Chair and members of the committee. My name is Devin. I'm the Devin Quinn. I'm the Director of Policy for the New Hampshire Women's Foundation, where we invest in equality and opportunity for the women and girls of New Hampshire through research, education, advocacy, and grant making. And the Women's Foundation very much supports HB 88 because access to a full range of reproductive health care, including abortion, is crucial for women's health, economic security, and long-term impacts on women and their families. Deciding whether and when to have a child is the most consequential decision relative to women's lifetime economic well-being. Women who have access to abortion have higher rates of high school and college graduation. They can invest in school and job training, increasing their long-term earning potential. And the intergenerational impacts of to previously born children or subsequently born children lower their rate of poverty, increase their high school graduation rate and college attendance rate. And access to care, to abortion care, is critical to disrupt the cycle of poverty between generations. So I also sent around my testimony, but also a colorful sheet that we put out this past summer that goes around, that covers the background on New Hampshire's legislative actions on abortion. It goes over information on care in the state and comparative policies in New England. I hope it's useful to you for any abortion-related legislation you see at this session. But I also presented this handout to providers over the summer, right after the Dobbs decision, and they found it very helpful because they were sharing stories with me that right after the Dobbs decision, they had a lot of questions from their patients. They shared that they had patients asking if they would have to remove their IUDs. And they said, of course not. IUDs are long-acting reversible contraception. But there was a lot of patient confusion, particularly last summer.
And they also had questions, of course, about their access, about patients' access to abortion. And so I was hearing a lot from providers that they were doing a lot of education on what their rights, their patients' rights were in New Hampshire. And I think that providers and patients and everyone in New Hampshire would appreciate and deserve to know that New Hampshire will protect the right to safe and legal abortion amid a rapidly changing landscape in the country. I know that there have been questions for an example or a situation that would occur when this affirmative right that we're seeking to establish in HB 88 would be theoretically enforced. And of course, these are theoretical ideas, but one example that we had discussed previously might have been if a state trooper sees someone driving into a clinic, an abortion provider, and sees that they have Texas plates or Florida plates or any other plates, and they are confused because other states have different laws, and they prevented that person from entering the clinic. That might be an example. This is theoretical. But what we're saying is that it is so important to be clear about our own laws because there really is no federal framework anymore. It's up to the states to decide, and we should be very clear with New Hampshire about where we stand on abortion access and rights.
Thank you very much. Questions for this witness? Seeing none, thank you. There's one more person who signed up on HB 88. That's Representative Potenza. Representative Potenza.
Thank you, Chair. Representative Potenza, Stratford District 19, Rochester's Wards 1 through 4 and 6. Listening to the testimony, I'd just like to clarify a couple of things. The laws of the land are founded upon the Constitution of the United States. In New Hampshire, our Constitution came first. So our New Hampshire laws come first and the federal comes second. In regard to overturning Roe versus Wade, just because there was so much testimony on that, this is following the Constitution and giving rights back to where they should have always been, where those rights originated from. The Constitution does not prohibit the citizens of each state from regulating or prohibiting abortion. Roe and Casey seized that authority. We now overrule those decisions and return the authority to the people and their elected representatives. Abortion is not healthcare. Abortion is an elective procedure. Abortion is a choice. If a woman decides to take the life of her 1 to 6 month old baby, that is her choice. And that choice is legal in New Hampshire because that is our New Hampshire law and what our constituents have accepted, what their representative body have passed. Listening to the heart-wrenching testimony here, I want to be clear. Terminating a pregnancy based upon rape or incest or any other horrific reason would never be against the law in New Hampshire. I know that. Terminating a pregnancy if a woman's life is in danger, the life of the baby or a fatal anomaly is considered health care. That's the difference. Based upon the most recent information gathered from the Center for Reproductive Rights, there are only 10 states, 10, that have state laws that protect abortion. If we want anything codified into law, do it the right way. That's through a CACR. On a side note, I was actually a patient of a doctor that testified here today when we lived in Concord. He used to wear a button that said, "I love women." He was a fantastic OBGYN. I loved him. But I'd like to correct one thing that he stated when he was in his testimony. He said he represents women in New Hampshire. We need to be clear that he only represents a portion of women in New Hampshire. Thank you.
Thank you. Questions for this witness? Seeing none, thank you. Is there anyone else who wishes to testify on HB 88? Seeing none, I'm going to close the hearing on HB 88 and open the hearing on House Bill 224, and I will call on Senator Sue Prentice, please. Oh, okay, I'm sorry. Yep. I'm sorry, we have Representative Wolf. I'm sorry. Did you fill out a card? Did you fill out a card? Fill it out later.
I apologize, Mr. Chairman. I
Fill it out
forgot
later.
to,
Don't worry about it.
there's a blank one right there for you,
I got
Representative.
one right here. Thank you.
224.
224. Great. Thank you very much. Thank you.
Thank you, Mr. Chairman. I didn't know I could screw it up before I even started.
No, don't worry.
Thank you, Mr. Chairman, and thank you for members of the Judiciary Committee. House Bill 224. This bill does nothing to make abortion any easier in the state of New Hampshire. It may clarify the law only. The 24-week time frame still stands. House Bill 224 repeals only the criminal penalties that were inserted in the Fetal Protection Act as part of the budget passed in 2021. These penalties include a possible felony conviction with a jail time of up to 7 years, as well as a fine of $100,000. These are charges which no other medical procedure inflicts on a doctor. A doctor acting in good faith and following the Hippocratic Oath would constantly be second-guessing his or herself. Could this uncertainty cause a doctor to not act immediately as would be prudent? Saving the life of a pregnant woman should be able to be done without any other thoughts clouding one's mind. And I want to point out a recent case in Texas that highlights the uncertainty that makes treating a pregnancy that has gone awry and the potentially fatal consequences that can follow. In Texas, a young woman's water broke, and she and the doctors knew that the baby would not survive. Yet, as the baby still had a heartbeat, they were unwilling to perform an abortion. 3 days later, the woman had chills, her temperature rose to 103. Finally, the doctors agreed and felt safe that they could legally perform an abortion. 12 hours after the pregnancy was terminated, the woman came down with sepsis. Intense medical intervention barely saved the mother. And I ask you, would you want this to happen to you? Or would you want your doctor to do what he or she is trained to do and to protect the mother's life? Very simply, for these reasons, I urge this committee to recommend that HB 224 receive a vote of ought to pass. Thank you very much.
Questions for this witness? Yes, Representative Greason.
Thank you, Mr. Chair, and thank you, Representative. How does current law define a violation of the law that could be prosecuted? And how does one prove that a violation has occurred when there's no way of proving the age of the baby? And how many prosecutions have actually occurred since this law became the law?
I think those were three questions.
I was going to say, it sounds like three questions, but we'll allow it. We'll allow it. Go ahead.
I'm not sure about prosecutions. I haven't gone into that. All I know is what I have been told by doctors in the field. I know following me is going to be Matthew Hood from Dartmouth and Dr. Cass, who's head of OBGYN up there, who can tell you about some of those things. I know that at one time we wanted to have some statistics, and we could never get anybody to agree on that, so I can't tell you the answer to your question.
Other questions for this witness? I guess I do have a question, Representative. As I think you and I had discussed in the hall yesterday,
The elevator rides have been too short.
The the statute for the criminal penalty says that liability for being guilty of a crime is if you act knowingly. And so I guess I have some difficulty understanding why with that caveat in there that limits, in other words, if there's some question that the doctor has not acted knowingly, that then there's not a basis for prosecution. But in other words, if a doctor does act, in other words, a doctor knows there's no question that this fetus is over 24 weeks old, and there's no justification, in the terms of life or health of the mother, or that kind of thing, fetal abnormalities, and the doctor performs the abortion anyway. I guess I am troubled with the idea that the doctor should not be subject to criminal penalties in that circumstance.
I think the issue that you raised, Mr. Chairman, is that it raises a cloud. And there's a cloud out there that may occur. And as I stated in the Texas case, it may delay proper medical care. If it can be proven that it's knowingly in violation, I don't have a problem with that. But let's have the medical procedure proceed without knowing that situation. Does that make any sense to you?
Well, I mean, I guess what I would say is I understand that obviously there could be circumstances where this could become a question. Did the doctor really know? What were the I completely understand that. But I guess the thing I'm trying to distinguish this from the example that I gave you when we talked. It's perfectly legal for doctors to prescribe narcotics for appropriate use, but it's not legal for doctors to do that if they're actually acting as drug dealers. And there have been, many, many cases in which doctors have been prosecuted for that. And it is often the situation in those kind of cases, and I know because I've had some of them myself many, many years ago, that there will be a question. The doctor will say, well, there'll be an issue. Was the doctor really acting within the scope of his practice, or was he being a drug dealer? And those can be complicated, but I'm not sure how they are all that much complicated from the circumstances you're talking about here.
You've raised an interesting question, which I don't have an answer for, except to say that I think a doctor acting in good faith would not want to have that sword hanging over his head.
Thank you. Other questions yes, Representative Stapleton.
Thank you, Mr. Chair. Thank you for taking my question. May I assume from the tenor of this bill that you or co-sponsors are not opposed to the 6-month restriction, but only the penalty?
Yes, or I don't know whether that's a yes or a no, but I'm willing to live with the 6-month restriction. I think it's a reasonable restriction. I know some of my people, including my wife, disagree with me, but I think we've found a compromise.
Yes, please.
Then may I ask, how do you enforce the intent of the Fetal Life Protection Act by withdrawing penalties and making an open choice to observe or not?
You have a law on the books that says you can't do something. There are other ways to enforce the penalty, whether it be a loss of medical license or something like that. But I think a jail term for a doctor, a fine of $100,000 for a person that is acting in their best interest, and the best interest of the mother, is enough of a penalty, enough of a threat.
Thank you.
Thank you. Other questions for this witness? Seeing none, thank you, Representative.
Thank you.
Thank you. Senator Sue Prentice. Senator, thank you for coming.
Thank you, Chair Lynn. Good to see you this afternoon, and members of House Judiciary. I know it's been a long day, so I will. My comments will be brief and hopefully to the point. I'm going to frame my testimony or focus it around really access, the gaps in maternal care that already exist in New Hampshire and that are growing in New Hampshire, and what a law like this on the books could continue to do to harm that situation. So for the record, my name is Sue Prentice. I'm a state senator from District 5. I represent 15 communities, large part of Grafton County, part of Sullivan County, and one town in Merrimack County. And I am here today speaking in support of House Bill 224, and I appreciate that Representative Wolf has filed this legislation. So as you know, and he has already said, but it's worth repeating, that this bill would remove the criminal penalties that are now in place for performing an abortion after 24 weeks. And those penalties are, it's a felony, it's a $100,000 fine, and a prison sentence. And as Representative Wolf said, this is the only medical care practice or part of the medical profession that actually is subject to these kinds of provisions and penalties. So when we were debating this in 2021, I heard from a number of healthcare professionals, and I actually took a quote out of a letter that we received that were signed by 200 New Hampshire healthcare providers that I want to share with you. New Hampshire already struggles to retain medical care professionals, and we are deeply concerned that these criminal penalties will undermine the state's effort to recruit and to retain clinicians. So, New Hampshire already has a shrinking population of obstetrical care providers. And I had the honor of serving the state of New Hampshire as the Chief of Emergency Medical Services at your Department of Safety for close to 10 years. And during that period of time, we started to see this shrinking population of obstetrical care providers, which was predominantly at that time in the North Country. So I teamed up with nurse midwives and obstetricians and other emergency medical service professionals, and we went into these areas. And what we did is we picked the areas that there was no maternity care unit present, but that doesn't mean that there aren't pregnant women in those communities and that an obstetrical emergency could actually take place. So we went up there and we trained them to manage the situation that was before them without the adequate type of backup that they really need, because again, this population has shrunk. At that time, I thought it was only a rural problem, but what I can tell you now is that this is not just a rural problem, that this is impacting suburban areas in New Hampshire as well. We have 26 acute care hospitals in the state. In the last 20 years, 10 of them have closed their birthing units. The 10th is actually in Derry, New Hampshire. Good afternoon, Representative Tripp. Good to see you. And we have an 11th that is planning to close its doors over on the seacoast. So that's a pretty significant number in shift of obstetrical care professionals and services that are available. And again, my concern is our pipeline in terms of the workforce and bringing more obstetrical care providers to take care of our moms and our babies and their families in New Hampshire. So, just a few other points. I learned from an obstetrician, a high-risk obstetrician at Dartmouth Health during the first time we were debating this in 2021, that they had a high-risk practice in Bedford, New Hampshire. Again, a more, not considered a rural area of the state, and that it took them close to 2 years to recruit a high-risk obstetrician and neonatologist who would be taking care of moms, and while they were pregnant, and that women from where I live, which is in Lebanon and Hanover and other parts of the Upper Valley, were rotating and covering that practice so that these women could still receive care. So I know that that particular situation has been remedied, but it doesn't mean it isn't going to continue in the future. I know that New Hampshire trains at a minimum 4 OBGYN residents per year. And certainly, we'd like the folks that we train to stay here and take care of our New Hampshire patients. So the big question is, will they think twice about this now? Will they seek positions elsewhere because of these criminal penalties that are going to come in between them and doing their job? So that's certainly a conversation that is happening, and I can't tell you that has impacted this recruitment already, but this is not even, what are we, 2 years old? This happened in my first term in the Senate. My greatest fear could become a reality, and that's that we won't, as I've said, be able to fill these important roles and provide access to obstetrical care in New Hampshire. Why would you want to work in a state that would prosecute you for caring for a woman in that most, and her family, in that most critical time? Criminalizing healthcare providers for providing compassionate care that's in line with their medical expertise, and the best interests of their patients is why I can consider it to be cruel and to be regressive and could have chilling effects in the long term here in New Hampshire. And we critically need to have a solid framework and infrastructure for obstetrical care providers. That's what's at jeopardy here. So I urge you to support HB 224 and to do the right things. Do the right thing for our healthcare providers and for the families, the women that they take care of. I support ought to pass. I'm happy to answer any questions that I can, and if not, I know that Representative Wolf has answered some, and we do have some other professionals and experts here that might be better suited. Thank you, Representative Lynn.
Thank you. Questions for this witness? Representative Turner.
Yeah, thank you, Mr. Chairman, and thank you, Senator Prentice, for your testimony. As a former head of the state's EMT, in situations late-term pregnancy, if it were to arise, I know there's been testimony that this, from a practical standpoint, doesn't happen, at least on a routine basis. How much time would be available to a provider in certain circumstances to make that decision about what needs to be done in the later stages of pregnancy if situations arise, and how clear would it always be?
Thank you for your question. That's hard to answer. I mean, it could be moments to minutes to more, but what we are putting in between them and their decision making is a risk manager, or the thought of what they might have to do, what criminal penalties they might suffer for doing their job. So I can't answer exactly, but thank you for the question.
Other questions for this witness? Yes, Representative Perez.
Thank you. I have a concern in the fact that this not only repeals criminal penalties, but it also repeals any civil penalties. For example, if a doctor performed an abortion on a minor and the mother didn't give permission, or if something happened during the abortion that the mother would not, the person having the abortion would not have the opportunity to provide any civil suit. So taking away criminal and civil penalties, I think, makes this kind of a red flag for me. Can you tell me why the civil is in there? And if that civil are my fears right, that it could take away the right for civil suit?
I'm actually going to defer that question to Matthew Hood, a former state senator, the government relations director for Dartmouth Health. Okay. Thanks, Matthew.
All right. Other questions for this witness?
Thank you.
Yes, Representative Stapleton.
Thank you, Mr. Chair, and thank you, Senator, for the detailed rationale and itemization of your argument. I have a question. If the intent of the Fetal Life Protection Act is to protect that viable life at a certain point going forward from the 24 weeks. And that right of life is violated by taking that life. Should there not be a penalty to prevent or caution people from stepping over the line and taking that life which the law intends to protect?
Good to see you, Representative Stapleton, and thank you for the question. So here's what I know. According to the Centers for Disease Control, less than 1% of pregnancies are terminated after 24 weeks. These are mothers and families that have named their children, that have painted their nurseries, and are preparing to bring this life into the world, but they are met with a circumstance, an unforeseen, critical, devastating circumstance that's put them in that position. So I just want to frame it in, this is not taken lightly, and it's not a matter of, I'm going to proceed forward because I can. I'm going to proceed forward because there's a situation that my medical care provider and I are talking about and need to make a decision on because my life, the child's life are in jeopardy. And I think it's important to keep in mind in the whole conversation that this is a very small percentage, which tells you how seriously not just providers, but the women and the families take these situations. Thank you, Representative.
Thank you. Other questions for this witness?
Good to see you.
Seeing none, thank you very much. Next, I'm going to call on Dr. Tom Sherman, former senator. You had to leave? Okay. All right.
He does have testimony.
I was going to submit. All right, great. All right, then next I'm going to go on to Danielle Pimentel, and the next witness after that will be Allison Bodell. Ms. Pimentel.
Good afternoon once again, Mr. Chairman and members of the committee. My name is Danielle Pimentel, and I'm with Americans United for Life. And today, in my last testimony that I'm presenting to the committee today, I urge the committee to oppose this bill because it will allow abortion providers to escape legal culpability for their illegal abortions that result in life-threatening complications to women. Repealing the civil and criminal penalties prevent New Hampshire women from seeking justice under the Fetal Life Protection Act if they've been harmed during an abortion. New Hampshire has a legitimate interest in protecting maternal health and safety, as noted by the Supreme Court in Dobbs. Yet HB 224 directly contradicts with the state's interest to safeguard pregnant women because it removes common sense protections for their health and life. For example, the bill removes criminal and civil liability for abortions in violation of the Fetal Life Protection Act that result in harm or death of pregnant women. And as I stated in earlier testimony, we know abortions carry a higher risk or higher medical risk when done later in pregnancies, and that many women suffer complications. So if a healthcare provider performs an abortion after 24 weeks gestation or fails to perform an ultrasound in violation of the Fetal Life Protection Act, that provider is subjecting a pregnant woman to numerous life-threatening health complications and potentially death. However, if HB 224 is passed, women cannot maintain a lawsuit under the Fetal Life Protection Act against abortion providers who performed an illegal abortion and again potentially caused them harm, physical harm, or resulted in their death. The bill also eliminates women's protections against psychological injuries from abortion. Under the Fetal Life Protection Act, a woman can seek monetary damages for both their physical and psychological injuries. And this is an important remedy given that pregnancy loss, whether that it's natural or induced by an abortion, is associated with an increased risk of mental health problems. And scholarship shows that the emotional reaction or grief from losing a pregnancy or experiencing a pregnancy loss due to an abortion can be prolonged, afflict mental health, and impact intimate or parental relationships. So abortion causes grave harm to women's mental health. However, HB 224 incentivizes abortionists to completely disregard the impact that an abortion may have on a woman's mental health being well-being by eliminating civil liability for psychological injuries arising from, again, illegal abortions under the Fetal Life Protection Act or from failing to provide an ultrasound in accordance with the law. The criminal and civil penalties under the Fetal Life Protection Act are some of the last remaining regulations in place to protect the life, health, and safety of women who choose to have an abortion in New Hampshire. And the Fetal Life Protection Act does not penalize doctors from compassionate care, as you may have heard earlier. It penalizes them for performing illegal abortions after 24 weeks that result in life-threatening complications to women. If this bill is passed, New Hampshire may become a safe haven for abortion doctors that take advantage of that. And for these reasons, I urge the committee to oppose HB 224.
Thank you. Questions for this witness? Seeing none, thank you
Thank
very
you.
much. Allison Bedell, and next will be Courtney Reed.
Afternoon. Oh, good afternoon. Nice to see you all back after lunch, right? I'm asking you to please don't repeal the Criminal Penalties Act. One thing that I didn't mention this morning is, in my morning's presentation, is that a baby's heart begins to beat at 18 days. That is 5 weeks after the mother's first menstrual period. The mother doesn't even know she's pregnant. Now, correct me if I'm wrong, if one person uses an instrument to stop the beating heart of another, what do we call that? Anybody? I think we'd call that murder. So now I ask you, how different is this from abortion, especially in late-term abortions? So I ask you, please, don't repeal the criminal and civil penalties from the Federal Fetal Protection Act.
Thank you very much. Questions for this witness? Seeing none, thank you. Courtney Reed, and next will be Julia Stute.
Thank you again, Chairman and members of the committee. I just wanted to provide a brief statement of support on behalf of the American Civil Liberties Union for HB 224, which we've heard would repeal the criminal penalties from New Hampshire's current abortion ban. I want to start off by making clear that abortion is healthcare, not a criminal activity, and that criminalization of abortion results in poor health outcomes. Abortion is an extremely safe component of comprehensive reproductive health care, and medical societies like the American College of Obstetricians and Gynecologists has expressed that abortion is an essential component of women's health care. But moreover, physician advocates and medical ethics experts have noted that laws similar to the existing criminal penalties in New Hampshire often require healthcare professionals to deprioritize the pregnant individual or act in ways that might be medically harmful, because instances where criminalization of abortion is only lifted for medical emergencies or risk of death, these narrow definitions that are in current statute have been described as vague for reproductive healthcare providers to interpret, which has often left physicians feeling cornered into limiting care or requiring a continued deterioration of a mother's health before an abortion is deemed as medically necessary. Moreover, imposing criminal penalties creates an unnecessary barrier to abortion access. According to the Journal of Family Medicine, laws that directly criminalize abortion providers discourages both capable providers and future clinicians from pursuing the practice of abortion care, which we've heard in statements earlier today. In fact, in 2021, when the abortion ban was introduced, we heard physicians and medical doctors express that these criminal penalties evoke fear that they might not be able to offer the best care to their patients. And it's already difficult to recruit physicians and other practitioners in rural states like New Hampshire. And in fact, a recent study of pre-med students found that how states respond to Roe's overturn will significantly impact where they choose to attend medical school. After the pandemic, New Hampshire's primary care and health professional shortage has been deemed as catastrophically staffed,
And legislators should affect policy that attracts healthcare providers to the granite state, not inspire fear through criminalizing healthcare services like abortion. Moreover, the current law singles out qualified providers capable of performing abortions later in pregnancy. The criminalization of abortion providers represents one of many politically motivated tactics to further restrict access to abortion, and these current penalties embolden individuals that seek to intimidate abortion providers further. Our law is a slippery slope and is an invitation for further harassment against these medical professionals and should be removed. And lastly, I'll leave it with polling data that's expressed in 2021 that 66% of Granite Staters have shown support for keeping abortion legal in all or most cases. So I encourage the committee to pass HB 224 and get rid of this ambiguity that obstructs quality care. Thank you.
Questions for, excuse me, questions for this witness? Oh, yes, Representative Tripp.
Thank you for taking my question. Are you aware that New Hampshire is a Dillon's Rule state?
I'm sorry, could you repeat that?
I said, are you aware that New Hampshire is a Dillon's Rule state?
No, thank you.
Oh, you're not a lawyer?
I'm not a practicing attorney now.
Oh, all right. Well, anyhow, in a Dillon's Rule state, typically what is not permitted is prohibited, which would mean that since you need to have, oh, I'm on the wrong bill. I'm sorry.
Yes, Representative Stapleton.
Thank you, Mr. Chair. Thank you for taking my question. We back out the penalty in this law. What kind of precedent does that set? Losing the penalty deterrent to other laws that protect some of the many people that your organization defends and supports.
Sorry, I think I only got half of that question. Would you mind repeating it?
The question focuses on the precedent that we set by backing out penalty, civil and criminal, but especially criminal, from laws that we have widespread in our body of law that are enforced and protected by, and a deterrent by virtue of the penalties that are listed.
Yeah, thank you for your question. The ACLU has taken a stance of supporting this law, as the medical community has noted that its vagueness has often led to tough decisions that obstruct their ability to best provide quality of care. And since I'm not a practicing attorney, I'd love to correspond with you further and get the advice from our legal counsel that we do have. Thank you.
Thank you. Other questions for this witness? Seeing none, thank you.
Thank you.
Julia Stute, and after her, Omer Ahern.
Good afternoon. My name is Julia Stout. I'm a resident and student from Sullivan County. House Bill 224, which would repeal the criminal and civil penalties from the Fetal Life Protection Act, is a senseless bill which I strongly oppose. Section 329(46) of the Fetal Life Protection Act, which would be repealed by this bill, says that any healthcare provider who knowingly performs an abortion after 24 weeks would be guilty of a Class B felony. What is the point of a law that is not upheld and the criminal penalty not enforced by our judicial system? These so-called healthcare providers, which should more honestly be referred to as abortionists, are not providing necessary and life-saving treatments to pregnant women. Rather, they are taking innocent lives and putting pregnant women at risk of serious health complications. These abortionists, many of whom are working in facilities with the specific purpose of performing abortions, should be held to the same standards of the law and its penalties as any other criminal would. Not only do these abortionists totally violate a human being's dignity and unalienable right to life by performing an abortion, but by doing so after 24 weeks gestation, they are also in violation of the Fetal Life Protection Act. These abortionists should be prosecuted to the full extent of the law, and in order for that to happen, House Bill 224 must be voted down.
Thank you. Questions for this witness? Oh, yes, Representative Testerman.
I'm sorry, I didn't hear the first half of the question.
My fault. We'll get this right, yeah.
Mine.
Okay. You stated some relatively strong reasons for getting rid of the bill, particularly in its current form. And a lot of those are based on the fact that many of the penalties or the injuries done were done in the background or wherever, but they were done by the doctors, but they seem to be relatively general kinds of things. Do you have the facts on those, some written facts of how many of each of those and what you're basing your argument on?
I'm not sure if I'm understanding you correctly, but I don't have any data or statistics with me today to present to you all. I do know that any abortion that takes place after 24 weeks or that is in violation of the Fetal Life Protection Act, which would go against the life of the mother or fetal abnormalities, I believe any abortion that takes place against those protections is wrong.
But do you have any exact cases of it? I hear the wording and so on, the generalities, but I'm not sure if those are facts taken from cases that you read about or if they're just generalities.
I'm not sure which specific part you're referring to. I know that any abortion that is, like I said, performed after the 24 weeks gestation would be against the life of the mother. I know that would be
But do you have
against
a case?
the criminal.
Do you have a case
law.
about an abortion that took place?
I guess I don't. I'm sorry.
Okay.
Other questions for this witness? Oh, I'm sorry, Representative Alonso, I'm sorry, thank you.
And can I just say, is not abortion care health care?
I do not believe that the intentional killing of a preborn child is healthcare. No.
Other questions for this witness? Seeing none, thank you.
Thank you.
Omar Ahern, please, and next is Phyllis Woods.
Thank you, Mr. Chairman and members of the committee. I guess one other thing I didn't mention in my first remarks to you folks, I didn't think it was important at the time, but based upon what I'm hearing this afternoon, I'm also a Grafton County Commissioner. And so I work with a lot of delegation members up there in Grafton County. So I thank you for all of your services, members of your county delegations. And as a county commissioner, I am one of three responsible for the operations and the management, not day-to-day management, but the operations and the management of a 150-bed Department of Corrections facility. So, and every month, as a county commissioner, I receive a Superior Court report. The Superior Court report basically tells the commissioners how many inmates we have in our correctional facility, where they're from, and why they are incarcerated, or why they are waiting for their trial to be completed. So, having said that, and I'm just speaking now in general terms of why we in our society, as individuals, we have a responsibility to act, with common sense. So, and all men are to be treated equally under our law, and men include men and women. But these laws and penalties on the book, but there are laws and penalties on the books now that were not there 20 years ago, 30 years ago. Unfortunately, because some people in our society do not know how to act with common sense and try to do what is right. So there are penalties that must be retained in order to remind people who may not believe that what they are doing is wrong. So we kind of need to retain these subjects under the penalties of law, and criminal and civil, I believe, are part of that. Accordingly, I oppose, and I ask all of you to oppose House Bill 224 FN. Thank you very much. And again, thank you all for your service.
Thank you. Questions for this witness? Representative Horrigan, did you have a question?
Yes. I'll use this one. Since you probably with the Grafton County Jail, that's probably where, if anybody has been prosecuted under this law, that's probably someplace they might end up. So to the best of your knowledge, has anybody been prosecuted or even arrested for violation of the Fetal Life Protection Act since it took effect in January 1st, 2022?
Not to my recollection. I do not recall seeing any of those. There are, a lot of pretty sick things that, minors abuse, pornography, things like that. But I have not seen anything in Grafton County. I don't know what's going on in the other 9 counties, though, Representative.
Other questions for this witness? Seeing none, thank you very much.
Again, thank you very much.
All right. Phyllis Woods. I know Miss Woods was here earlier. She had, all right. Okay, all right. So Miss Woods has left. Mary Ann Cooper? Ms. Cooper? She may have left also. All right. Sheila B. Oh boy. I think it's Marshall, but I could be wrong. From Somersworth? I'm on a roll here, looks like. Yeah. All right. Roy Dennehy. And Beth Scarer will be next. Mr. Dennehy?
Yes, thank you. I'm Roy Dennehy from Windham, New Hampshire, and I oppose House Bill 224 FN, as I previously have also opposed the previous repeal bill for the Fetal Life Protection Act. And as I mentioned earlier today, I'm the life director for the New Hampshire Knights of Columbus, and I represent over 7,000 knights here and their families, and who believe in the sanctity of human life from the moment of conception to natural death. Fellow pro-life supporters in the New Hampshire Executive Council, State Senate, House of Representatives have been accused of having extreme, quote, extreme ideology and partisan ideology for supporting and protecting the current fetal life protection law. This law, in fact, protects the preborn baby from being brutally killed from 24 weeks after conception to its actual delivery date at 9 months. This current law, in effect, allows a pregnant woman to allow her preborn baby to be killed at any time up to 24 weeks after the baby is conceived. these abortion providers, such as Planned Parenthood and others, hide behind the slogans of women's health, reproductive freedom, and sexual education. They are extremist and partisan ideologues. They are very strong on supporting and promoting and funding the killing of preborn babies right up to the moment of death. And here in Concord, the Democrat leadership has proposed this bill today in order to gut or totally eliminate any penalties to the current fetal life protection law and replace it with a totally unrestrictive abortion law that would allow the killing of babies in the womb from the moment of conception right up to the moment of birth. So who are the extremists here? The Fetal Life Protection Act protects the human rights of each preborn baby. So it's a major human rights issue, and why the Knights of Columbus are in total opposition to this bill. Thank you.
Thank you. Questions for this witness? Seeing none, thank you. Beth Scarer, and the next witness after that will be Ian Hewitt.
Hi, I'm Beth Scare. I'm a mom from Nashua, and I'm here for a second time today to speak in defense of New Hampshire's Fetal Life Protection Act, which protects healthy babies just a few weeks from being born from being killed in an abortion. And again, I've included a picture of an abortion at 23 weeks with my testimony, which is just a week before the Fetal Life Protection Act kicks in. And I'm speaking again because I fear some members of this committee and of our legislature believe that voting for repealing the legal and civil penalties for performing a gruesome late-term abortion would give them cover against being accused of supporting abortion up until the moment of birth. Governor Sununu has made it clear that he believes that if he signs this bill into law, that he can use this as a fig leaf in order to not be branded as an abortion extremist. Good luck with that in the presidential primary. No one's fooled by that. If there are no legal penalties, then everyone knows there is no protection at all for babies from being killed in a late-term abortion. It's common sense. There would be nothing to prevent doctors from performing the procedure. And I'm even more suspicious now that I've heard that Representative Wolf proposed this, saying that we could put in other penalties, but he didn't include them in the bill. The bill is fatally flawed right off the bat. Remove all the penalties, put nothing in its place. Moms and babies and abortion workers would continue to suffer from this gruesome multi-day procedure, which cannot be used to save the life of a mother or save the health of a mother in an emergency medical situation, because it takes multiple days to complete. And it's traumatic for the abortion workers, as I detailed in my testimony this morning. I'll end with a quote from Frederica Matthews Green. "The problem is that it's a baby winds up in deadlock with it's a woman's right. The two statements do not refute each other, so no resolution is possible. What's more, they continue a pernicious fallacy that deadly conflict between women and children is a normal state of affairs. In no sane country are women and their own children assumed to be mortal enemies. Any culture that does so is slowly committing suicide. When we accept as normal the ripping of a child from her mother's womb, we violate something disturbingly close to the heart of the human story. In the land where women kill their unborn children, every lesser love grows frail." Please vote ITEA inexpedient to legislate on HB 224 to protect innocent babies from a gruesome death and their mothers from physical harm, and the abortion workers from the serious mental health repercussions of participating in these inhumane procedures.
Thank you. Questions for this witness? Seeing none, thank you. Ian Hewitt, and next after that will be Bethany Severine, I believe, or Severine. Mr. Hewitt?
Thank you, Mr. Chair, members of the committee. Again, I'm Ian Hewitt, General Counsel at Cornerstone in opposition to House Bill 224. I will not repeat myself unless there are any questions which overlap with anything I spoke about before, which I would welcome. I will just raise 2 points. One is that because our law in New Hampshire already allows the killing of viable children before 6 months, and because there's an exception after 6 months for fatal fetal anomalies, the only children whose deaths would be authorized by this bill are children older than 6 months who are viable. That is, children who could have been induced and delivered on the day that they were aborted instead of being killed and would have lived. Children a lot like the children whose 5 corpses were discovered in Washington, D.C. last year, where 5-star upscale abortion clinics like the DuPont Clinic advertise explicitly on their website that they will perform abortions after 26 weeks when there are no fetal anomalies. The second point that I'll raise is that I have seen a number of statutes that have no penalties and are purely symbolic that refer to what the general court will do or what an agency will do. But I have never seen in New Hampshire a statute that falsely purports to prescribe what citizens will do. And I think I haven't seen that because a statute like the one that this bill would create would be alien to the idea of the rule of law. We have always said that we and our supporters prefer a bill like House Bill 271 to a bill like this one for reasons of clarity, of transparency, and ultimately for reasons of life because of the deceptive effect that a bill like this would have. Relatedly, I think there might be a drafting error in this bill. It does not remove the Class B felony penalties from RSA 32936. So under the bill in front of you, a provider, if he removed a child 6 months or older in pieces, he would face not so much as a parking ticket, but if he opted to remove it more quickly as intact as possible, then under Section 36, he would be a Class B felon, in which case I think some abortion providers might be in for a surprise. Thank you, and I'd be happy to answer any legal questions about our law or abortion law generally.
Yes, Representative Smith.
Thank you. Good afternoon. I wonder if you could help the committee by providing us with written documentation of the ad that you described about New Hampshire offices that offer abortions.
I believe you're referring to the part of my testimony where I talked about corpses of full-term children being recovered in Washington, D.C., and then I referred to the fact that abortion clinics there, where there are no limits on abortion, explicitly say that even if there are no fetal anomalies on their own websites, they will perform abortions after 26 weeks. I described Washington, D.C. as an example of what we might look like if we explicitly allowed a legal abortion up to
Thank
birth.
you for clarifying. So none of that refers at all to what happens in our state.
None of that refers to
Thank
anything
you very
that we
much. I
know of
appreciate
that has happened in our state where no statistics are collected on what abortions are performed.
All right, thank you. Any other questions? Representative Perez.
Yes, thank you. If we eliminate civil penalties from this statute, will that eliminate Section 32947, which states civil remedies? The woman, comma, the father of the fetus, if married to the mother at the time she receives an abortion in violation of this subdivision, comma, and or if the mother has not attained the age of 18 at the time of the abortion, comma, the maternal grandparents of the fetus may in civil action obtain appropriate relief unless the pregnancy resulted from the plaintiff's criminal conduct or if brought by the maternal grandparents and maternal grandparents' consent to the abortion. Such relief shall include monetary damages for all physical, psychological, and physical causes by the violation of this subdivision. Would this new House bill eliminate that possibility if because it has the word civil penalties?
Well, not only does it say that it removes civil and criminal penalties, but if you look at the text of the bill, it removes that section you're referring to, 47. So it removes the Class B felony penalties in 46, the civil penalties in 47. It does not remove the Class B felony penalties in 36, which is the section I referred to a moment ago.
Okay, so there would be no ability for a civil penalty for the mother, the father, the whatever, the grandparents. Okay, thank you.
It would entirely nullify our current law and allow abortion at any time for any or no reason.
Okay, thank you.
Other questions for this witness? Seeing none, thank you very much, sir.
Thank you.
Bethany
Syverson.
Syverson, I'm sorry.
Yes.
And the next witness after that will be, Richard Laline. I hope I'm pronouncing that correctly. Anyway, you'll be next after Ms. Summers.
Good afternoon, members of the Judiciary Committee. My name is Bethany Syverson, and I am here with my twins, Micah Syverson and Landon Syverson. Do you guys want to wave? They've been here all day. Well, we did take a break for lunch to get them out of here, but Micah and Landon are the pride and joy of mine and my husband's life, yet their lives were nearly destroyed by their birth mom at sometime after 20 weeks. I don't know exactly what week she went in, when she walked into Planned Parenthood with the intent to end their lives. Once at her appointment, by the grace of God, she decided that she could not murder these little guys, and our family is so blessed because of that. She stood there in that Planned Parenthood room, recognizing that these lives were inside of her, these lives that at beyond 20 weeks already had fully developed bones, eyes, eyelids, a heart that was pumping blood, kidneys, and other organs that were pumping urine through their bodies, teeth buds beginning to develop, and stuff like that. They also knew that they had genders, that they were boys, that they were identical boys, and these are our boys now. Our boys whose lives would have otherwise been ended by the state's abhorrent laws that at that time allowed for the legal murder of babies, human lives inside the wombs, their lives were saved, not by moral consciousness of those who were elected to protect those babies, but by the birth mom who intuitively knew that those lives growing inside of her were in fact human lives. Listen, I've been here and I've listened to some of the testimony, and I have sympathy. I was gang raped at 13. I can stand behind still at rape. I went through my first pregnancy and got preeclampsia. I heard an earlier testimony, and I was extremely sick delivering my first child. My liver and kidneys started to fail. But all along the line, these are human lives. We have to understand what abortion is. It isn't just a healthcare issue. It is a life inside of another human being that is growing. It is a life that has its own perfect DNA from the time of conception. It is a life that has its own perfect fingerprints, unique fingerprints from a very early age gestationally. When we understand what abortion truly is, we can't just then turn around and say, it's okay to just murder those lives because whatever reason. Like their birth family, a married couple, they were super financially in a very tight spot financially. And they understood that, and they recognized that the risk to having these little guys would have been, detrimental to their marriage. They made that plan. They went into Planned Parenthood. But ultimately, she knew that that was not okay. So the argument that there are situations, right? When I was raped at 13, I could have become pregnant, and that would have been horrible at 13, but that still would have been a human being inside of me. I've lived through so many of these examples that are given, and I still would have chosen life for every single one of them. So we as a state must protect these babies from the atrocities, and voting in favor of House Bill 224 would gut a bill that finally outlawed these barbaric measures on a baby that can fully survive outside of a mother's womb. We must recognize the truth. I urge you to vote in opposition of House Bill 224 and vote for the lives and babies, children, humans that all have a right to live and have a life ready to be lived, whether that's through birth moms or an adoptive family like ours. There are choices. We argue that this is about choice, but there are choices. The choice can be adoption. And we as a family are so blessed because that mother chose life for these two little guys. We're so blessed. So their lives matter to us and to this planet, to the future. Their lives matter, and so do the thousands of lives that can be saved in New Hampshire by your vote in opposition of House Bill 224. I don't envy the job that you have, but I would urge you, I heard another representative from Dover earlier say, I urge you to not vote with your stance on abortion, and I would strongly urge you against that. I would really encourage you to vote with the knowledge that these are human lives growing inside of every single woman. And that is not to take lightly of their situation. Again, I could have been in those situations, and I was in some of those situations. It isn't taking those things lightly, but it is recognizing that these are human lives.
Right.
So I'm happy to take any questions, and I have written testimony for each one of you.
Thank you very much. Questions for this witness? Seeing none, thank you.
Thank you.
Next, I think it's Richard Lesline. I hope it is. And next after that is Patricia Glauer. Richard Lesline? Richard Lesline. I hope I'm not pronouncing that incorrectly. Maybe LaPlume? From okay. I assume he must have gone home. Next is Patricia Glauer from Hanover. And after that will be Emily Sosana.
Hello, I spoke with you earlier. My name is Patricia Gloa. I'm a physician currently working through Dartmouth Hitchcock Medical Center in Lebanon. I'm here to speak in support of House Bill 224. And good afternoon to all of you, and I appreciate the opportunity to address you. Pregnant people and their doctors sometimes face a terrible dilemma of whether or not to continue a pregnancy in the third trimester. These circumstances arise in the context of lethal fetal conditions, where an abortion will save the fetus from the suffering that would ensue if the pregnancy is continued. The pregnant person may have serious medical conditions, such that they may face worsening health status and possibly even death if they continue the pregnancy. Those circumstances might include worsening liver or kidney failure, heart failure, a new diagnosis of cancer that is more aggressive in the presence of pregnancy hormones, and a variety of other conditions. These situations are not easy. The painful decision to terminate a pregnancy at these times is undertaken with very careful consideration by both the physicians involved and the pregnant person and their family. The doctors involved at these times carry a heavy burden of responsibility to work with the pregnant person and carry out a difficult procedure. Penalizing them for doing their difficult job is cruel and inhumane. These doctors and their patients deserve our support, not our opprobrium and punishment. The repeal of the criminal and civil penalties invoked by the Fetal Life Protection Act will allow our valuable medical practitioners to continue doing their difficult job with compassion and skill, not inhibited by the threat of state prosecution. I'd like to make a side comment on this issue of viability. There is no such thing as a one-time definition of viability. It is an arc. Yes, there are some 24-weekers who are resuscitated and survive, but you have to understand that those are extremely sick infants, dependent on life supports and medications and painful procedures to make it to that point. And they almost all, at that early gestational age, end up with physical disabilities of some type or other. It might be blindness or visual difficulties. It might be intracerebral hemorrhages such that they have neurologic limitations. They may not be able to hear or speak. They may not be able to swallow food because of death of portions of their gut. They may require long-term feeding tubes or ventilators. These are not, quote, healthy, viable fetuses.
Right.
The decision to continue that pregnancy or to end that pregnancy is dependent on those shades and gradations of risk and should not be penalized with criminal penalties. Thank you.
Right.
Yes.
Questions for this witness? Yes, Representative Turner.
Yeah, thank you, Mr. Chairman, and thank you, Dr. Glowa, for your testimony. I just wanted to clarify, can you envision or do you foresee that there's any times when the provisions of the Fetal Life Protection Act would put you in conflict either with your Hippocratic Oath or with standard of care?
I will state that I am not in the position of performing abortions at that late gestational age. That is a highly specialized skill. I could imagine, however, that if I were that kind of clinician, that I would be constantly worried about every single decision to carry out that procedure, worrying that some aggressive prosecutor would decide to pillory me, put me in jail, deprive me of my livelihood, and it would have a distinct chilling effect on my ability to practice.
Other questions for this witness? Seeing none, thank you.
Thank you for your time.
Emily Zizano, and I see we have 15 more people listed to testify, and given the hour, I'm gonna really request that you keep your testimony to 2 minutes, please. 2 minutes, thank you. And I should also say, by the way, anybody, you can submit testimony electronically to the committee. If you wish to do that, please don't hesitate to do so. Thank you.
Hello again, Chairman Lynn and committee members. My name is Dr. Emily Zajano, and I ask you to support HB 224, repeal the criminal and civil penalties from the New Hampshire's current 24-week abortion ban. The current law singles out medical providers who have the training and expertise to provide abortion care later in a pregnancy. There is no other profession that the state has criminalized. This law is an invitation for further intimidation and harassment against these medical professionals and has a chilling effect across the healthcare landscape in New Hampshire. We have seen this reality play out across the country. There is a significant shortage of healthcare providers already, and specifically in labor and delivery. Every couple of years, for the last 20 years, hospitals in New Hampshire have been closing down their labor and delivery units. There are obstetrical deserts in our state, and as nearly 200 providers said when the original abortion ban was adopted, criminalizing the profession for providing evidence-based care will exacerbate difficulties in recruiting and retaining critical OBGYN providers. I appreciate that last year the legislature directed more money to hospitals so they will continue offering birthing services. However, that will not help New Hampshire families if there are not enough physicians with expertise to provide care in those units. Those proposing these criminal penalties have likely never been in a room when a woman has to hear her baby won't survive, or that continuing a pregnancy could put her life in danger, or that there is nothing that can be done to save a baby. I have been on both sides of those discussions. It is devastating for the patient and the medical team. The discussion and ultimate decision is not taken lightly. The people of New Hampshire trust their doctors to offer sound medical advice. The state legislature needs to do the same. I urge you to support HB 224 and end the criminalization of New Hampshire's capable and trusted doctors. Thank you.
Thank you. Questions for this witness? Seeing none. Ovid Young. And I know I've pronounced it, I know it's not open, and I apologize. I'm sorry, I apologize. Dr. Young, it's probably, it's easier to put it that way. Dr. Young, please.
And so, all right, I previously introduced myself, so we can forego that. I do want to say I'm here testifying on behalf of the New Hampshire Medical Society and the obstetricians in our state in support of House Bill 224. I've long held that there is a sacred social contract between physicians and society. As physicians, we sacrifice a good portion of our youth and young adulthood to train and learn the skills so that we can devote the rest of our life to caring for other human beings. Society society is supposed to create a reasonable, fair environment. And I would argue that the criminalization of physicians in this situation violates that social contract. Given the complexities of second trimester and early third trimester pregnancies, this law makes no sense. All it does is create a barrier or a burden to the provider who's trying to make the best decision for his or her patient when it comes to delivering or terminating a pregnancy. Now, let me just give you or share with you a story to illustrate what I'm talking about.
Well, yeah, we're trying to limit everyone's testimony to 2 minutes, Doctor, so
I'm sorry.
make it pretty quick, please.
Well, I once had a physician and his wife present to me. She was very healthy. They achieved pregnancy without any problems. At 25 weeks, she presented with severe preeclampsia, a headache, swelling, severe hypertension. And to save her life, I performed an emergency cesarean section. The baby died of complications of prematurity. This happened 2 more times. By the third pregnancy, very unusual story. She delivered 26 weeks. The baby survived. She survived. The baby has severe cerebral palsy, but otherwise as well. I'm telling this story to point out how complicated this situation was. And the thought of thinking about criminalization in making the decision to deliver her seems unfathomable. I wouldn't have done anything different than I did, but who knows, this might have ended up in court.
Doctor,
Somebody
I appreciate
claiming
your,
that I was
we're really,
inappropriately delivered early. So the point I want to make is that this social contract between physicians.
I've shut his mic off.
Don't do that. Yeah. All right. So, Doctor, you're quite a bit over your time, and I appreciate your being here, but we have a number of other people we need to hear from, so thank you very much. Are there questions for this? Great.
I'm going to
Thank you.
ask
Questions for the
consideration of the committee members who have other political commitments this evening after
Questions?
this. So please.
Question
let's
for
stick to
this
the 2
witness.
minutes. Sorry.
Representative Macbeth.
Thank you, Mr. Chair, and thank you, Dr. Young, for my question. In the scenario that you were just describing, when you had to do the emergency C-section at the 26 weeks and on the third time the baby did survive, but is that a situation where you might have been criminally liable if the baby died, but you're not liable and won't get the felony if it lives. And so it's not only the mother's health, but it's the baby's health that you're worried about for these criminal charges?
Other questions for this witness? Representative Turner.
I just wanted to ask the same question that I asked roughly of Dr. Glowa. As a former practicing OBGYN, do you ever envision that there'd be the possibility of this fetal protection law being in conflict with either your Hippocratic oath or standard of care?
Turn on the microphone.
All right. Thank you. Other questions for this witness? Seeing none, thank you very much, Doctor. Josie Pinto.
So I'm actually here on behalf of an OBGYN in New Hampshire. Is it okay if I read her testimony, or would you prefer if I submit it?
Why don't you submit it, and if you have, if you want to just sort of summarize very briefly, but you can submit it, that's fine.
All right, I'll do that. Thank you.
Great. All right, thank you. Jason Hennessy, please. And next after that will be Ben Safford. Jason Hennessy?
Thank you again, Mr. Chair. My name is Jason Hennessy. I'm the president of New Hampshire Right to Life, and I'm here to oppose HB 224 on behalf of our many members. We already talked about a lot about the reasons why we want to keep the FLPA in the previous hearing, so I won't dive into that. But HB 224 is essentially a repeal. A law with no penalties carries no weight. So the question is that the direction we want to go? As I said earlier, the vast majority of New Hampshire, over 70%, agrees with abortion limits at some point. And 6 months is the latest point that anybody could think of, that if you look at our national landscape.
All right.
So the question is, what would be a deterrent then from doing this? And there wouldn't be one. Also, another thing I wanted to throw out there is we just heard that most late-term abortions are not elective, but that disagrees with the few statistics that we have, where at least in one of the states that we have the statistics for, it's roughly over a little bit over half. So over 50% are elective and done for the same reasons that early-term abortions are done.
All right. Anything else you want to tell us, sir?
I guess one thing I would say, I just wanted to address the point that we would have trouble recruiting physicians here in New Hampshire. If 43 states have the same law or even an earlier prohibition, and they also presumably have criminal penalties, I don't understand how that would affect our state's recruiting ability. Thank you.
All right. Questions for this witness? Seeing none, thank you. Ben Safford, please. Yep. No, that's fine. I think that's fine. Just speak up if you would, please. And then after Mr. Safford will be Sam Safford.
Yeah. Okay. Honorable House Judiciary Committee members, good afternoon. I am here today to oppose HB 224. How many future doctors, teachers, firemen, legislators, and parents have we lost due to abortion over the years? Their dreams and contributions to our society have been lost forever. In this great land of opportunity, someone like me with Duchenne muscular dystrophy has been able to live away at college, graduate with a degree in social work, serve others in my church, and work for a nonprofit that helps others with disabilities. As a person with Duchenne, I am living on borrowed time right now. My brother Samuel and I have already exceeded our life expectancy. Someone I know just recently, 2 weeks ago, who was 24 years old, passed away with my condition. And I know some that have not survived their teens and some that have made it maybe to 31, 32, but I'm pretty much over my life expectancy. We, more than most, know how fleeting and frail life can be. My condition is, you get it when you can have it at birth, so it can be under fatal fetal anomaly. So underneath that, I could not be here today. If my mother had elected to, take, the fatal fetal anomaly and abort me, I wouldn't be here today. I'm thankful that I'm still here. I'm asking this committee not to return our state to one that allows abortion on demand up until the moment of birth. If this HB 224 goes through, it guts the Fetal Life Protection Act from any penalties. And then just think about it. Is it really needed as a law if it has no penalty? You might as well repeal it because it won't have any weight. The majority of granted staters support our modest 24-week abortion ban and do not support unfettered abortion access. That's where we're heading if we pass this. Please vote ITL on HB 224. Thank you.
Thank you. Questions for this witness? Seeing none, next I'm going to call on Sam Safford, please.
Sorry, it'll take us a minute.
All right.
Honorable House Judiciary Committee members, I am here to oppose HB 224. This bill would essentially return our state to abortion on demand till birth. I am also here to represent those in the disability community who cannot be here today. Everyone, even a person with a severe disability, deserves the right to live, and this bill would deny them that right. Being differently abled doesn't make anyone less of a person who is endowed by their creator with inalienable rights, the first of which is the right to life. Whatever your thoughts on disability or abortion, I hope you'll agree that killing a baby who would be viable outside the womb after 6 months gestation is criminal. Please vote ITL on HB 224. Thank you.
Thank you. Questions for this witness? Seeing none, thank you. Lori Safford, please.
So I'm here today not actually representing myself, but my friend Laura Preston, who is a high school science teacher in Salem, New Hampshire. She couldn't be here today. Just going to read her testimony. As a pro-life woman who made a mistake and had an abortion when I was 18, I am appalled that the state of New Hampshire is even considering going back to allowing abortion of viable babies all the way up to birth. When I was 18, my first year in college, I was scared, ashamed, and uncourageous, and I didn't want to disappoint my widowed mother. I thought I took the easy way out, having an abortion at Planned Parenthood. But little did I know that I would be haunted by this decision for the rest of my life. Since that time, I have been on the course to help in any way I can to save the babies and to help women facing an unplanned pregnancy. Children are a blessing. There are many choices when having an unplanned pregnancy, including adoption, and I believe women deserve better than abortion. We have 2 beautiful grandchildren we happen to be raising because our daughter made a couple of wrong choices. But she chose to have her babies instead of aborting them. I'm so proud of her. She was much more courageous than I. I feel like God has given me a second chance with our grandchildren. I have been blessed beyond measure. Whatever you think about the issue of abortion, I hope we can all agree that purposefully killing a viable child after he or she has already developed in the womb for 6 entire months is unconscionable. Please oppose HB 224.
Thank you. Questions for this witness?
Real quickly, just because I have to really rebut the 2 physicians who said that they thought that viability is still at 24 or 26 weeks. I have a very good friend, Robin Moore, who lives in Framingham, Massachusetts, and her daughter was born just months after mine. I don't know what her issue was. She had a uterus that couldn't hold the baby. She was in bed for a couple of weeks while she was pregnant, and her daughter Kaylee was born at 19 weeks. She was obviously in the NICU for some time. There were issues with her lungs, and they weren't sure if she would, be blind or not. But she is a totally typical 23-year-old today, and she competes in dancing competitions. If you want to look up Kaylee Moore or Robin Moore on Facebook, you'll be able to see her competing. So to say that 24 weeks is stretching viability is not true.
All right. Thank you very much. Questions for this witness? Seeing none? Thank you. I'm going to, next witness is Dr. Ilana Cass, and I know that the representatives here from Rockingham County have to be at another meeting at 6:30 tonight, and so I'm supposed to be there too, but I'm going to hang in there here as chair, and the other representatives that need to go. If you're from Rockingham County and you need to go, please feel free to do that. We don't need a quorum for hearing purposes, and obviously, I'm sure that people who do have to go will listen to the testimony before we deliberate on the bill. So next, I'm going to call on Dr. Ilana Cass for your testimony, please.
Thank you very much, Chair and committee members. So I'm the Chair of Obstetrics and Gynecology at Dartmouth Hitchcock Health, and find myself currently in the situation that many have alluded to today. Just to remind you all, I am currently recruiting 2 maternal fetal medicine specialists to Dartmouth Health. I will remind the members of this committee, at last sort of estimate, we have 7 such maternal fetal medicine providers in the state of New Hampshire, and 2 I am currently trying to recruit, as I'd indicated. And I'm urging you to consider the benefits of HB 224. This has become evident already in my efforts to recruit maternal fetal medicine specialists to care for the women and families of New Hampshire. This is already an issue in making a hospitable and also a reasonable place for them to practice the medicine that they have been specially trained to do, to care for, I might add, pregnant individuals with any range of medical conditions, trying to promote healthy and safe deliveries for our Granite Staters. But I'd like to invite you to consider the downstream consequences of the legislation that adds criminal penalties for a provider in the sanctity of the relationship between that provider and patient, the downstream consequences of criminal persecution. This has an impact on our residency, the only residency program in obstetrics and gynecology in the state of New Hampshire. This has an implication for our medical students, the only medical school in the state of New Hampshire. This kind of environment makes providers, as you've heard from many of my colleagues today, more apprehensive about delivering care, concerned that they will potentially face criminal consequences as well as financial consequences, making it difficult to impossible for them to go on with their professional careers that they have been trained specially to do. I'm happy to answer any of your questions given the hour, but I would point out that this has far-reaching implications for the healthcare landscape of the state of New Hampshire, in which you've already heard very important testimony about the shrinking number of obstetrical units in our state. As indicated, we have fewer and fewer places where women can seek obstetric care, and to add criminal penalties for providers further carries us along in a continuum which could pose great peril to the women and families of this state.
Thank you. Questions for this witness? Yes, Representative Payne.
Thank you, Mr. Chair. Thank you for taking my question. I need your help. I'm reading, and this in part, I think, is going to help, I think, in a translation, if you will, from the legal world, which
Sure.
I'm a little more familiar with, to the medical world, which I'm completely unfamiliar with, but you are. So I'm looking at 329:46. That's the criminal penalties, and it uses words that are familiar to me by my training. Knowingly performs or induces an abortion, and knows, and this is sort of getting into the mental state of the doctor, or consciously disregards a substantial risk. Those terms are, I won't say comforting to me in the statute, but as a lawyer, they give me some bedrock to look to. So, but I'm wondering, in the medical room where all this is going on, it must be a little bit more complicated than that. There must be scenarios where it's not as linear as the lawyer mind would like it to be for a criminal code. And I'm wondering if you could describe that sort of complicated kind of nature that I'm guessing is there, but I don't know.
Yeah, so thank you for that excellent question, which I think really highlights the point that many people have shared with you today who are medical professionals. There is a tremendous amount of uncertainty in the context of a pregnant woman who perhaps is in the situation that the pregnancy poses some concern or life-threatening condition, but just proximal to that, as things are sort of unfolding, the condition of that woman, the condition of that pregnancy can literally change by the minute. There can be uncertainty about the gestational age of the pregnancy, which in and of itself we use as an anchor, but can be unpredictable. And the circumstance that I would submit to you with regards to some of the uncertainty and how that plays itself out, we are seeing situations currently in the United States of America where providers in that space of have things gotten to the point at which, and this could happen in the state of New Hampshire, can I definitively say that the circumstances that I can see in front of me mean that if I don't act right now, the patient will die as a result of the pregnancy? That can be very vague territory and decision-making, which can change by the minute, can be very ambiguous, and can lead to significant delays in care, which can imperil the condition of the mother as the provider tries to decide what the right thing is to do. And to compound that, what is that provider to do? Again, in faraway places, where there is perhaps less access to immediate maternal fetal medicine care, where in the middle of the night that provider has to make a decision based on their best evidence and best medical judgment, always with the fear that there may be some criminal prosecution if that individual has to second guess themselves, if the outcome is not as they project or think it might be based on best practice, based on the best data that they have in front of them. So there's a tremendous amount of uncertainty. And I would add that to criminalize a provider who in consultation with their patient is trying to practice best care with the best evidence adds a dimension that is both dangerous to the patient, dangerous to the physician, and ultimately can have implications for our state, as providers will invariably look to that and decide, I'm not going to apply for that job, I'm not going to apply to that residency, I am not going to apply to that medical school.
Questions? Other questions for this witness? Thank you very much. Peter Chamberlain?
Thank you so much, Chairman and members of the committee. I rise in opposition to the repeal that has been placed before us. I am Peter Chamberlain. I pastor the Granite State Baptist Church here in Concord. I'll approach this from I believe it ought to be an ethical and a moral and also a righteous duty that there are laws on the books. And the very subject matter of a law is to be enforced. In fact, if we were to come back and look at the very definitions that are given in modern dictionaries, it is something to be enforced by the body, and without it, we cannot have law enforcement. If there's ever a law that ought to be enforced, it ought to be that which protects the heartbeat from the beginning to the end. But as we look at laws that are on the book, if they are to be enforced, I would say by the very repeal of this law goes against the very nature of why we would even have a governing body, a legislation, or a governor in place, because there's no other lobbying to be able to take away penalties for breaking the law. And so I know abortion has been debated all day long. I would think there ought to be a correction on terminology that's being used as person after person stands up and calls it health care. I personally believe it's prejudiced health care, that it's actually looking to take care of the health of one human being and not the life of another human being. And it's not promoting the moral well-being or the physical well-being of those. But then if we allow this to have a law on the books with no consequences, no enforcement whatsoever, then what precedents, it was asked but not answered earlier, what precedents and where does this stop? Does it stop with speeding tickets? Can I then turn around and sue for prejudiced enforcement of laws that it's not being enforced one way or another? And so we look at these things. Does it stop with stealing? Does it stop with murder? What laws are there allowed to be on the books that we do not have enforcement of those laws? By the very nature, it's not a law then. And by the very nature, we're not lawmakers, and there is no law enforcement. And so saying it's fine for providing health care, it is selective. And to be able to go, and I'll just give maybe some common sense to this recruitment. For New Hampshire, we have a speed limit, so maybe by us having a speed limit, let's follow that through, maybe that's going to hinder drivers from coming to New Hampshire. Well, we see every weekend that that doesn't. And so I just believe that we ought to enforce the laws that are on the books. There's some that have said, well, maybe we could do this. That's not before the committee. You're not allowed to look at alternatives of what could be done until those laws are submitted. This is a repeal, but it would be a repeal with no enforcement, no replacement of it. Therefore, it takes the law completely off the books. And so I do urge, do not repeal this law and have a law that has no consequences whatsoever. Thank you for your time.
Thank you. Questions for this witness?
Thank you.
Seeing none, thank you. Jennifer Lanscott.
Hello, thank you all for your time today. I know it's been a long day and you've heard so many testimonies, but I'm going to try to keep mine short. I'm here to oppose HB 224. As a mother of 4 children, I have carried all of those pregnancies to full term, and I can tell you honestly that at 24 weeks and beyond, there is a real life inside of me, and at every point in the pregnancy, but I have felt my babies dance when they're happy. I have had them give me gentle nudges when I'm sad. They're intuitive and real. A lot of the testimonies today in regards to abortion, though, I hear a lot of people express concern about women's rights with abortion. But the fundamental question I have is that we should be asking is, does an unborn child have rights? Should they have rights? And my question for everyone in this room is, if your mother had chosen abortion, how many rights would you have today? Thank you for your time.
Thank you. Questions for this witness? Seeing none, thank you.
My 11-year-old was wishing to speak of his own will. Is that okay?
Very briefly.
Very brief.
Very briefly.
Keep it brief.
My name is Quintus Lengto, and I am 11 years old, and I oppose the Home Bill 224 because I believe that all people have a right and a reason to live and to have a family. And if all these people proposing this bill want everybody to have freedom, then infants should have rights, and if somebody can't afford babies, then where does it say here? It stops writing there, so I'm gonna just go here.
Sorry. Thank
To
you.
those, am I done?
Go ahead.
Okay. To those who don't know how your babies are aborted, then you should look up the most common abortion method. But I will say the most common second trimester abortion method is dismembering the baby and taking it out. Vote no on Home Bill 224.
Thank you very much. Laura El Assam?
Thanks to all of you for your patience on this long day. The Fetal Life Protection Act has only been in effect since last January, and in those 13 months, there's been like dozens of bills, it seems, maybe only a dozen, but just so many bills that seek to gut it and just neuter it. And this is yet another one that will gut it, and you might as well just repeal it, as several people have said. I am the parent of 4 children that check every box for abortable, according to the stories I heard today. And yet they disagree. They are happy, healthy, thriving young adults at this point. And I think that if any of you are still considering this a sort of a feminist issue, a women's rights issue, then I would encourage you to think again. We listened to these stories today. We've come such a long way from the mantra of safe, legal, and rare, and now it's just legal. Doesn't need to be safe necessarily, doesn't need to be rare. It shouldn't be rare, as a matter of fact, to hear some of these stories. Just needs to be legal. Abortion for abortion's sake at any time up until the day of the baby's birth. And what's especially not feminist about this is the term that I heard over and over again today. They're erasing woman and mother from this equation, and I find that tragic. Again and again I heard pregnant people, pregnant individual. There is a dignity and worth to motherhood and femininity that you just can't replace. And one of the cruxes of femininity was we recognized that we needed to protect the life in our womb. In fact, womb was a synonym for a safe place for as long as I can remember, as long as the English language has been around. But for some reason, and I don't understand it, women have just abdicated their role as protectors of life in the womb. And so unfortunately, that means it falls to you. And I encourage you to just vote ITL on this. It will essentially gut and repeal the FPLA and leave us with abortion up until the moment of birth in the company of some very bad actors in the world that do not respect human lives at all. And it has a terrible effect bleeding across all of society when you don't respect human life. Thank you.
Thank you. Questions for this witness? Seeing none, I have 2 cards I think are from the same, well, maybe not, I'm sorry. I have Christopher Duffley and Christine Duffley.
That is correct. Thank you, Chairman. Thank you, members. I know it's been a long day, so we'll keep it brief, but good afternoon, late afternoon now. My name is Christopher Duffley. I'm 21, Manchester, New Hampshire, and 21 years old. And we are both here to oppose HB 224. And I'll just quickly share my story with you. I really should be honest with you. I shouldn't be standing here today. I was an unplanned pregnancy, and both of my biological parents were using drugs which led to my premature birth at 26 weeks gestation, weighing me just 1 pound and 12 ounces, pretty much like a small head of a cabbage. I'm here today because we are discussing unborn children that were just like me at risk in the womb. My life, and so many others in this stage has value. And because I'm totally blind and live with autism, nothing has stopped me from living a full and happy life. Please remember that all life has intrinsic value, and please protect the lives of preborn children after 24 weeks and maintain the current law as is on abortion here in New Hampshire. And I will emphasize, without repeating, the points that were made by the other opposers today. Thank you.
Thank you. Questions for this witness?
Could,
Yes, Representative Smith.
Yes, Representative.
would it be appropriate for me to ask you about that machine that you're using?
Yeah, I can't see why not. So, I'm using, in short terms, I'm using a, it's a Braille display, and this particular one is by Freedom Scientific, who makes, blindness products, and it's a Focus 40 Blue, and it's a Braille display, and I can, so with this particular thing, all I can do really is pair with my phone and be able to read from it, and it's, but yeah, it's interesting. I think this is the second time I've been asked this question by a committee. So, but
And
anyway.
thank you very much.
Yes, thank
It
you.
was a pleasure to see how smoothly you operated that.
Thanks.
Yeah, that's a pretty cool device.
It is. It
Thanks.
is.
Thank you very much.
Yep.
Whoop, I'm sorry. Did you have something else you wanted to say? Then Christine Duffley, please.
Hello, members. Thank you so much. And we have had a long day. My name is Christine Duffley. I'm from Manchester, New Hampshire. I have 5 beautiful children. And the last one here, Christopher, he's adopted. And I have a husband too. And I also run a nonprofit for inclusion education. I am grateful to come before you today and to offer a few brief words opposing HB 224. Now, this past Sunday, we witnessed something that people cheered and they jeered for. It was the yellow flag signaling a penalty. Not just any penalty, but one that changed the outcome of a game that names a champion and funnels millions of dollars, fame, and a Super Bowl ring. Holding matters. Where a big hold, whether it was a big hold or a small hold, that call was made to maintain the integrity of the game. A line was drawn. In fact, I just got a message on my phone, and it says, oops, it says I only have 5 more minutes because my meter's expiring, and I'm going to get a penalty. Whoops. Grace, help. Sorry. So what I'm saying is penalties matter, and today we are revisiting a very controversial topic and all the emotion of the final moments of the Super Bowl. But we're talking about human life. Worthy of acknowledgement and protection, and why not the penalty when a line is crossed? You just met my son, Christopher, 1 pound, 12 ounces, 25, 26 weeks, 1 pound, 12 ounces. You've heard testimony today that lives that small are not worthy. They're not productive. My son has influenced millions of people all over the world. I meet parents, I get emails of parents that have had premature children that are thriving like my son. Folks, life is precious. And I too believe that life begins at conception, but we have a law here in New Hampshire that I will respect. But I will speak up and say that we need to draw the line and have a consequence, or we're going to have the invitations for physicians that will come if we have 24 weeks and other states have lesser weeks. gosh, people are going to come here. And we might even get physicians that say, wow, we're going to make some money. Everybody wants to take advantage of something, but let's not happen to life. I mean, I understand life is messy. My brother went to prison. I'm telling you, life is messy in all its forms. So today I'm just going to end. I thank you and reminding you that life is beautiful with all its unplanned and messy parts. Let's not devaluate it any further.
Thank you very much. Questions for this witness? Seeing none, thank you. Dina Stahlheber? Dina Stahlheber? Oh, she passed. Okay, all right. So that, former Representative Wilper. Is he still here? Doesn't look like, looks like he left. All right. And lastly, I have Matthew Hood from Dartmouth Health, who said he's here. He's available to answer questions if we have any. Does anybody have any questions for Mr. Hood?
Thanks, Mr. Chair, and members of the committee. I didn't sign up to testify, but my name was referenced several times in connection with subsequent testimony, so I wanted to make myself available if there were questions. Much more important for you to hear from Dr. Cass with respect to the implications for recruiting healthcare professionals and for the ambivalence for providers in the space about mens rea. You had raised that question about knowingly earlier, so happy to address any of those questions or others.
All right. Questions for Mr. Hood?
This is a former representative and a former senator.
Okay. I'm sorry. I should have recognized that, but I did not.
No apologies are necessary, Mr. Chair. That's it,
But are there questions for Mr. Hood? Seeing none. Thank you very much, sir.
Standing in the way between you and leaving the committee is like a horrible posture to be in. So thank you for your service tonight. Appreciate it.
Thank you. All right. I think I've gone through all the pink cards. Is there anyone else who wishes to testify on HB 224? Seeing none, I'm going to close the hearing and thank you all for attending and thank my colleagues for hanging in there for a long day. I appreciate it very much. For another one day, that's right. Thank you for getting us through. That was